Ms. Richardson, are you ready?
Yes.
All right. Good morning. We'll see. All right. Good morning, everyone. We're going to get on the record in 24cv000278, which is Friends of Piney Grove and two others versus the Bluffs at Lenox Homeowners Association. The microphone's really loud. I don't know what that is. It's good. Okay. As long as you're all right. I feel like I'm yelling. I'm not yelling yet. Okay. Good morning. Appreciate everyone being here. It is May 2nd, and we have almost the whole day set aside to work through a series of motions. I believe we have a motion for partial summary judgment filed by plaintiff seeking summary judgment on counts 1 through 4 of their complaint. And then we have a complete motion for summary judgment from the defendant seeking summary judgment on all 6 counts of the complaint. We also have some evidentiary motions to work through. The defendant is seeking to exclude some fact witnesses and some expert witnesses. We're going to start with the dispositive motions, but we're actually going to start with some questions that I have. But before we do any of that, I'd like the two sides to introduce counsel and let me and Ms. Richardson know who is likely to do most of the talking about what, since there are multiple motions and on one side, a couple law firms. So why don't we start with Friends of Piney Grove?
Yes, Your Honor. Mike McConnell with Jones Day. I will be handling 2 of the arguments. So I'm going to be handling our affirmative motion for partial summary judgment. I will also be handling our response on the expert motion. Janine Metcalf, my colleague who is seated here to my right, and what we've decided to do to make it easier for your Honor is to handle our response to their summary judgment, and she'll also handle the rebuttal to the arguments to partial summary judgment. We were thinking that we can do both motions at the same time is what I was thinking. The court, what we were going to propose is staggered. I would go first with the partial. Defense counsel to proceed with their motion and rebut, and then Ms. Metcalf would wrap up.
So Ms. Metcalf, your presentation, should you present, will be opposition to the defense's motion for summary judgment.
That is correct.
Okay. And I want to be clear, you are not drawing permanent lines if something changes, like, oh, McConnell, sorry, that has to do with, it just helps me understand generally who to turn to. Anyone can stand up and talk or sit there and talk as long as we can hear you. I'll just know if I have a question about the expert motion, that's Mr. McConnell on plaintiff's side.
Right. And then to the extent that there's rebuttal in support of our partial summary judgment, I would handle that as well.
Okay.
Just for economy and efficiency, we thought that would be.
Got it.
And then on the fact witness, Mr. Michael Storr, also with Jones Day, is going to handle that. And with respect to the request to exclude certain documentary evidence, that's going to be handled by Mr. Todd.
All right.
Handle several other motions.
Yep, I recognize him. And some of these folks I haven't seen in person, but you look pretty similar to what you were like on the screen. There's a little more body attached.
And I think that for us, Your Honor, that's our plan of attack for any of these various motions.
Got it. Okay. Anything you want to cover procedurally, Mr. McConnell, before I turn to defendants?
No, the
Counsel.
only procedural thing we were going to discuss is how the court would like to hear the argument presented, and I'm sure you're going to tell us that. So
okay.
Thank you.
Well, I'm going to give you my thoughts, and then we'll see what we end up doing. All right. And on behalf of Bluffs at Lenox, good morning.
Good morning, Your Honor. Kate Whitlock, I am here for the Bluffs at Lenox, and we have Ramona Mendoza with us on behalf of our client. She is on the board. Also, the last time we had a telephone conference, you told us to bring snacks. So we did. They are up by the court quarter.
Wow.
If anybody wants snacks or water.
All right.
I will be arguing the brief in support or the motion. Let me try that one more time, Judge. I will be arguing the Homeowners Association affirmative motion for summary judgment. Thomas Whidden, who's a lawyer in my office, will be arguing against the plaintiff's motion for partial summary judgment. Patrick Notchheim, did I say it right?
Close.
Close. Also a lawyer in my office will be arguing to exclude the fact witnesses. And Hillary Shawkat, who is our esteemed co-counsel, will be arguing the expert motion and the hearsay evidence.
I'm with a different firm, Your Honor. I'm at-
Luder Larkin.
Yes, sir.
All right. Got it. How do you pronounce your last name?
Your Honor, it's Mr. Knoxon.
Knoxheim.
Perfect.
Got it.
Thank you.
I'm going to spell it phonetically on my notes here. Knoxheim. And you're handling the excluding the fact witnesses.
That's perfect.
Got it. Okay. It's a lot of lawyers. That's helpful. Anything procedurally, Ms. Whitlock, you want to take up at this point?
No, sir.
Okay, I have two procedural questions. Ms. Whitlock, did your side actually file your notice of filing number 7? No idea what that means, but I've been told to confirm that it was actually done. And plaintiffs, you're going to have a similar question, but I don't know what notice of filing number 7 is. It exists. The question is, we got about 12 bankers boxes from the sides combined. And so Ms. Niles has been helping me go through many things. And we just want to make sure that if there was something you got to the court and you intended it to be also in the record, that it was filed. So notice of filing 7.
I understand what the question is.
I don't,
Check
but
my
good.
file.
Okay.
And if it was not, with the court's permission, we'll get it on file.
You have my
We'll get
permission.
it on file while we're arguing.
Okay.
Did you get a paper copy of it and not an electronic?
We got an electronic version, I think, and probably a paper copy, but I don't think I saw it make it into the document.
Okay, thank you.
But I could be wrong on that.
We'll make sure that gets.
That's what we're confirming, is what's in there and what's not. And as I said, there's a similar one for plaintiffs, but I want to find my directory first. There it is. Wow, that's a lot of folders. There was a manual filing that you sent to us, Mr. McConnell, on a USB. Mr. Storr, I know we talked about this during one of our teleconferences. Was that also filed with the clerk?
The notice of manual filing was filed on the docket, but the physical the flash drive, no, Your Honor, was in this house.
Okay, so if heaven forbid something gets appealed and needs to go up, how would what was on the jump drive be in the record that gets transmitted to the Court of Appeals?
That is a good point, Your Honor, but my reading of the procedure was that we would give it to Ms. Niles, and that the manual filing would then go to the clerk's office, but we will make sure the copy goes to the physical clerk's office.
Okay, I think.
It went through it went through the clerk's office, but they provided it to Ms. Niles, so we'll make sure that they.
Okay, and we don't need to do that today either, neither.
Flash drive later.
Okay, but we'll just need to sort out with the clerk's office so that the docket that is transmittable, as opposed to the mess in my office, includes the manual filing.
Yes, Your
Okay, thank you. All right, before we start with the motions for summary judgment, but in connection with them, I have a few questions, and I guess they're for Ms. Whitlock or Mr. Whidden, but again, anyone on the defense side can answer them. Under the ordinances that were passed in connection with the cemetery, do I have a right to access the cemetery?
I think that you have always had a right to access the cemetery with or without the ordinance.
Okay. So the ordinance might enshrine it in municipal authority, but even outside that, I have the right to access the cemetery.
Yes, sir.
Okay.
And I'm sorry, Your Honor, if I could clarify, I think you have the right to visit it. I do not think you would have, for example, the right to choose to bury somebody there without something more than you have right now.
Right. And the definition of maintain and the definition of access will probably be what bedevils us throughout the day. I'm just trying to figure out if there's a way to focus things a bit. There is understandable sprawl to this because it's an important issue for both sides. But it's helping me understand more the defendant's perspective. If you had said no, then I was going to ask, well, does Ms. Jackson or does Ms. Collins have a right of access? If I do, I assume even more so, if there's more of a right than a right, then Ms. Jackson and Ms. Collins would have a right to access, not necessarily bury someone, but to go to visit, not necessarily to cut a tree down, but to go and to visit uninterrupted, not being told, oh, it's a Saturday. Not saying anyone said this, but it's a Saturday, you can't go. Maybe you don't go at midnight with a loud band with you, but when you want to go, you can access it. And it needs to be accessible because, of course, what's the right to access if there's a big old no trespassing sign, or maybe not this case, a gate up or a fallen tree, and I can't actually physically access it. It's nice that you say I have a right to do it, but because it's not maintained, I can't get there.
Well, and that is what we're going to be talking about all day, because if you look at the history, the access that was being discussed at the time was access that had been reduced because of other development. For example, George 400, because you used to be able to come at the cemetery from the top, the sort of on a hill, you used to be able to come from the top. Now, the only way that you could get to it was from the bottom. And so that's what, if you read the history of this, that was what was the concern is, if we let you build this last condominium, because you're the last one here, we've got to make sure that we leave this path open to the cemetery.
Okay. And that path, that wherever the access is coming from, up on the hill, down below, that access, you're telling me is something that is, and I'm not trying to use freighted words, so don't say, oh, well, if you're going to use that word, I disagree. But I have an entitlement or a right to access the cemetery through the only available access point now, which is lower rather than higher because of development. And really, so does anyone in the public.
True.
Okay. Maintenance. Does your client have a duty to maintain the cemetery?
Yes.
And that flows from what?
I think it flows from, for my client, not for the plaintiff. They have two sources of obligation. One is the zoning ordinance, which was imposed by the city, and then one is one they imposed on themselves through the declaration.
Okay, but you're not contending that neither applies anymore. Both apply and both impose some obligation on your client to maintain, whatever that term might mean, the cemetery.
Yes, sir. And if you recall, when we were in here for the first hearing on the preliminary injunction, we had some question about whether through the bankruptcy and all of this, the zoning ordinance survived. I think we have satisfied ourselves that it survived. Okay. And now the question is, what does it mean?
Okay. So today doesn't involve a dispute or arguments about the applicability of the ordinance. It does impose a duty on your client to maintain the cemetery. We need to define what that means, but there's not argument today that, well, actually there was a bankruptcy or the original owner didn't do what he was going to do with it. He was going to do these other things. It creates this obligation that then the homeowners association, the condo owners association, imposed on itself through its declaration.
Correct.
Is there any difference in the scope of the burden imposed on your client by the ordinance and the declaration?
I don't think there's a difference, and Mike Smith, who is the one that drafted the declaration, said that it was intended, the declarations were intended to incorporate that zoning obligation. What we think is the declaration gives further definition to what maintain means.
Could the declaration narrow the obligation of the homeowners association? If the ordinance is broader?
That's a good question, because I think the zoning ordinance would have been imposed by a municipality, and a private person probably would not have a right to narrow it. But I think they, looking at the declaration gives you good information and helps define what the parties meant at the time when all of this was being developed and Mr. Smith was dealing with the city and the city was imposing its obligation.
When you say the parties, I know you don't mean at that point Ms. Jackson or Ms. Collins or Friends of Piney Grove, as you point out, it didn't exist back then. But who are the parties who are figuring out what the terms and scope of the declaration's definition of maintain?
So there's a couple of things. I think the parties in the zoning were the original developer who never developed anything, but the original developer in the city. And then you go to the declaration, and that is the developer that actually developed it. And he was working with the city at the time. So I would say it would be the actual developer and the city.
So that you believe, or the record shows, that the city had input as to what the terms of the declaration were?
No, if I said that, then I overspoke. But Mr. Smith testified that he did have ongoing discussions with the city that informed him in developing those declarations.
Got it. Okay. And it doesn't sound like from my review of the two-side summary of Mr. Smith's testimony that he was seeking to narrow the homeowners association's obligations. He was seeking to replicate the impact of the ordinance into the declaration. And then he affirmatively alerted the incoming elected members of the HOA, you have this obligation, it's in your declaration. All true?
That was his testimony.
Okay, all right. But I'm not, you may not like his testimony, but that was his testimony.
Yes.
Okay, got it. So, given all those acknowledgements, if I find that I cannot access some part of the cemetery, there's a grave I want to see, I can see that there's some graves over there, I can see them, but I can't get to them because of the state of the cemetery. Is it your position that I have no standing to do anything about that impingement on what you have told me is my right of access?
I don't think that's the position that we've ever taken, no, sir. Even when this started, the letter from Ms. O'Connell, did I get that? I get your name, was it Erin O'Connell?
It's Erin O'Connell.
Okay.
Correct.
Who is that?
That she is general counsel for the homeowners association. So
Okay.
she was involved before we got into litigation.
Got it.
But she wrote a letter to the Friends and their lawyers and said, you can come in. We don't want you cutting down trees. We don't want you doing this.
Okay, right. I remember that type of exchange.
Right, without talking to us.
Okay.
And so it's always been, let's talk about it. You know, if you want to take the weeds off of your grave, of course, go forward, do that. But if you're going to start doing things that might affect other graves, that might have some impact on our land, we want you to talk about it.
Okay, fair point. I do recall that. I didn't ask my question well, or my scenario I need to flesh out a little bit more. I want to get access to a part of the cemetery. I can't. I reach out to Ms. O'Connell or you or Mr. Whidden, say, hey, there's this issue here. And you say, that's interesting, but one, you don't have anyone buried in that cemetery, so we're not particularly interested in your right to access. But two, it's open. You can park your car and you can walk in and you are physically in the cemetery. That's the extent of our obligation. I'm not saying anyone said that, but let's say that was the response from the Homeowners Association's representative. Do I have standing to bring an action to vindicate my right of access that you said is guaranteed, my word, not yours, by the ordinance, and maybe without the ordinance, I have a right to access. And I feel that I can't access the cemetery in a way that's meaningful for me. And I don't mean that spiritually, not that that's unimportant, but I mean it very, very factually. I can't get to that grave over there. And it's not my relative. I know the nature of the cemetery. None of my relatives is buried there, but I'm a member of the public and I want to see that gravestone over there. I can't get there because of how this space has not been maintained. And Team Bluffs at Lennox said, we're maintaining it. You're able to get your feet on the property. That's the end of our obligation. Is that the end of the discussion and I don't have standing to bring an action?
I think that is true, Judge. Yes, I think that is true. You do not have standing to do that.
Who or what could compel your client to provide access to that headstone that is in sight but out of reach, if there's a disagreement that access doesn't mean you can get 2 feet onto the property, but you actually can't navigate to a headstone at the far reaches of the property?
I think in these circumstances, because this is not a cemetery that people have bought plots to and you have an contractual obligation, I think the only entity that has the right to do that is the city. If the city thinks that we are not doing what the zoning ordinance says, then the city can come and fine us and, do whatever they do through their zoning program. But I do not think that having a cemetery where we have not prevented people from going in gives all those people the right to sue us if it's not maintained in the way that they think it should be maintained.
Got it. Okay, thank you. That helps me a whole bunch, just hearing that little piece. And Mr. McConnell, I'm going to turn it over to you. I'd like you to begin your discussion, not about the experts, but about your motion for summary judgment, please.
Thank you, Your Honor. And I would be remiss, I didn't have an opportunity. When answering your initial question about who was going to argue, I failed to also introduce my clients who are here. So I just wanted to take 1 second before I dove in, with the court's indulgence. So and you may remember Ms. Audrey Collins and Ms. Rhonda Jackson.
Good morning to both of you. Thank you for coming back.
We have, you may have heard, one of the original board members unfortunately passed away, Ms. Beth Marcus. There are new board members. 2 of them are also here today, Ms. Bug and as well as Ms. Hardy. So just wanted to.
Was the other one was over there. Okay, you're blocked by the lawyer. Good morning.
Sorry about that.
That's all right. Oh, and someone else is here.
Yes.
Oh.
Cheryl Lane.
Oh, Ms. Cheryl Lane, Your Honor.
Good morning, Ms. Lane. Thank you for being here.
All right.
Oh, one other procedural thing. This is not on the record. Ms. Richardson, if you ever need a break, let me know. We will take regular breaks, but I may just be so swept up by the argument, I forget about you. I don't mean that in a bad way, so let me know when you need a break. Okay? And in terms of breaks, I have a Zoom call I have to get on at 11. That'll be about 30 minutes. So that's going to be our first break. It'll be a little longer than a 10-minute break. And then we will, assuming we're still going, we'll have a lunch break. That'll probably be more like 12:30-ish, so we can get something done between that Zoom call and when we break for lunch. And I'll probably have the lunch break be less than the standard hour because this Zoom call is going to take longer than like a 10-minute break. There are enough lawyers on both sides that hopefully we don't need to break just for the lawyers. You should feel free to get up if you need to. Mr. Knoxheim already stepped out once and that was perfect. I mean, I hope it was perfect for you, but we don't need to stop for one of you to get up and take a break. Unless you are the arguer and you need a break, in which case we will stop.
And
One other housekeeping thing. I think we agreed about this before, but I just wanted on the record that the parties are sharing takedown.
Great. I was going to cover that at the end, but we now know up front.
perfect. And Your Honor, and before I jump into the argument, I don't have snacks, but I am the bearer of a slide deck.
All right, that I'll take.
May I approach?
Please. Do you have two?
And I was told that the ones with the orange tabs are the prettiest ones, so.
Okay.
I'm gonna hand those this.
Thank you.
And there was a order. You want a copy? You're fine.
Everyone wants a copy.
Yep, sure. Did I turn those out? Okay. All right. And so, may it please the court. As we've discussed, I'll be handling plaintiff's motion for partial summary judgment. And I will demonstrate during today's argument that summary judgment should be granted as to counts 1 through 4. First, summary judgment should be granted as to count 1 on behalf of all plaintiffs, which seeks a declaration that Piney Grove is a public cemetery under Georgia law. Summary judgment should also be granted as to count 2, declaring that plaintiffs Audrey Collins and Rhonda Jackson, the descendants of 11 persons buried at Piney Grove, have easement interests in the cemetery.
You, in your pleadings and just now, use the term easement interest, which gets us into the Anderson versus David case. And everyone should know, if you haven't already figured it out, that was my case and the Court of Appeals got it wrong. But their decision is the law. I don't think they understood the nature of the easement that was bestowed upon the Davids by the predecessor of the Andersons. But my pushback is not against the Court of Appeals having gotten that one wrong. It is you calling it an easement right as opposed to access right or anything else. You're careful with your terminology. Do you think that it makes your argument easier, harder, more complicated that you're calling it an easement right as opposed to they have an access right, or maybe there's no such thing as an access right? And so since we're talking property, we need to call it an easement because, of course, once you get into easements, then there is the Anderson versus David opinion about, well, there are joint owners or people who share access to this land. And so one person's enjoyment of her easement can't impinge upon the other side's enjoyment of its easement or its right to the property. So that was sort of stretched out, but you chose the term easement, and I'm assuming that was purposeful. Do you need to call it that given what Ms. Whitlock acknowledged, that we all have a right of access, but maybe that's what an easement is, and I just didn't use that word when I was asking Ms. Whitlock?
Yes, Your Honor. Well, there are various cases that use the term easement with respect, and I believe the Davis v. Overall case is the one that says when a family burial plot is established and it creates an easement against the fee.
Okay, so there's case law involving cemeteries and access right where the term the courts use is easement, and we ought to stick with that term.
Yes, Your Honor.
Okay.
And my reading of the law, and then I can get into this further, is, you know, what is the difference between that and say what you were saying? Do I have standing to go to the top of the hill? And I believe there's public use rights under public access, under the public cemetery laws, but there's a distinction with an easement interest. And that's an important distinction, as we'll get into with respect to count 4. And the reason is that an easement interest is in fact a property interest. That is pretty clear under Georgia law. And that's why that's an interest that's unique to Ms. Collins and Ms. Jackson here, as opposed to the public at large.
Got it. And I very purposefully was asking, do I have the access rights? I'm situated differently from Ms. Collins, for example, because I don't have that familial connection. As I figured, if I have access rights, anyone has access rights. But possessing an easement right, I think, makes your standing argument a whole lot stronger, because then you are vindicating not the city's declaration that everyone can go to Piedmont Park and everyone can go to the Piney Grove Cemetery. It's, I have a property interest in this space, and that would be different from my connection to it, where I might have this public use or access right created by the ordinance.
Exactly. I think for the public access, and we will get into that springs from a different common law interest by the dedication to the public. The source of their entitlement springs from Georgia law as to the rights and interests of burial plots and in the descendants.
Does the cemetery need to be a public cemetery for Ms. Collins and for Ms. Jackson to enjoy that easement?
No, it doesn't have to be a public for them to enjoy that easement. That easement arises under Georgia law by virtue of the fact that their ancestors are buried in the cemetery. And as a matter of law, the case law sometimes uses the word heir. Sometimes we say descendants. I'm using them interchangeably. That from that is the source of the easement.
So irrespective of my finding on claim one or count one, the declaratory judgment that it's a public cemetery, there still are easement rights from your perspective that would entitle and empower Ms. Jackson and Ms. Collins and any of the other fact witnesses who can show that they are descendants of people buried there to have access to that space.
Right.
Okay.
And what the full scope of the easement right, whatever that
is,
which includes the access.
Sure. Okay.
And so, but hopefully that's the reason we did have a count one and a count two is for those two very distinct reasons, Your Honor.
Yep.
And then as to count three, we believe we're entitled to judgment as a matter of law with a permanent injunction. And that is with respect to the prohibitory injunctive relief, which would be prohibiting actions taken that would prevent us from maintaining and caring for the cemetery. And then the last one, count four, is we're entitled to summary judgment as to mandating the permanent injunction, mandating that the cemetery be maintained as required under the amended ordinance 06, I got that wrong, 06-0-0952.
So do your client's entitlement to do their own maintenance flows from their easement, right? Is that your argument? I'm thinking about count three now. There's sort of two sides of the same coin, that this space, this important space needs to be maintained. And actually, no one disagrees with that. Ms. Whitlock has said, my client has an obligation to maintain it through the ordinance, through the declaration. What maintenance means will be a source of great debate, I'm sure, will continue to be. But your count three goes further. It says, Judge, you should prohibit the homeowners association from interfering with your client's ability effectively to do their own maintenance. And I'm curious as to where maintenance authority flows from easement rights.
Well,
and maybe I'm misunderstanding what you seek to prohibit if you were granted the permanent injunctive relief in count three. But I understand it to be, Judge, tell the homeowners association to stay out of our way when we are beautifying, my term, the cemetery. We can do that. You can't put up a big neon sign, but you can do the weed removal. You can stand up a headstone that's toppled over. If there's a tree that's fallen over, if the maintenance doesn't mean that the homeowners association will do it, certainly we as easement holders have the ability to do that. Am I overstating what you're seeking to prohibit?
I mean, what we're seeking to prohibit is essentially being prevented from undertaking to have care and access for the cemetery so that you can go up the hill, so that you can access all areas. Essentially, a lot of the items, Your Honor, in the order that you entered in the consent order when in response to the interlocutory injunction.
Right.
Most of those things is what we would be seeking to preserve through a permanent.
Made permanent. Okay.
And,
But-
and
but-
we have some suggestions to rewording it slightly, but that would be what we are essentially looking for in a permanent injunction. To your point, though, your specific question, where does this come from an easement? Why do you have a maintenance? And I would direct your honor to Davis again, the overall. And there it said Davis and Farmer as heirs of the person who established, and they own an easement to enter. This was to enter, care for, and maintain the burial plots.
Okay. And there's the M word.
Yeah, and of freedom from damage or disturbance, and to use and enjoy the property. So I think it's very similar, I think, in scope to the language in Haslerig, which obviously is talking about a public cemetery. So there's overlap. I do think if you had a Venn diagram, there would be a lot of overlap between the public use rights under the public cemetery law of Haslerig and its progeny that has developed over time, and the easement rights.
So Haslerig is about public use, public access rights because it was a public cemetery.
That is correct.
Okay. And one of your points is that we think this is a public cemetery and you should so declare. But even if you don't, two of my clients have easement rights because they are descendants of people buried there. Those easement rights per Davis v. Overall give them some ancillary authority to be able to get onto the property and to maintain the cemetery. And that's where then making the temporary injunction permanent is exonerating those rights that flow from the easement they enjoy.
Correct. It would flow from the easement as well. For the Friends, it would flow from the public. They would, our position is that Friends has a public access right. And because of that, we're also relying on Haslerig as support for that count. So,
Right.
and that was the reason I do think that these interests overlap and they support the same relief.
No, I appreciate the Venn diagram concept, but there is a sliver that falls outside. This is a public cemetery that still would entitle two of your three clients to the relief they seek.
Absolutely.
Okay.
If it's not found to be public
Mhm.
use. And then as to the count 4, that is that they are entitled to enforce the ordinance. And this is only that plaintiffs Collins and Jackson have that. We're not asserting that Friends
Right.
has standing to assert that claim. And I didn't know, Your Honor, you're obviously very familiar with the record. I was going to go through a short presentation of the facts. If that's unnecessary, I'm happy to jump right into the argument.
The part of the facts I'd like you to address right now, and then we'll bend back into the facts as questions lead us there for both sides, is what in the record shows that it is a public cemetery, by which I mean, because where I think the two sides are colliding is not that it was a cemetery and not that there are not many people buried there, at least 300. It's a large cemetery. Not that it's unimportant. Every cemetery is important. But the part that was less clear to me was who could be buried there. And I'll just state now, and the defense will do what they want with it. I'm unimpressed with the fact that they observed that no one white was buried there. That, to me, ignores the social realities of what was going on in Atlanta when that cemetery was open, and in the sense of people were being buried there. So I'll hear that, but that's not moving the needle at all for me. But I also read that to be buried there, you needed the church's permission. And one, is that a correct recollection of what all the evidence is? If so, how does that impact the notion that it's a public cemetery where if my my family's not from Atlanta, but if my family had been from Atlanta, wanted to bury my great uncle there, could we have done that? And if the church, for whatever reason, said, no, that's not going to happen, then is it not a public cemetery? So if you could just, on the facts side, and this goes straight into count one, so it'll get you there, but that's the part of the facts I struggled with the most, was trying to figure out how to reconcile what I thought was an agreed upon fact. And if it is a material issue, then you don't get summary judgment on it. We'll litigate it more. Did the church have final say as to who could be buried there? And if they did, how do you turn that cemetery into a public cemetery?
Well, Your Honor, and I do think in response to your question, the testimony is that yes, the church did have final say based upon some of what the descendants said, but they never turned anyone away. And I do think, so I think that is what is important, and that the testimony has consistent, and we had various descendants testify to this point, which is, or they testified to this point, that it was open to African Americans throughout the Buckhead community, and primarily for those who could not afford to be buried elsewhere, and that they would be available for the folks to bring their loved ones there to be buried, whether or not they were affiliated with the church.
Okay, that's my next question. Do you have a sense of, we combed the records and there's one guy buried who wasn't a church member, but he worked for the church. He wasn't a member, but he helped keep the church clean? Or is it, there were dozens of people who were buried there who weren't church members. Yes, it was church property, but the community knew this was a safe and open space to bury family members. And yes, you asked the church and maybe you give a little donation, but you were never going to be turned away.
Right. And like I said, I do believe, and I can come up with the specific names of the descendants who testified, that it certainly was viewed in that fashion and that it was open. And I also believe the testimony, and this is where Dr. Robinson, who's going to be the subject of the expert, but through her anthropological research and looking at various materials, it's her view, and I'm not going to have the precise number, but I do think that it's at least 20 to 30 individuals that probably were not affiliated.
So 10% of the folks buried there weren't church members.
Right, and that could be understating it, Your Honor. The reason that could be understating it is what it's based upon is we looked at where the church service for that particular person was, who was buried. And many times in those 20 examples, the service was at another church, but the burial was at the Piney Grove Cemetery.
Any sense from the record of whether that church was also the largest church in that area anyway? And so it's not particularly remarkable that, I'm going to now flip it to say only 10%, but that's because most people in that community were members of that church. And so you wouldn't have a lot of non-members buried there because everyone was a member of the church. Does that question make sense? Correct, right. If it was the only black church within 3 miles, then everyone's going to be a member. And it's unremarkable that there weren't many non-members buried there because almost everyone in the community would have been a member of the church. And so looking to the signification of member or not isn't a good read as to whether it was a public cemetery. This was the black cemetery, and this is where black people were buried publicly. I'm wondering if that was work that one of your experts did to say, well, of course, most of the people buried there were members because most of the people in that Buckhead community were members of the Piney Grove Baptist Church.
Well, and in fairness, Your Honor, there were many African-American churches that were located throughout the Buckhead community.
Okay, so that's not the answer.
Right,
Okay.
and that's my understanding, and I want to, but that's my understanding.
Okay.
But what it does show is that a member that was presumably someone who had their service at another church is unaffiliated with Piney
Right.
Grove, but Piney Grove took them in.
Exactly.
Which is going to the point, and I don't think there's any evidence in the record that anyone was ever turned away. And that the reason that they had to go and talk to them is like any other place. You have someone who manages it, someone who has an understanding. This is where you're going to be buried. We have a delineation map, which I'm sure you've seen, which I'm sure there has to be some.
You don't just show up and say, I'm gonna dig the grave site right here. Hey, we're here, great, here's a spot for you.
Correct, Your Honor.
Did the work your experts did indicate of the various Black churches in the Buckhead community in the 30s, 40s, 50s, 60s, did most of them have graveyards, or was Piney Grove Baptist, if you will, a destination because there weren't other options?
Some did have cemeteries. For example, the one in the Mount Olive Cemetery was affiliated with the Mount Olive Methodist Episcopal Church. That's right on Far Road, Your Honor. It's a stone's throw from the place that we're talking about here. It's very, very nearby. They had a cemetery. Other churches did, some did not.
Okay.
But again, the testimony of the descendants was that it was known within the community that if you didn't have the money and the resources to bury, this Piney Grove Cemetery had their arms open to you.
Is there any evidence in the record that contradicts that? Or is that the only evidence in the record
That is
people who knew, people who have recollections where that recollection is more or less uniformly, this was open to members of the community. You didn't have to suddenly say, okay, I'm going to join your church so that I can be buried here.
That is correct.
Okay.
We had multiple descendants testify to that very point, Your Honor.
Thank you.
And I didn't know are there any other facts, or is it better just to take them up as we proceed through the argument?
The latter. One other question, it may be more for defendants. It's not, I don't think it matters to you quite so much, but who ultimately developed it? Was it JBGL or Providence, or does it just not matter?
They're affiliated.
Okay, one's a parent of another?
Exactly, Your Honor.
Okay.
And one was the developer, one was the builder, and they're under a common ownership.
Okay.
And Mr. Smith was a representative of them, and then when they developed it, was also a representative of the HOA.
Okay.
All right, well, let's just jump into count one, and we were dealing with that. And Your Honor, as we know, Hassler-Rig is going to be the key decision here. And how does this case fare in comparison to that case? Well, just like this case, the Hassler-Rig case involved an African-American cemetery that had been in use for over 50 years at the time of the action. Just like this case, it was undisputed that prior owners of the property verbally consented to be available to African Americans in the community. Just like this case, all owners in the chain of title, all of them, had knowledge of the existence of the cemetery, which was identified in surveys throughout the relevant time. And those surveys are in the record, and I believe some of them are in the handout that I had provided to the court. Just like this case, a subsequent owner attempted to restrict access to the cemetery. We go to slide 13. And in that instance, how did the public was going there? They wanted to do a burial, and then also wanted to access. The owner was frustrated with them because he wanted them to join in a lawsuit against Georgia Power, which had done something on it. They declined to join that lawsuit, and it looked like retaliation. So he obstructed the roadway, and large logs and rubbish were used that interfered with access to and through the cemetery, getting up to the top of the hill. And also they were trying to do self-help remedies because he had cattle trampling over the cemetery. And they said, we want to put a fence up to prevent that. And so this was tried, and of course, the injunction was granted in favor. And then on appeal, the whole issue was, what is this? How was this a public cemetery? And the first thing the Supreme Court said, there's no exact form as to how this happens. And what we do is we look at the fact and circumstances, and we take that into consideration. And, what is there an intention by the owner to dedicate this property for the purposes of being a cemetery? And you don't need some formal acknowledgement, but
When the church sold the land, was there anything in that transaction, some covenant they tried to extract from the gentleman who bought it that would preserve or protect the cemetery? Or they simply said, here's the land, it's yours now?
well, at the time of the transaction, Your Honor, they did maintain an easement to the cemetery across. So this is in 2002. And at that time, the access, the church was, and I wish I had something, it would probably be good if you could visualize this. Do we have one of the slides that would be good for the register?
What did it look like?
Just from a survey perspective.
Because when Mr. Ahmed bought it, his first plan was to actually dig everyone up. That says to me that the church said, you do what you want with the land, as opposed to, you can develop this, but this is sacred. You're agreeing when you buy this to either we maintain an easement on here or whatnot, but you're saying they preserved an easement or maintained an easement. It sounds like it was an access easement and not anything that would have prevented Ahmed from doing what he initially tried to do, which was to dig everyone up.
Right. And if I could, and now this is very good facts to
Well,
get.
but it seems like bad facts because Hasslerig doesn't involve anything like that. There was never someone who said, now on this land, I'm going to turn it into something else. This isn't a public cemetery, it's private land. I'm going to dig the bodies up.
Two answers to that.
Okay.
In fact, one legal and one factual. First, a legal one, doesn't matter. Because once it's been dedicated to this as a cemetery, it can't be revoked. It can't be revoked by the one that dedicated it. Once it's been accepted by the public, it can't be revoked by anyone subsequently in the chain of title.
Whether it's private land or not, it
Whether
has
it's
become a special type of land, even though privately owned, that the new owner or subsequent owners can't change the nature of it.
Right. And that's a good example of that. And there's several, but this is just one that comes to mind, Your Honor, is Brandon v. Perryman, 308 Georgia Appeal 832. And in that situation, this had been a longstanding cemetery for about 40 years. Subsequent owners decided, we don't want you to use it as a cemetery anymore. They said, you can't revoke it. That's not up to you. And so I'm sorry, Your Honor.
So if Mr. Ahmed had actually moved forward with the disinterment plan he had, people would have had a right of action to stop that because he would have been undoing the dedication. He ended up changing course, but it doesn't sound like, maybe because he backed away from it, but the record doesn't seem to show that as he was exploring this option, that people were seeking to prevent it from happening. He decided on his own not to do it.
No, Your Honor,
No.
that the record that conflicts with the record.
Okay.
And we rely on the testimony of Mike Reynolds, who was he was a 30B6 witness for Brockington. And
that's the company that was doing the survey of the land.
They were retained by Mr. Ahmed. And I think they were exploring all options, the developer. And one of the options under Georgia law, this is a statute. So you can go to any cemetery. Someone could try to do it now. The homeowner association, if they want, could try to have this declared under Georgia law to be abandoned. And then if it's abandoned, then there's a disinterment process. And there's a statute under Georgia law that says how you go through that process. And it's not, even if it is deemed abandoned, there's any number of things then that could happen. The city of Atlanta can acquire it through eminent domain.
Okay.
It can do, there's a variety, so it's not one end. But now factually, to your point, did anyone raise their hand? Yes. The public did get involved in connection in the summer of 2006 when this was starting to be, there was never a formal application to do the disinterment.
Which is why these ordinances were, I mean, the ordinances didn't just fall from the sky. I guess this would have been, people began to express concern. What's Mr. Ahmed or Capital Partners going to do to this property? And the city stepped in to say, you can do a lot of things with the property, but the cemetery is the cemetery and it stays there and people have access rights.
Right. And the way, because Mr. Reynolds, they were retained to try to disinter the bodies. They had an interest in doing that. So I asked him during the deposition, I'm paraphrasing obviously, so why did you stop? And he said that his understanding based upon the lead project manager for the project is that they were getting so much opposition in the city of Atlanta that they weren't going to go that route. And then the next thing we see is what you put your finger on, Your Honor, which is the evolution of what came to be the ordinance. So it's that was the deal that the developer went to Plan B and said, instead of moving these people, we'll care for them. We'll care and maintain the cemetery.
But if Brockington concluded that the cemetery was abandoned, does that mean there were experts who said it's not a public cemetery, or it may have been, but it's not anymore because it was abandoned? And yes, there was city opposition and ultimately there was an ordinance, but had we persisted and just put our heads down and ignored some of the public outcry, we could have gone forward with disinterment.
They were retained to say it was abandoned.
Well, that's one way to describe it, but everyone retains an expert to say we win.
Oh, no. They were.
Yes.
No. I'm not disagreeing with what your Honor said. Yes, experts are retained to say we win. But in that instance, just like every other expert, you get to assess the credibility. What they say isn't adopted by the city of Atlanta. That was never even submitted for consideration by the city of Atlanta. Whereas their archaeological work that they did, in terms of the delineation map, that was all within the scope of their expertise as an archaeological field. They are not lawyers. So for them to determine and make that assessment, and his examination is to that point. So that's all I'm suggesting with respect to that. And even if they did say it was abandoned, that's not the end of the story.
No, I understand.
I'm trying to circle back. I think we were talking, or I was talking about the obstructions by, and you wanted to know also, the first one to question was, well, if Mr. Ahmed wanted to do this, doesn't that show it's not public and you can't revoke it? So the public part survives. The second part, Your Honor, and I just wanted to briefly show you this, is on slide 4, and the cemetery is highlighted, the dimensions. If we go back to 2002, if you look just to the left, in the upper left corner, it's my understanding that's where the church was located. So if historically, what you would do up there is, you see where the 3 units are? Mm-hmm. That's roughly where the church was. You would access, there was parking up there, and that's how you would go to the cemetery. And that's the top of the hill of the cemetery right there, and it goes down from there. It's my understanding the church retained an easement, access easement to the cemetery.
Is this a topographical map so that the dashed lines represent altitude change?
I don't.
Your colleague is saying yes. That helps.
Yeah, anything with a real estate survey, Mr. Todd is that person.
Okay, but it helps illustrate the slope. It's not flat land.
Yes, Your Honor.
Okay.
So anyway, I just wanted to point that they did, it wasn't like they just said, we don't care about the cemetery anymore. They did retain an easement, it's my understanding.
Okay.
And so the legal holding there, as we were, no form or special ceremony is necessary. And assent can be shown through expression or concurrence or acquiescence. We have all of those, Your Honor. We have testimony that the church agreed to do it. We have testimony that they understood that this was going on and that's what it was being used for. And also what Hasselrig is important, going to your point, can you go up the hill? Is the cemetery is more than just graves. It includes all walks and grounds for shrubbery and ornamental purposes. All must be regarded as consecrated to a public and sacred use. And it doesn't take much to show acceptance. In this instance, the Hasselrig court showed that after the dedication by the owner, it was accepted by the African-American community after that day, and the cemetery had been in continuous use for 50 years since then. And here, I think we're stronger than Hasselrig. We've been open and notorious for over 100 years.
Right. Does the fact that the last burial was 1991 and what we're dealing with is 10, 15, 20 years later, how does that change the analysis? I understand dedications don't expire, although something can become abandoned, and I'm sure I'll hear about that from the homeowners association. But it sounds like with Hasselrig, people were still trying to use it in the classic sense of we are trying to bury people here, and I don't know who the person thwarting that was, Hasselrig or the other name, but someone was preventing the community from continuing to bury people and obviously spend time at grave sites. Here, there wasn't that type of use proposed or attempted from 91 onward. Does that have any impact on the analysis? Because that's a difference from the Hasselrig.
Right. And, and it's an interesting question. I guess, if you haven't used the burial, does that do something, not necessarily to the status as a public cemetery, but as to that use right? I think that would be how you would look at it. But there's nothing under Georgia law that would suggest that there's a revocation, that you have to have a burial
Every 5 years?
Exactly.
Okay.
So, and nothing in the cases would suggest that somehow, all of a sudden, because someone hasn't been buried there in 10 years, that you can't go to the cemetery anymore, or you can't care for
Then all the historical cemeteries would expire. You reach a capacity, you can't fit anyone else.
Exactly. And this one, and the delineation map, Your Honor, I believe is slide 2, if we could. And this is a map that Dr. Robinson relies upon. It was one that was created by Brockington, and I believe it was 2005, and they used this probing technique in order to go to each of the graves, and they had to be able to access each of these things to go with these probes to see. And so back in 2005, they could do that.
Church would have been, and it says Georgia 400. Okay, got it. I'm just orienting. Keep going.
And so my only point is, and then there's some water drainage that goes down, as you can see through the middle there. There's a lot of graves out there already. So the only thing I wanted to go to, you said it may be at capacity. I don't know for a certainty that it is, but just visually looking at it, it looks pretty full. I just wanted to point that out to the court. And then the other factors we've already discussed. I just think that, it's undisputed the church owned it for the 100 years. The surveys, numerous civic organizations have acknowledged this. That goes to the open and notorious nature of the cemetery. This goes back to the 80s, Your Honor, where they were talking about National Register There's various political officials that have gotten engaged over different time periods, from the early 90s with Georgia 400, when it was going to be there very close. The civic organizations, Beth Marcus's mother was very involved in trying to preserve the cemetery at that time period. And then in the 2005, 2006, there was community involvement in trying to get focus so that it would be preserved, notwithstanding the development. So that also, I think, is important, that it was understood to be a cemetery, and that the public and it was open and notorious for those purposes. And then I think the city of Atlanta's ordinance itself is evidence that this is a public cemetery. It refers to in a number of the zoning board as that this is a hallowed ground. It is referred to as historic, and that it wanted to, contrary to it being abandoned, saying that you got to maintain access to the cemetery, and that it also, you had to provide the maintenance for it. And you could only build your site plan in accordance with the site plan that we saw a little earlier, which clearly showed the preservation of the cemetery. And I think all those are factors as well that support the public cemetery analysis. And then even the HOA zone declaration.
Yeah, I circled that in my notes here. What in the declaration says, oh, that's a public cemetery? That kind of defeat the, well.
No. Well, none of these will say public cemetery. That's a legal conclusion. So we're looking at the facts and circumstances. One of the facts and circumstances that Hasselrig focuses on is this open and notorious. And what's evidence of open and notorious? How do people refer to it? How do they characterize it? The HOA, in writing their own declarations, refer to it not once, but twice as an historic cemetery. In two sections of the, if we could pull up.
But historic doesn't mean public. It could
No,
still be private. It could have been the Smith family cemetery that had been on the church property. And the Smiths gave a lot of money to the church. And so their family was able to be buried there. And no one else. If you weren't a Smith, you couldn't be buried there. And it could still be very historic. And so the HOA acknowledging what the city told them they had to do anyway, how does that make it some understanding that it had been dedicated to the public?
I'm not saying necessarily it's a concession by them that it's been dedicated to the public. And
Okay.
I'm not trying to overstate that.
Okay, but it's an indicator.
It's an indicator. The fact that Hasselrig is focusing on is that open and notorious. And I'm just saying, what they are saying, yes, this is a cemetery. We know it's a cemetery. And not only is it a cemetery, it's a historic cemetery, which to me means that's well known, that is notorious. So it goes to that factor. No, by itself, Your Honor, I'm not suggesting that's definitive, that it's a public cemetery, but I do think it is included in the data points for the court's consideration. And last, Your Honor, we do think that the decision by Judge Downs in 2010 in the Osby v. Marshall decision is instructive. That involved the Mount Olive Cemetery. This involved another African-American community that used to exist in Buckhead. And I may say it wrong, it's either Macedonia Park or Macedonia Park. But I mean, no offense if I mispronounce it, but that in the 1940s, that had been an African-American community with about 40 homes or 60 homes, I should say. And this was a cemetery affiliated with Mount Olive Episcopal Church. It did not have as many folks buried there as we have, and the footprint of the cemetery is a lot smaller than the footprint of the Piney Grove Cemetery, which is approximately an acre in size. And in that case, the question was whether a person that bought the property could move the bodies, and went in and was trying to do that, and it received opposition from folks from plaintiffs who was a descendant to object to it. And there, the court relied expressly on Hasselrig and acknowledged that following Hasselrig, a long line of Georgia cases have held that public burying grounds cannot be disturbed. And court held that there was no disputed facts that the cemetery, which served the surrounding African-American communities, was dedicated for public use. I think it's a very similar situation and similar fact pattern. And the fact that it was frankly not very far from the current location is instructive that Hasselrig also applies here. And the defendant essentially, as my understanding, raises about 4 arguments in opposition. It says that there's no evidence that the church intended it for a public use. Again, Hasselrig doesn't require any certain type of form or a formal grant. All it shows is conduct. So is their conduct consistent with the church acquiescing with the burials? And Your Honor, there's no dispute that happened. Then they said that there was no proof that anyone accepted this dedication, but we disagree with that. Very similar to the Hasselrig reasoning, Your Honor, which is the African-American community did accept it by burying people there. And also they argue that unless the owner abandons all interest in the fee, then it can't be declared to be public, but that's not the case either. It certainly, the fee passes subject to the public interest that is created under the public cemetery, which can't be revoked by any subsequent owner in the chain of title. And so for those reasons, we respectfully say that we disagree that this is not a public cemetery. They raised various standing arguments. I can address that if the court would like for me to do so.
Well, we'll need to at some point. It's one of the questions I asked is, would I have standing to do that? And the answer I got is really no, only the city. The city is the only entity that could, but we hadn't gotten as nuanced as access right versus easement. And I want to be fair to Ms. But I didn't ask Ms. Whitlock if an easement right holder, and if we accept the case law that says descendants of people buried have certain easement rights, that's different from my ability to sue, trying to vindicate my access right or use right created by the ordinance and by the HOA declaration. It's a separate set of rights flowing from that common law that says if you're a descendant of someone buried there, you have an access right. And I didn't get to press Ms. Whitlock on that. But I have always assumed there's very, very different standing for Ms. Collins and Ms. Jackson than Piney Grove.
Correct. And for the Friends of Piney Grove.
That's what I meant.
Right.
You're
And I did, as to count one, I'm not sure because it kind of goes back and they've taken a position. I don't think they're challenging standing as to.
How about this? I'm going to let them argue that when it's their turn, and then Ms. Metcalf can
Yes.
swoop in as the rebutter.
That'll be fine.
Okay.
However, that is absolutely fine, Your Honor. Then shifting to count 2, and this will be much quicker, Your Honor, this is the entitled to a declaration that they have easement interest in the cemetery. This is.
Doesn't the defense agree with you that they do? It's a question of compatibility of easement rights. And this is where the Anderson v. Davids case come in, that they acknowledge there are certain easement rights that Ms. Collins and Ms. Jackson have, but they are, 1, limited, not absolute, and 2, they need to be exercised in a way that is consistent with HOA's property interests.
Absolutely. And Your Honor, I don't really think that should be a source of tension. I think, as with a lot of things, this is going to require.
When you say a source of tension, meaning the concept that I just described?
No, the idea that we are not disputing that the homeowners have an ownership interest in the property, and obviously they have rights with respect to the property, and they can't interfere with the rights of the public, and they can't interfere with the rights of the descendants with respect to their easements, but nor can members of the public and the folks who are descendants interfere with the property interests of the homeowners. The homeowners are the servient, right? The dominant tenant in this relationship is going to be the owner of the easements. And so, but as a servient tenant, they certainly have interests, and we can discuss what those could be. So if there's time and place, as the court was saying,
Yeah.
you shouldn't be able to show up with a marching band at midnight.
Right.
We get that. You shouldn't be able to have a chainsaw.
Okay.
You know.
This gets to the contours of what is the relief that is provided through this litigation, as opposed to, is there an entitlement to use and access by way of that easement that is naturally bestowed upon descendants? Got it.
Right. And so with that, if everyone's agreeing they have easement interests.
Well, I'm not speaking, I'm going to let, they'll get to speak their piece, but I think you're right. This is not one where we need to spend much time about, does the easement right exist? It's going to be, how does one navigate
what you do with it.
Right.
And I think, Your Honor, one, if I may suggest, count two is just a declaration that they have an easement interest, which is where I was, where now what can you do with that easement interest? That's going to be 3 and 4.
Okay, let's go there.
And then count three is more than simply the easement interest. This is also on behalf of friends as a member of the public. And this is our Venn diagram situation, because I do think what we have requested in the past and what is in the consent order was on behalf of all plaintiffs. I think a permanent injunction should be on behalf of all plaintiffs
So
as well.
let's violate my instruction and talk about standing a little bit here. How does Friends of Piney Grove have standing to seek the injunctive relief?
Okay.
Because if their rights of access and enjoyment of the cemetery flow from the ordinance, what I heard Ms. Whitlock say is, okay, the city needs to then bring some action. And maybe it's code enforcement rolling up in a little truck saying, you have to remove this tree and you have to do that. But the complaint would flow from not Ms. Collins and Ms. Jackson, but from Friends of Piney Grove to code enforcement, or I don't know who the city council person is for that part of Atlanta, Shuk, or whoever replaced Shuk, whoever it is, person X. Hey, I can't get to this cemetery, and there's this city ordinance that says I should be able to get here. But the city enforces its ordinances. We don't have the private citizen ordinance enforcer. That's the argument.
Yes, Your Honor.
And let me finally say, and I promise to let you talk, part of me says, who cares? Because I think your other two clients have an absolute basis to bring an action for a permanent injunction to vindicate their easement rights.
Right.
But all three have sued for this.
Yes, Your Honor. And the main distinction, and I agree completely, when it comes to the enforcement of the ordinance or reliance on the ordinance in terms of the relief, then Friends does not have standing. And we haven't taken the position that they have standing as to that. Count 3 does not turn on enforcement of the ordinance. Count 3 is based strictly upon the rights for care and maintenance that members of the public through a public use have as a public cemetery, and also that descendants have under their easement interest for care and maintenance. That's the prohibitory. We don't want to interfere with them going on and caring and maintaining the cemetery.
So is it Haslerig and other cases that gives the general public a right of access and general maintenance?
Yes, it is, Your Honor.
Okay, not, it's not the ordinance you're pointing to, or the easement rights that would flow from other case law, but your contention is that Hasselrig gives not just to descendants of people buried there, but the general public, predicated on a finding that it's a public cemetery, that we all, as members of the community, would have a right to maintain this public space. And if that right is being compromised by the HOA as the dominant tenant, whatever we want to call it, their inactivity, or keeping us off with our clippers and our rototiller or whatnot, then we have a cause of action.
Correct.
Okay.
This is the self-help side of Hasselrig, Your
Okay.
Honor, where, you know, I mean, don't let the cattle trample the cemetery.
We put up these fences so the cattle would stay out.
Right. This is, we're trying to get the weeds out of here. We're trying to, so you can get up the hill. We're
And
trying
did
to-
Hasselrig actually get to the granularity of, hey, there were members of the public who were seeking to put up the fence as opposed to descendants, and so it's the easement right as opposed to the public's right?
And Your Honor, I'd have to go back and look at the case, because I know that the discussion of the cattle, I believe, was in the discussion of the complaint and the relief that was being sought, whereas the decision itself, I don't know if it sheds a whole lot of light. And when you get into whether it's part of the holding, is it implied, is it, a physical precedent? I don't want to mislead the court.
I don't feel misled. I'm curious.
But that is what count 3 is about. And if I understand the challenge to standing as to Friends is that they're a corporation and therefore they don't have standing.
Yeah, you don't need to respond to that.
So what is the standard? And I'm sure the court, you're very familiar with the standard. It's set forth in OCGA section 9-5-8 that the elements for the entry of a permanent injunction is appropriate and clear and urgent case where there is a vital necessity to prevent a party from being damaged and left without an adequate remedy of law. And so the first question is, does a vital necessity exist? And we submit it does.
Where all your experts come in.
Right.
Yeah.
And that's where the experts come in, well as the fact witness descendants, because they're testifying as well about problems in trying to get to the cemetery, trying to access it. And
what they find when they get there. And if we wait any longer, this headstone will disintegrate, or who knows what'll happen.
exactly. And time is not on our side. And so in this instance, it's, and I, there's huge trees that have fallen out there that there's at least 3 major logs that have fallen down that almost go the entire width of the cemetery at portions. You can't, you have to walk around them. Some of them have fallen on headstones. They have just been left there. And of course, growth now is going over them as well. The invasive one, it's a constant battle, because what has happened when those trees fell down, the canopy was destroyed. That canopy used to protect it so you would have the natural species there. Instead, with the additional sun, invasive species have gotten in there and have just taken over. And it's a constant day-to-day, month-to-month battle with that. And then also, the no trespassing sign is a real problem. This no trespassing sign, Your Honor, and I believe Ms. Metcalf will probably discuss it further, and we have a slide in there for you. This is the sign. And this sign is erected, and just so you can see, this is a better example. This is slide 41 of the deck that we handed up.
With that blue arrow that's how you get into
That
the
was in it,
cemetery?
yes, that's how you get into the cemetery. And so and I don't think there's any dispute that this no trespassing sign discourages people from going to the cemetery, and there's no signage that, hey, by the way, this is the access area to get to the cemetery. An access area that the city of Atlanta mandates for vehicular and pedestrian access. And if I'm driving up, the first time I drove up, I was like, can I go on there? I'm an attorney. And I had to really think through the issue. And so that is very discouraging to folks who may not, certainly now, friends and our supporters and folks who are familiar with it know that they can go to that access area.
What is the vehicular access? Because part of the guarantee is that there would be vehicular access. I don't mean you drive through the cemetery, but
To the cemetery.
to it, but I don't see any parking
Do
here.
we have the site plan? Can you pull that up? Which slide is that? I think I can show it on the site plan, Your Honor. Can we go to the prior one of that? I don't want the.
Is it locked down?
Go back to 4, please. So where on this?
And I was hoping, so the blow up is of the blow up of it's covering the easement.
Oh, it's covering where?
That's the reason why I was trying to see if I could get a better one for Your Honor. But if you look, go to down to the middle of the page, you can see the entrance where the circle is.
Okay.
And
So that
and
the
that
photograph
sign-
where there was the sign that said no trespassing is somewhere in the vicinity of that gray.
Exactly.
Looks like a letter P on its side, sort of.
Yes, Your Honor. And then if
Because
you
Whitlock may have something here.
If I could just say, Judge, that arrow is the vehicular access. The
Oh, that's
sign
paved?
On the other side
oh,
of the driveway, and you drive where that arrow is, you walk in there and you also drive in there, and people do drive in there down to the cemetery.
So then let me ask my follow-up question. Is there parking down there? If I were to turn right and go where that blue arrow was in my small car, so it would fit down there, could I park, or I could just drop people off and it's a turnaround?
You can leave your car there and go down. to the
Okay.
cemetery.
That gets to my question. I appreciate that there's a sign that says no trespassing. That's a different issue. But I wouldn't have to park at Lenox Mall and walk up there if I drove there. Clearly you could walk down the hill, but you can drive down the hill and there's a space to park a car or two and then walk a lesser distance to get into the cemetery.
Yes.
People are shaking their head in the audience saying that is not how it works. Oh,
and I
you're not the
really-
right person to answer that.
No, I am the right person, but I also don't want to get into a disputed area of disputed fact,
Okay.
but because I don't think there's a dispute. The sign is the sign.
Sign says what it says. What would happen if I drove past the sign and turned right and went down the hill? What, do I drive into a bush? Do I drive into mud?
You would pull up what looks like a grass area, but it has, and I forget the name of it, but the developer put in some type of support that will allow vehicular traffic to go through there.
Okay.
And
I can park my car?
I don't know that you can park your car there.
Okay.
I've never seen a car parked there, the times that I have been there. There's no signage that says you can park there. There's no signage that says that this is the access to the cemetery. You would have to try to have a map with you such as this.
You'd have to know that this is the important place you're trying to go to. You're with someone who's been there before, something like that.
Exactly.
Okay.
Because there is testimony that people went there and couldn't find it just because of the lack of signage, because of the no trespassing sign. But you are right. Theoretically, you can drive to the entrance of the cemetery.
Okay. So you have been talking about the vital necessity, time is not on our
Exactly,
side.
yes.
And I got us.
And we were just kind of going through, what is the vital necessity and what has the HOA done to create that vital necessity? And these all contribute to this. We respectfully submit that this is no different than qualitatively different by allowing the invasive growth, by allowing the logs, by allowing all these things from Hasslerig or the overall B. Davis case where they were piling junk around and near the cemetery and allowing animals to roam and interfere. Any of those things are out of bounds for interference with the public use access. Now, what are the consequences? This goes to the expert. This is where Dr. Robinson testifies extensively. This is where Dr. Hobson testifies extensively, both of the historical and anthropological significance of this, not only from an anthropological standpoint, the collective memory of the community. In many respects, Your Honor, this is the last vestige of the last physical monument to African-American communities that historically were in the Buckhead area during the Jim Crow era. And a lot of those communities, and this isn't passing judgment, right or wrong, are gone through development. The MARTA station, that used to be Johnsontown, down by MARTA, it's just a plaque now. But the physical remnants of that, the people that made that up, are left in that cemetery. And that is important to preserve that as that physical historical landmark. But it's also important for other reasons. It provides additional opportunities for future research. It provides opportunities for ethnographic anthropological research. And it's our understanding right now that a student at Oglethorpe with a graduate degree is doing that. So for all those reasons, we think that this easily meets the vital necessity test. We don't, getting into the weighing of the harms, Your Honor, we don't think it's close. We think the evisceration and elimination of this cemetery in comparison to, frankly, what is modest expense to maintain it clearly outweighs the other. Now, I think, unless you have questions about that one, I want to jump into the mandatory because that is a little different. And so not every citizen has standing to enforce a zoning ordinance. We start with that.
Does any citizen have standing to enforce a zoning ordinance?
Yes, Your Honor. If you are a person with a property interest that is specifically impacted by the ordinance, then yes, you are. And a good case on that, Your Honor, is the AT&T Wireless PCS Inc. versus Leafmore Forest case. That's a Georgia Court of Appeals case, 235, Georgia App 319, 1998.
I'm sorry, can you give me those last numbers?
Oh, sure. It's 235, Georgia Appeal 319.
Thank you.
And this is a case that is also, defendants rely on this case, Your Honor, in their response brief. And this was a case that involved a zoning ordinance where it was a conditional, just like here, a conditional zoning ordinance, and the veterinary clinic was allowed to have a clinic next to a residential area and nearby homeowners. And that the condition was you had to use it only for veterinary purposes. But the veterinary clinic found another way to make money with the property, and they entered into a contract with AT&T to put in a cell tower on the same property. And they worked with the DeKalb County and received a permit to go forward with that. The lawsuit was then brought and it was challenged. The standing issue was addressed, and the court held that yes, these folks have a property interest. It didn't matter whether it was, because a lot of times in the stuttering, this is one of the arguments defendants make, is that that's limited to if you're just appealing a zoning decision, which it frequently is the case.
Sure.
But it's not always the case. And as is stated in this case, they were allowed to enforce the zoning ordinance and successfully did so. So and the court said, you know, whether it met the substantial injury prong, and the court said yes, because the Leafmore residents, the nearby residents, open quote, would bear the brunt of the changed conditions, because by the permit, they eviscerated the conditions. It'd be like writing out the maintenance obligation. Further to this quote, they were the express beneficiaries of the rezoning conditions which they seek to enforce, which is precisely, Your Honor, is our situation. The beneficiaries of that ordinance, the maintenance and care, are certainly the descendants of people that are buried there to go and to visit those graves. So with respect, so as to that aspect, we think that they they apply. Now, as to prong one, but there are two prongs, so that's only the second prong, and I've kind of jumped ahead in response to your question. Prong one is you have to have some type of property interest, and so that is, you know, the question, which is, do you have an interest in real property? And so the question is an easement an interest in real property? And we believe the answer to that is an unqualified yes. And there's many cases in our briefs that raise that point. So I won't elaborate it, but the Arlington Cemetery case says that specifically, because they have an interest. They say that they have an interest in the property. In that case, there's also the WSCE resort owner case, which is cited in our briefs, which confirms that an easement interest is an interest in property. And so as to count one, we do, you know, it's our belief that certainly the stuttering test applies whether it deals with an appeal or enforcement. We believe that they have a property interest. Is that property interest unique to them, or is it shared by the community at large? It's not shared by the community at large. This would be the difference between you and them with respect to that. And that's the reason I was drawing the distinction for purposes of 3 and 4. And then they also say that in their response that you should not allow an injunction to enforce a zoning ordinance. And we disagree with that for two reasons. One, the case, the AT&T case, but also the Georgia Supreme Court also held that you can use an injunction to enforce an ordinance in the Harold v. Little Pup Development and Construction case 269 Georgia 143, that private citizens can enforce a zoning ordinance through injunction. And there the court held that the plaintiff citizen was entitled to injunctive relief as a matter of law. And there was 3 things that the court looked at. The language in the conditional ordinance was clear. We submit that the language in the ordinance here is clear, that the developer failed to meet the condition. We submit that in this instance, the party that was obligated under this, the HOA, has failed to meet the condition. And the public is entitled to rely on the 4 corners of the ordinance.
You're also seeking to enforce the declaration, and that would seem like it's less controversial to enforce. I mean, count 4 is brought by the individual plaintiffs only, or it seeks relief for the individual plaintiffs only. So we don't need to worry about standing or what the corporation wants. Why are you not also arguing to have an injunction that would enforce the HOA's obligations under its own declarations, in which case you don't have to do the dance about you're basically telling the city to enforce what it's supposed to, really, for the homeowners association to comply with the ordinance, but it's still, you're using an injunction to enforce the city's ordinance. You're doing the city's job. You're not doing anyone's job other than having me tell the HOA to do its own job under the declaration. Or are you not seeking injunctive relief in connection with the declaration? I think you can get both. It may be that a ruling would be you're entitled to both, but should an appellate court find that this is an improper instance of a court saying injunctive power can be used to enforce an ordinance. Nonetheless, the two plaintiffs win because you can have injunctive relief enforcing the declaration.
Right, and you can, as under a third-party beneficiary argument, which is pled in the complaint, and there's testimony from Mr. Smith of the HOA that they were included and intended as beneficiaries by that language.
Right.
Why would you put the language in there?
Right, and they have easement rights that are being compromised by the lack of maintenance.
That's exactly correct, Your Honor.
Okay. All right.
And so, and then, you know, there are suggestion that they don't know what it means to maintain. This is some ambiguous term, and if I could take a moment to address that, Your Honor. And it's covered in our briefs. I think the law is pretty clear as to what it's your job to decide what it means, and that there are rules of construction that apply, very similar to statutory rules of construction. Look at the plain meaning of the words, and also look at it in context. And we think it's very important in looking in context to not only first to look at the plain language. How has Georgia courts interpreted the word maintain in the past? And in the Hardy decision, which I think is somewhat helpful because that dealt with a public road, that means to continue in existence, to preserve.
So maintain wouldn't, I think, by any of the definitions you've relied on, be the HOA has an obligation to create a pathway that never existed before.
That's correct, Your Honor. We're not suggesting that. And we have given this some thought as to what it would look like for the types of things for what a permanent injunction would require. And I have not shared these with the other side, but I knew that from a practical sense, this is going to require trying to figure out what that would mean.
Right, and I don't think we do that today because if the defendants are successful, then we don't ever need to navigate that.
Absolutely.
But I do want the sides to be thinking about what maintain means, and it's helpful to hear you say on the record, maintain doesn't mean create something new that never existed, but maintain might mean change things from the way they were when we, the HOA, finally got serious about maintaining. Because I think that's where there will be tension. If in the end there is a ruling that you got to do what you said you would do, which is maintain, if when the HOA finally got serious about doing things, there was a tree that blocked access up the hill, one approach would be, but that tree was on its side, dead on the ground, when we, the HOA, started maintaining. And maintain means there's a tree there. We don't have an obligation to move the tree. I don't know that that's where we end up. And I think that's where there needs to be some hopefully productive discussions. That maintain might mean changing the status quo, maintaining access in a way that it should have been, but wasn't, not necessarily through the HOA's fault, it's just through the passage of time, et cetera, which is different from a tree falls down tomorrow. A tree that falls down tomorrow is on the HOA's watch after they've already said through at least the temporary injunction, we have certain obligations to do things. But it sounds like there are going to be obstacles to full access and use and enjoyment that existed maybe even before Mr. Ahmed purchased the land. And so we're going back several iterations. And so I just lay that out there to say, maintain is going to be an elastic term, but I don't think it does. And you're agreeing, someone develops a master plan. Wouldn't it be nice if there were pathways here and there that never, ever existed?
Right. But if I could just go back to the point you raised, and obviously it's not necessarily the law, but I do think the Hardy case, the way it looks at it from practical. What's the purpose for this property? Well, the purpose is to do exactly what you put your finger on to begin with, so to go up that hill. If you want to see a grave up there, you should be able to. You shouldn't have to be able to be an Olympic athlete and traverse the logs.
Right.
And so that means to continue in existence as a cemetery, to preserve as a cemetery, not to suffer or cease to fail. I think it ceases to fail if you can't go up the hill. To keep in a particular state of condition, supply what is needed. If you need to remove the log, remove the log. So that's our view, and I would respectfully submit that's a common sense view of the term for maintenance. The HOA, on the other hand, says no, just let it go, leave it in a natural state. That we're just going to let it be, in their words, open quote, an urban forest, close quote, their testimony, which I don't think is what the city of Atlanta had in mind. And frankly, it wasn't what Mr. Smith had in mind, who actually did try to do maintenance, brought goats out there and testified under oath that it was not in a state of disrepair when you had a switch from the original board to the subsequent board. So.
Original board meaning the corporate appointees.
Correct.
Before it became a board of residents.
Correct. Same entity though.
Understood.
Same HOA. And so the plaintiffs though say, but this is outrageous. I mean, some of the language is over the top, extraordinary relief that is being sought here to try to frankly get what we submit is what the city of Atlanta contemplated would be the bargain, right? You get to build your 29 townhomes, but this comes with the meal. You've got to take care of the cemetery was the common sense approach. And we don't think, if you look at it, and this goes to some of the other experts are too, we have the Trees Atlanta and the headstone expert. By the way, Your Honor, not suggested that they have to do what they're saying. We're trying to use that as an illustration, however, that if you wanted to do a sustainable basis for this cemetery, what the likely cost would be over a 5-year period.
Sure.
And it doesn't shock the conscience. So it's not an incredible imposition. And their suggestion that somehow this is, being asked to be forced to do this is onerous. There's plenty of Georgia case law that shoots that down. I would direct your court, and this will be the last case I mentioned, I promise, the Polo Golf and Country Club Homeowners Association case, 310 Georgia 804. And that case, interestingly, Your Honor, did not involve private citizens. Forsyth County was enforcing an ordinance against where they adopted an ordinance that HOAs had the responsibility for management of wastewater and other runoff at all of their developments. And there was a dam at issue, and they had to maintain the dam. Pretty expensive undertaking. And they didn't even own the property around the dam. Unlike this situation, the HOA didn't own the property. And the Supreme Court, and this is in 2021, said it doesn't matter whether you own the property or not. This is under the ordinance, you have to do it. And there, one of the issues was, well, this is extraordinary. You're making us have to expend this money and go through all these things for something we don't even own. That's an involuntary servitude. And the Supreme Court rejected that argument. But I think some of the language is instructive here. And on page at 288, Georgia at 78 of the.
It's a different site. You said it was 310 Georgia. The
Oh, no,
Polo case?
I apologize, Your Honor. You're exactly right. I was citing the case they were citing.
Okay.
I apologize. That was the Gasses versus City of Riverdale case. I misspoke. But it's at that same site. And they say that the prohibition against involuntary servitude does not prevent the state or federal government from compelling their citizens by threat of criminal sanction to perform certain civic duties, including jury service, military service, and road work. Likewise, and this is the real point, this court has held that a municipal ordinance requiring citizens to, open quote, maintain grass, weeds, and vegetation for the welfare of the community is not constitutionally prohibited involuntary servitude. So what we're talking about here, maintenance of weeds, removal of trees, the things that are contemplated, these are not onerous items or things that are novel to the state of Georgia. These are things that are in many ordinances throughout the state and are enforced routinely. So, and this goes to the argument that they're saying that this is imposing unreasonable, penalties upon them. And we just don't think it does.
Perfect timing. It's 11. We're going to take a break. I got to go talk about space usage in the courthouse. And when we come back, I'm guessing it'll be about 30 minutes. Ms. Whitlock, you've been very patient. It's going to be your turn, so I can start to hear the other side of the story, because there's always another side. Okay? Thank you. This.
Just some other.
Did you get enough of a break?
Yes, Judge.
All right.
Thank you.
All right. We are back. I learned more about space opportunities in the courthouse. We are getting 2 new state court judges, and they're gonna dislocate a bunch of folks when they arrive. So we're figuring out where those people go. When we stopped, we had reached the conclusion of Mr. McConnell's presentation on behalf of plaintiffs in support of the plaintiff's partial motion for summary judgment, which I think means either Mr. Whidden, you're going to talk because you represent the defendant's opposition to that. I think that's how you all divided it up. So I'm ready.
All right, may it please the court. I would say good morning, but we're in that kind of weird, almost noon time here.
Still morning.
My name is Thomas Whidden with MGC in Atlanta, and of course, I'm representing the defendant, the Bluffs at Lennox Homeowners Association.
Your Honor, just can we get copies of the slides if you can?
We're trying to email them to him, Judge.
Okay. Are you using anything that's not already been exchanged in discovery? Okay.
No, Your Honor.
All right. We'll work on getting the slides over, but if it's all things that plaintiffs have seen before, just repackaged in a pretty way, then you can keep going.
Okay, excellent. While logically standing might be the right place to start here, we're going to save that for our affirmative motion for summary judgment arguments.
Okay.
And move to the substance of these arguments here. Some maybe table setting that we didn't discuss or that you didn't hear from our opposing counsel that is worth flavoring our discussion here. It is undisputed that the HOA does not own the entire cemetery. Plaintiffs concede this in their complaint in 2 paragraphs. The church has retained some title to the cemetery, whether that's been abandoned by prescriptive easement or some other method. It's not been advanced as an argument. The plaintiffs also did not buy burial lots to the cemetery. Their descendants did not buy burial lots. That is contemplated by statute that handles the sale of cemetery lots, cemetery corporations. Some of the authority that you've seen deals with defendants who are in that space, which the HOA certainly is not.
So let me explore the significance of the 2 things you just said. The first one I was going to ask you about anyway, but the second one is new to me. If I had ancestors buried in the Piney Grove Cemetery, you're saying they didn't buy a lot there. They may have had to pay something to get buried, but it wasn't like a private cemetery where I could give them $50,000 and I've got a little plot where I could have my dad and my mom and someone else buried there.
We, to our knowledge, have not seen any evidence to say one way or the other that anyone paid for a burial lot.
So assume that's the case, that this was a service that the church offered to members of the church and at least 20 to 30 people who weren't members, and you didn't have to pay anything at all for it. So what?
It's distinguishable or noteworthy because there are different duties and obligations that would apply to a landowner like our HOA. So it's worth distinguishing that they are not in that bucket of subject to these rules or public accommodations that might apply to a business, something of that nature.
Okay, but does it go in any way to whether it's a public cemetery or not? Or does it go more to any maintenance obligation your client may have?
It may speak to that, and that's what some of the authority that's out there speaks to, whether if you're a cemetery corporation, you are in the business of maintaining cemeteries. And maybe that's the important point to strike here, that we are not in the business of maintaining a cemetery.
Okay, understood. The first point you made actually came up in some of the pleadings, and I think plaintiff is trying to take away that fact. You don't get to erase a fact, though. The church still has an ownership interest or an easement, or what is it that you contend, when I say you, your client, contends the church still owns or controls or has in connection with the cemetery? Because when I first read about it, I envisioned you're going to show me the diagram, and there's 412 square feet that the church still owns. But I don't think that's what it is. It's that the church, what is it?
Essentially, that is correct. That there's a strip in the cemetery area, from what we understand, that in 2002, when the church began selling off the 3 parcels, they held on to this one, which is in the cemetery area.
And it still owns it.
It has not.
If no one bought it, then they still own it.
It has not been deeded out in any way.
Okay. Is this large enough that you could lie down on it, or is so small you couldn't fit a loaf of bread on it?
It's my understanding that, it's not, half an acre, but it's not, from me to you. It may be, but it is, for what it's worth, a piece of real property that our folks do not own.
Okay. And what is the significance of that, if true, to what we're litigating here?
And this may jump into the standing issue, or maybe to a procedural issue that perhaps not all of the necessary parties are involved. We've briefed that all the necessary plaintiffs are not involved. But maybe this speaks to the fact that in this slide, you'll see there's been at least 4 owners of this property who, just like our folks as plaintiffs contend, didn't maintain the cemetery as they think best. And yet they're not in this courtroom today as party defendants. So maybe that's the larger point, that if a property owner does still have title, and we are being singled out as the only party defendant.
But wouldn't the resolution of that, if true, be that it's almost like if maintenance were as simple as, and it's not, we're mowing, the HOA would mow everywhere except for a 47 square foot area that the church still owns. And then there'd be tall grass there. And ultimately, I'm sure we'd come up with a solution that would say the church says it's okay to mow that area, or the HOA would say, well, we want an extra $10 because we got to pay the guy a little extra to mow that space. I know that's simplifying it, because I've now learned it's not a flat space, it's hilly, it's variegated, but the HOA's obligations exist for the land it owns, and it owns 90+% of it. I don't know, because you're not showing me how big this other piece is, but clearly a majority of it your client owns. And so all the relief the plaintiffs are seeking, if they get any of it, would be as to the land that your client owns.
I think part of the issue is that if there were some kind of obligation that's imposed on the HOA, if the church wanted to do something adverse to that, if they wanted to do something extraordinary compared to that, then there would be 2 standards and
Got it.
a whole another scope of liability for our folks.
Okay. I'm going to add that to my list of, all right, got to hear about that from the other side. Thank you.
Okay. Essentially, what plaintiffs asked the court here to do is to play the role of the city of Atlanta. There is a code of ordinances structure in place in the city of Atlanta for a property owner to petition the city, and exactly in a situation like this, to find some resolution to what an ordinance means, to enforce an ordinance, whether that be in the form of some kind of code violation or what have you. Tellingly, the plaintiffs have not decided to pursue that avenue. They've jumped straight to court. And this,
When you say straight to court, were there not efforts to negotiate before the suit was brought? I thought that was this reference to Ms. Overstreet, whatever the name of the general counsel was.
Ms. O'Connell, yes, sir. You'll recall that happened in September of 2023. Ms. O'Connell sent a letter basically explaining that we are not denying you your access to come out here. We simply want to cooperate so that we don't run into more incidents where the HOA, as the property owner, feels like they have lost control of their property, and that there would be some kind of reciprocation, cooperation, so that on one hand, our plaintiffs here aren't carte blanche being allowed to cut down trees without going to the city, which would expose the HOA to liability. And on the flip side, that the HOA respects that, there is a cemetery here. There's no debate on that. But again, that doesn't mean simply because there's a cemetery that there is carte blanche. Access means whatever we say it means. Maintain means whatever we plaintiffs say it means.
Okay.
And that communication in September was the end, and then
the lawsuit.
January comes around and there's a lawsuit.
Okay.
Another point worth mentioning, we saw the Brockington report in the plaintiff's slideshow. It included what looks like a survey. It's our Exhibit E, Brockington 1. This 2005 survey shows a fallen tree. So to the point of urgency, and then at the same time, the spirit of cooperation, we're talking about a property that, as you see here, since 2006, and beyond that, the church left in 1996. So this is after a decade of sporadic at best cleanups by individuals. Nature is taking its course. I mean, the grass will grow, but as you can see there in the second picture, I mean, there's fallen trees already. So to say that this is some urgent new dilemma ignores the fact. And again, to circle back to the September letter, our folks, the HOA, were interested in exploring ways that plaintiffs could come out, that there would be a level of amicability, communication, open dialogue, and they were met with 3 months of silence and then a lawsuit.
All right. Tell me what facts are in the record that you think create, well, I guess you're moving for summary judgment. So don't you agree that there are facts in the record that create an issue for the trier of fact to decide whether the cemetery is a public cemetery?
And you heard a couple of statements earlier, mainly that no one was ever denied from being allowed to bury their loved ones here. There's no evidence in the record that I've seen to that point. Certainly, it may be that it is that you had to ask permission, which shows a level of control. Case law speaks to giving exclusive control to the public. That is certainly not the case. That has never been the case through the history of the church to now. A private entity has held the land in title and in effect. And you see that in requiring permission to bury. You see that in private sales per profit. You see that in development. So the idea that there was some dedication, that there's 3 prongs to prove dedication, and on all 3, there is no record evidence. There's no record evidence of an intent to dedicate to the public by the church. Certainly they held ceremonies, mass, funerals. That doesn't by itself constitute an intent to give your land to the public. The next step is an acceptance of the land by the public. No one in the public has claimed that they own title to the land. Again, no one has bought a burial plot in the land. At best, these interests are use rights.
But isn't that, when we talk about a public cemetery, and it's much more limited than yours, understanding of the case law is not that that land suddenly becomes public land. In other words, the city of Atlanta suddenly came to own the cemetery for Piney Grove. But that cemetery has become a public space to which members of the public had certain access rights. Not easement rights, but access rights. And so if you were to trace the deeds in Hazelrig or this case, or the case that Judge Downs dealt with long ago, Osby, it wasn't, no one held a ceremony saying we hereby divest our claims in this land and it becomes public land. And there was the mayor with his sash on saying this is Atlanta land. The land stays with the owner, but the use of the land has been such for a long enough time with outward manifestations that the owner couldn't suddenly the next day put up a gate saying you can't come in here and look at your uncle's gravestone anymore because this is private land. And it is private land. It is that person's land. It's Piney Grove's land, it's Hasselrig's land, but it has been put to a use for a long enough time in a conspicuous enough way to a broad enough array of people that the owner loses certain rights of exclusion. And I think that's what we're talking about when we say public cemetery, not anyone loses title to it as in ownership, but you may lose some of the aspects of what title might normally give you.
Sure, and I don't dispute that. But
Okay.
The distinction here is still that the rights specifically with respect to burials that the church exercised demonstrate that it decided who could be buried here. It maintained its ability to enforce its own policies about who could be buried and visit. We haven't heard anything to the effect of what limits they might put on visitation hours, but again, that certainly would be within their right as the owner of property and without an express dedication to the public.
Do you understand the law to be a public cemetery? The owner may not, in the course of the burials, have been able to impose any conditions on that? Or is it more so the owner didn't prohibit members of the public from having burials there? In other words, sort of the difference between a club. You can't, people can come bury whenever they want, but you've got to be a member of my club. And so it's exclusive in that respect, as opposed to, no, any member of the public who asks, we'll let them bury a loved one there. You can't do it at midnight. You got to do it during the day. You can't do it during a church service. You got to do it when we're not having our church service. The latter, putting some constraints on when the burial could occur, I don't read the case law saying that means it wasn't a public cemetery. The former is, I think, much more a hallmark. If the landowner regulated who, not so much the when or where on the land, but who could be buried there, that seems to be more the hallmark of a private cemetery than a public cemetery.
And that's what we've heard in depositions from oral histories of people familiar with this cemetery while the church still owned it. And
that the church regulated who could be buried there?
Right, that you had to approach someone with the church for permission to be buried there.
Okay. Anything from the oral histories of, and sometimes the church said no, or simply you had to ask them so they understood why this car just pulled up, a hearse just pulled up, and there was a casket, and they're not caught unaware. It's like, oh my gosh, there's a dead body on our property.
Right, and we don't, there's no deposition testimony that you'll see where they said that someone was told no. But what we do have are plaintiff's own experts saying, I, Thomas Whitten, as a white person in 1900, most likely would not have been allowed to be buried there, which, to your point, talks to the exclusive control to decide who can use the property and who can be buried there specifically.
Okay. How about the easement rights, count 2? Tell me, well, I guess that's one, and I was pressing your colleague, Ms. Whitlock, on that. It sounds like the defendant's perspective is not easement rights don't exist. It's that Anderson versus Davids, how do we balance the extent of and the exercise of Ms. Collins and Ms. Jackson's easement rights with the ownership rights, not just easement rights, but ownership rights of the homeowners association.
Right, and you spoke earlier with our opposing counsel in terms of a dominant and subservient tenant. The fact that an easement exists, and specifically in the context of a cemetery, does not mean that the dominant tenant makes the rules. The subservient tenant has to follow their direction, which is the position that up until today plaintiffs have taken. They have said that we will get to decide what maintain means, and we will do what we say maintain means. Again, with no involvement with the city of Atlanta to support that position.
So, but let's talk. So, as I understand, and I'm distilling it to my necessary level of simplicity, count 2 basically asks for a declaratory judgment that Ms. Collins and Ms. Jackson have easement rights to the cemetery. And is your response to that no, or you don't get summary judgment on that because they do? I mean, you don't get, put differently, there's no uncertainty around this. Why would you have a declaratory judgment? Because they do have easement rights. There may be a debate about the contours of those rights, but I guess I'm trying to understand what the basis of the opposition to the statement that those 2 women have easement rights to the cemetery is.
Partially, it's that they, in one breath, want a public cemetery and then want private rights in that public cemetery, which is kind of having it one way and the other at the same time.
But let's assume it is a public cemetery. Just let's assume you and I, with no descendants in that cemetery, have certain access rights because it's a public cemetery. Because of other case law, don't people who have descendants there have, it could be duplicative, but an additional source of authority to be on that land through the easement rights that accrue to someone whose ancestors were buried on the land. So it's not, I don't know if it's so much have it both ways as it is, you know what, it may be, Judge, this is now plaintiff talking, we lose on the public cemetery side. And even if we win on the public cemetery side, we want you to make plain that these easement rights exist for these 2 women who are descendants of occupants, if you will, of the cemetery.
Your Honor, can I interject one thing? This is something that Mr. Whitten started to talk to you about when he started. And if you look at, we do disagree that they have easement rights. And one of the reasons is that they never bought a cemetery plot. And if you look at all of those cases about easements, every one of them bought a plot, and no plots were bought here. So it's our position that they have greater use rights because they can go in and clean off their people's graves and that kind of stuff, but that does not necessarily rise to the level of an easement.
Interesting. So this is where, Mr. Whitten, you started out by saying, hey, 2 interesting things. 1, the church still owns some land, and 2, no one bought any burial plots here. And the significance in your mind of the lack of purchasing of a burial plot is that that would mean no easement rights.
Right. What the case law bears out is that plaintiffs have a use right, but again, that's limited. That's part of the issue with what plaintiffs want declared here. They want the carte blanche approach, not the what we had before the lawsuit, which was, we are the landowners. You certainly have a loved one buried here you can visit, but that doesn't mean that you have some easement right that allows you to cut down a tree on the top of the hill.
Well, and set aside what the extent of the easement rights are, because it may be no one gets to cut down a tree, but you still have easement rights. But basically what you're saying, I'm putting a crass spin on it, but if you got some money, you can have an easement right. But if you couldn't afford to pay for a burial plot, but we're still buried there, you might have enhanced access rights if it's a public cemetery. But if it's a private cemetery and you didn't pay for it, they could keep you out.
I think your point at the end there is well taken. And
I'm just curious. I don't know the answer. And you have absorbed more of the case law, but I'm trying to take the position to its logical end, which would be if it's not a public cemetery then, but they let you bury someone there, but you didn't pay for it. If that landowner then decides, oh, we're done now. I'm sorry, your person's buried here. I'm gonna dig them up and give them back to you, but you don't have any easement rights to visit that grave and clean it up. If just, again, not cutting down trees somewhere else, just get weeds off the burial plot because you didn't pay for it.
right. And there's a useful quote here from, I'll direct you to Nicholson v. Daffin, 142, Georgia 729. Stating that a descendant does not acquire any title to the soil, but only an easement or license for the use intended.
But is that someone who paid for the burial? Because that's all we're talking about is the easement. I don't hear plaintiffs arguing that they own the land or have title to the land. That's not what easement is. It's access rights. The Davids did not own the land that they put the lacrosse nets up on. That was the Andersons' land. The Andersons didn't like the lacrosse nets. And they said that interferes with our ability to enjoy that part of our ginormous lawn, even though we can't see the lacrosse nets unless we go way out to the side of our parcel. So you got to take down, in fact, we're taking down your lacrosse nets because it interferes with our enjoyment of our land. And the David said, but we have an easement. It says we can do whatever we want on this little bit. Different case, but you all rely on that case. So what's the situation if you didn't pay for the burial? Yes easement, no easement.
Not to avoid the question, but I think that part of the solution is that there is the ordinance that provides clear access. And again, Patrick, if you can get me the picture here, we kind of talked around what this looks like. This is our access alley. You'll see it was in the zoning plan that was submitted and approved by the city. So it is this path with this rubber that allows you to drive a car down there. And at kind of the end of this greenery is where the cemetery begins.
So I would be driving on what kind of looks like lawn parallel to the fence?
Correct.
Does it ever go down or it stops sort of at the end there and?
It's flat and then the grass stops and cemetery begins.
Okay, so you don't drive further than what looks like flat off into the distance.
Correct.
Get out and then you on foot can descend into the cemetery.
That's right, Your Honor.
Okay.
So again, this is something that exists in the HOA's declaration that it landscapes so that access is maintained to satisfy the ordinance. So again, to your question of if it's private or public, how does my easement exist? The ordinance is somewhat the solution here that the city, seeing a need with new ownership coming in to develop this place, resolve this with this ordinance.
Okay.
And again, we've kind of talked around Anderson and David, and there's also.
No, we didn't talk around. I got to talk about it. It felt good to talk about it. Because they go to the peace. It ended up being a messy trial, and there's the motion for new trial. These people hate each other. They really hate each other, and they're spending so much money on lawyers, and it's so workoutable.
Yeah, lacrosse families.
Mm.
And part of what came out of that holding was that your reasonable enjoyment of the easement. It's a balancing. It's not, like I say, carte blanche for one side or complete blocking for the other, to use the plaintiff's language. The HOA's intention this entire time was to find a solution that avoided going to court. The letter in September didn't have to be the end of that. There could have been more dialogue. There could have been something like the consent interlocutory order that we had as a written agreement between the parties without ever having to see you.
And then we never would have met.
Have that. And we never would have met. Again, reasonableness is the operative word here. To say that, if a limb falls near a grave, that grave has been blocked and we need to get the court involved to decide who can move that, that's not reasonable.
Okay.
What's reasonable is coming to the HOA, communicating, and the HOA also speaking with the plaintiffs about any projects that they may have in mind in the cemetery. But again, reasonableness is the operative word when deciding both the plaintiff's rights and the HOA.
Okay, fair points. I agree with that. What about count 3 then? What Mr. McConnell characterized as the prohibitory injunctive relief. In other words, telling your client to not interfere with the easement rights of the two individual plaintiffs.
Right, and much was made of the no trespassing sign at the front of the neighborhood. But again, the record bears out the plaintiffs met with the former board president of the HOA in either 2016 or 2017. And I believe that's the year. I could be a few years off there. But it was one of their first visits, if not their first visit after the development was finalized. And his name is Mr. Duncan, showed them how to get into this access easement and get down into the cemetery. And he worked with them down in the cemetery. So to say that they've ever been denied access or blocked from 2020 or whenever it was to the current date is not borne out, in fact.
So is your argument that there's not need for injunctive relief of that form, or is your argument they're not entitled to it? Because the injunctive relief, I think, that's being sought is not simply saying, stop keeping us out. Because I don't think there's much, if any, evidence in the record that some armed guard is at the front saying you can't come in. There's a sign that says no trespassing, and that probably is confusing to someone who might for the first time be showing up to say, I'm from Oglethorpe and I want to do some important genealogical research here. Uh-oh, no trespassing. I'm a college kid. I don't want to go to jail. Different issue and very fixable. But there is the claim that access is denied because I can't get to the gravestone at the top of the hill, not being a steeplechase runner. And that, of course, shouldn't ever be a requirement to get to the gravestone at the top of the hill.
Sure. And I believe that gets back to the language of what is in the ordinance itself. The city of Atlanta told a prior developer to maintain. That prior developer had.
Did the city of Atlanta tell everyone who might own that land? I didn't read the text of the ordinance, I'll be clear, but I'd be shocked if it would almost be a bill of attainder if the ordinance said only Mr. Ahmed has to do this, but anyone else who owns it, this ordinance doesn't burden the land. I mean, wouldn't it be anyone who has that land?
It contemplated Mr. Ahmed establishing an HOA himself. That obviously did not happen
Right.
during his ownership of the property. or during any of the other developers' ownership to the property. Mike Smith, Providence JVGL took it upon themselves to write that language into the declaration.
But didn't Mr. Smith testify in his deposition because of the ordinance? That's why we did it? As opposed to, well, there was this ordinance that governed Mr. Ahmed, but out of the goodness of our heart, we're going to put this in the declaration.
That was a bit of a misleading statement that you heard earlier as well. You were told that Mr. Smith said he wrote the language about the ordinance into the declaration because he intended to benefit descendants. You will not find that testimony in his deposition. You will hear him say that it may benefit the HOA to write that language in. It may benefit descendants, but he did not explicitly say that I intended to benefit.
Okay, but setting that aside, my question is, did he say anything in his deposition about why he did? Why did you burden the HOA with this obligation to maintain the cemetery?
Again,
I hope someone asked him that.
I was at the deposition, Your Honor, so I apologize. I might have a little bit better
That's
recollection
okay.
of that. And yes, he did say, I put that in there to be consistent with the zoning ordinance.
Okay, that's all I'm getting at. So it's not an Ahmed only ordinance. Mr. Smith himself, on behalf of the HOA as it existed then, believed that the HOA and the then current owner of the land had to comply with the ordinance. It applied to them. If I bought it tomorrow, it would apply to me.
Yes, sir.
Okay.
And I believe your question before, well, I'll jump here. Part of what that ordinance language specifically says, the city approved, to back up, Ahmed and Capital Partners had applied at first, like you've heard, to exhume bodies. They, for an unknown reason, because they were not deposed and the city of Atlanta wasn't deposed to explain, regardless, he amends his application, but he uses the word or the statement that he as a developer will refurbish the cemetery. The city of Atlanta obviously reads that application and it ends up adopting language maintain. So language like refurbish, which I think we can both agree is distinctly different than maintain, was on the table, but the city of Atlanta chose to say maintain, which refurbish would mean a completely different set of actions. You know, refurbish would be different than leaving an undisturbed natural state. But that is not the language that the city of Atlanta chose. The city of Atlanta said, clear access to the cemetery and the HOA will maintain the cemetery.
If we go back to count 3 and the request for a permanent injunction, so making permanent what is currently temporary, it sounded like in reading your opposition to it, it wasn't opposition to the notion that your client has a duty to maintain. It was more scope and reasonableness. And so I guess my question for you is, do you think that there should not be a permanent injunction? Or yeah, maybe just so that harms are avoided, et cetera, but that permanent injunction ought not to be, to keep it super simple, about refurbishing, because it's about maintaining. Obviously, it would have to be fleshed out more than that.
Part of the issue with a prohibitory permanent injunction for just these plaintiffs is that there is a world of plaintiffs or party plaintiffs who are non-parties here, who could interpret access or maintain differently than what Ms. Collins and Ms. Jackson say it means.
But wouldn't, I don't have to ask you, the permanent injunction, if there were one, would define those terms. It would not be a helpful one if all it basically cut and pasted the language from the declaration and or the ordinance and say, hey, you need to do this. Because your client believes it is doing that. And the plaintiffs think they're not living up to their obligations and they want a permanent injunction saying you got to do what you're obligated to do under the ordinance, under the HOA declaration, and consistent with our easement rights to be able to use and enjoy the cemetery. But because those terms are vague, like maintain, reasonable minds differ.
Exactly. So my answer would be twofold. First, that we do not believe that a permanent injunction is necessary because we've argued all along that we have complied with our obligation to provide clear access and our obligation to maintain. The second is to your point about reasonable minds. We could very likely be in this exact same scenario as the HOA when a new plaintiff comes along who says the relief that they got in the form of that prohibitory injunction, I don't like what Judge McBurney said. I think there needs to be a new order. And that's a very real reality. We're talking about a cemetery with 300 bodies, and we have 2 plaintiffs. And we have their organization that they formed, which up until February was a 2 board member company of the 2 plaintiffs. So there's a world of interest out there that this case doesn't address. And practically, this permanent injunction would be unnecessary, and we think unhelpful, if anything, because of that reality.
So it's a two-sided question I'm about to ask. I grant the permanent injunction, and exactly what you fear comes to pass. Descendant number 3 appears and says, this is insufficient. Ms. Collins and Ms. Jackson didn't ask me to join this lawsuit, and I think maintain means even more than that. McBurney's order is no good. That's expensive because your client needs to get a lawyer, and we have to come back to court. And we'll come back here. There's no mystery where it will go. It's a related case. And so descendant number 3 would be saying, McBurney, your order's terrible. It's always a bad way to start. But we'd work through that. Okay. I deny the relief to the plaintiffs, and descendant number 3 appears and says, well, I'm suing because I'm the guy with the headstone up on the hill. I can't access it at all. It's a different, and sues in this very same way. Friends of Piney Grove 2.0. You still would have to saddle up, and it's expensive to the HOA. There's no prohibition on that. But it seems like both those would be resolvable pretty quickly by way of the law of the case. There's a permanent injunction. This is what you get. Or McBurney got it wrong the first time because the facts and circumstances of Ms. Collins and Ms. Jackson's case, for whatever reason, in this court's eyes, didn't merit that relief. But the gentleman with the headstone up on the hill, that's totally different. I hadn't thought about it that way, and I'm going to give you this relief. I mean, don't we run the risk of being back here whichever way I rule on this?
Part of the issue is that
it's okay to say yes or no right after the question and then explain.
Yes. Part of the issue is that there is the avenue of going to the city of Atlanta to get a definitive answer. We pass this ordinance, maintain means this. This is what we meant. Clear access means this. And that avenue just has not been tread.
It's almost like a failure to exhaust administrative remedies. You came to court too soon.
That could be right, yes.
I don't know, that's right. That's what it feels like.
The other flip side of the prohibitory injunction also is that if plaintiffs are told, if the HOA is told, you have to let the plaintiffs go in and act as they want, there is still that world of possibly 1,000 descendants who the plaintiffs could go in and they may already have disturbed and irreparably damaged or moved a gravesite. And we as the property owners are still on the hook. And I know that's something we talked about back in February of last year, but it is an unavoidable reality of the relief they request.
To me, it's one of the more complicated parts of all this. If relief is granted, how is your client protected from liability, either from, hey, my headstone, my ancestor's headstone got trampled on by these other folks, or I'm just trying to get to this headstone, I trip on a root, and it was negligent of the HOA to not have removed that root or spray painted it orange, and I'm suing. I mean, that can't be the outcome here. That is not a reasonable and fair outcome. And so that's part of working through what does access mean in a way that protects rights, but also affords rights.
Right. And I think that's exactly right. And that is our overarching reason why we do not think a permanent injunction on this point is necessary and should be denied.
Okay. Do you want to talk about count 4?
Of course.
You could say no.
Now he's got a law degree, Judge, you can't say.
Again, there is the Atlanta Code of Ordinances that states how an aggrieved property owner can enforce an ordinance. And that would be to determine what maintain and clear access mean. The plaintiffs have.
What is that? Let's say there's an ordinance in my neighborhood that leaf blowers, gasoline powered leaf blowers, can't be operated before 10 a.m. It's an ordinance, not a law. You're not going to go to jail if you violate it. And my neighbor, 8 a.m. every Saturday morning, it's off and going. No citizen's arrest. I can't do anything there. What is this route that you think that the plaintiff should have done where they could go to City Hall and say, hey, here's this ordinance. Go check out Piney Grove Cemetery. It's not being maintained. Is it 911, 311?
Well, I mean, we have a zoning committee for exactly that reason. That would be who you petition to figure out what they meant when they passed in 2006 their zoning ordinance 0600952. But again, that wasn't relief that plaintiffs sought.
So, but walk me through that. I didn't know that was a possible answer. So I'm not doubting you or pushing back, but you're saying that basically an aggrieved citizen of Atlanta would bring a petition of some sort to the zoning committee or commission saying, you've got this ordinance on the books and either it's not clear or it's not being enforced or whatever. And I want you, zoning commission, to do what? To maybe amend it to say maintain means you can't have weeds on headstones.
Exactly, something to that effect.
And there's a hearing, so I guess they're members of this committee, and there's a hearing. In that scenario, would your client have been given notice so they get to show up as well?
Yes, and I've gone to zoning.
You've done this before.
Back in Augusta in a prior life.
Okay.
It's not exciting, but it is exactly as you described. Members of the community come, neighbors come. Usually there's some kind of posting on the property to notify your neighbors that there's going to be a zoning hearing.
Okay.
And again, this wouldn't be rezoning the property, which some of the case law that has been cited by both sides, it speaks to rezoning.
Well, I've seen those signs you see. There's a big old blue sign and it's got an S on it, a white S, and that we're going to subdivide this property and everyone is given notice. If you want to oppose that, you can go to some obscure place at an inconvenient time and try to oppose it. But this is different. I don't know, unless you're saying someone would have to put a sign at the cemetery saying, I'm challenging a lack of enforcement of the ordinance. But I guess you'd get a lawyer if you didn't know how to do this yourself and get in front of the zoning commission for the city of Atlanta and say, you've got 06, the one we've been talking about, 592, and I don't think it's being complied with by Bluffs at Lenox.
Exactly.
Okay.
And of course, it's a strange scenario. It's not something that you would normally imagine, but that avenue does exist for exactly that reason.
And in this instance, the zoning commission would either, like I said, amend it to say maintain means these 5 things, nothing more, but nothing less. That would be a possible outcome. And then people would know, yep, in fact, Bluffs does need to mow the grass around the area. It's all cleared up.
Right.
Do you go there to get it enforced? If there wasn't a lack of clarity, but there was a lack of compliance, can you do that? Or do you have to sue?
It would be the same process. You can petition to or I guess call in a complaint, a zoning coding violation. And again, that would inform property owner, the HOA, that you are not in compliance. This is what we say compliance is. Do X, Y, and Z to get there. Or
like code enforcement, you might get a little note on your door saying that car that's up on bricks on your front yard, you got to get it out of your front yard.
Absolutely.
And what happens if you don't?
Certainly then, the plaintiffs as interested parties could either, bring an action against the zoning board, which is eye raising, or, at that point, I think that they would have a right to say, we're going to come to court, we petitioned for this relief, you have not acted, how we petitioned.
Okay. Failure to do that, is that a bar to bringing a lawsuit? Or it's just you chose not to take that route, which might be cheaper in terms of paying lawyers. You might be able to navigate that at less expense, and maybe more quickly.
Right. The practical issue here is when you have a mandatory permanent injunction that the HOA must comply with the ordinance, as we, the plaintiffs, say, the better resolution is to say, let's go straight to the source. The zoning committee, tell us what you meant so that we can go forward. Versus, Ms. Collins and Ms. Jackson's, they had different definitions of what they thought maintain meant. The other fact witnesses that the plaintiffs brought.
Oh, meaning in their depositions, when they were describing, here's what to me, maintain means you plant flowers, and to another person, and forget flowers, but I need to be able to get from point A to point B.
It would be beyond, beautifying, it's construction, it's, build me a path so I can get to the top of the hill, even though I might not have a loved one at the top of the hill. I just want a path to get up there. That speaks to why this claim should be denied as well, that you're opening up our HOA to 300 people, 300 descendants.
Well, it's going to be more than 300. If there are 300 people buried there, and some of them were buried 100 years ago.
People's descendants, their meaning of what maintain or clear access might be, if it's different than Ms. Collins and Ms. Jackson's.
Are you aware of any case law that says it's improper for a court to enter an injunction that says follow the law? Because that's sort of what this is. Now, the law, the ordinance, unfortunately for everyone involved, is not clear. What does maintain mean? And that's, like we've all said, why we're here. But it could be simple. It could be the speed limit on my street's 25, and someone keeps going 30. I guess I could try to get an injunction saying, you can't drive 30 here, follow the law, it's got to be 25. But what's the point of that? The law is 25, and a police officer could pull you over if you're going 30. Code enforcement could be brought out to the cemetery to look and then cite the homeowners association. So I'm just, and it may not be case law because typically people don't do this, but one way to package count 4 is, judge, make them follow the law. And we want a permanent injunction, they must follow the law. Well, guess what? We all have that ongoing obligation.
Absolutely. And the issue as well is, what does the law mean? There's not a case out there directly on point with an ordinance directly like this saying, using the language maintain with respect to a cemetery. That's the issue that this claim would not resolve if there was a mandatory injunction, because there is not a case out there that says this is what you as a HOA that bought an old cemetery have to do when the word maintain is thrust upon you.
All right.
And again, to go back to Anderson versus David, again, it's about being reasonable and fair. The most likely or extremely likely result of a mandatory injunction like this is that the HOA is right back and forth with you, with a different person who has a different view of what maintain or clear access means. And we've seen that in the record with several witnesses who already can't agree what maintain means. So the HOA would be in no man's land at the mercy of whoever came to them to basically drain their coffers. Meanwhile, these plaintiffs have raised money for the same reason and thrust the obligation onto the HOA instead.
But isn't there value to your client in particular, but to everyone involved, to define maintain? And that would be an outcome of a permanent injunction. And I'm not too hung up on prohibitory versus mandatory. Everyone agrees there's an obligation to maintain. No one agrees on what maintain means. And so if the outcome of the litigation is you must maintain per your declaration, per the ordinance, and here's what maintain means, and that's spelled out, I hear you that descendant number 3, not part of this lawsuit, may not like that definition, but there's your definition. And it's not a particularly compelling action to get back in front of me to say, I don't like that definition. You know how much work was put into that definition? A whole lot. And it involves stakeholders on both sides, the landowner, descendants, an organization of descendants. I just don't see a new plaintiff getting a lot of traction in the face of that type of resolution, as opposed to, we'll just dismiss all this and see what the next person has to say. So I'm with you that an injunction that says you should follow the law without further defining what we mean by that law or that ordinance or that language in the declaration gets us nowhere. It's the definition that's the key. And it's what you and your side worked very hard with Mr. McConnell and his side in coming up with the terms of that temporary injunction.
Right. And a practical effect that we see if the plaintiffs are allowed to basically unilaterally tell us what our declarations and what the city's ordinance mean is that our declarations are being rewritten by someone who is not a member of our community, who we recognize is part of our lives forever. There's a cemetery there. It's not going anywhere. But, you know, when the declaration is written to give the board certain discretion to leave in an undisturbed natural state, and unintended third party is allowed to go to court and tell us that our rules and policies are now their rules and policies. That is the reason why this claim has to be denied. We have maintained that we have followed our declaration, we have followed our ordinance obligations. And basically to say that 2 out of thousands get to rewrite all of that cuts against fairness. It cuts against the precedent that says ambiguity in zoning language is to be strictly construed in favor of the owner of title, which is the HOA. And that's Board of Commerce of Henry County versus Welch, 253 Georgia 682. That's the practical effect here, is to say, one, the precedent that says if we as the property owners say that this ambiguous language means this, that no, it doesn't, that flies in the face of decisions by this court. And then also to allow a third party to basically blue pencil policies that don't apply to them also is not a fair and reasonable resolution.
Okay, you'd agree it's not quite as extreme as the plaintiffs here are trying to rewrite the rules and regulations around the community pool to which they have no interest, but it's in connection with land with which they have a direct connection.
That gets to part of their different definition of maintaining clear access. Part of what different witnesses have demanded is gate access into the community, which certainly would change our rules and policies. They've asked for lighting, which is, you know, an expense that we would have to bear every night, different than a landscaper who comes at a certain interval. So, I mean, I would say the opposite, that yes, part of the issue again is that maintain means different things to different people. And the HOA would be at the mercy of whatever the next person said that maintain means.
Okay. Thank you. Anything else?
I,
You were handed a few pieces of paper. Don't ignore those.
mhm.
Or ignore them at your own peril. No snacks.
Judge, that's all I have.
Okay. So I think what's next then would be Ms. Whitlock arguing the defendant's motion for summary judgment, which is sort of the flip side of a lot of what we heard, and be sort of more of what we've heard, but I'm happy to do that. We can break for lunch before we start that, or if you want to do a half hours-ish before we break for lunch, I'm good either way.
Makes more sense to me to break at this point.
Okay.
And then I'll go after lunch, followed by Ms. Metcalf. It's my.
Okay, before we break, preview for me a bit what you think we're going to be talking about that we didn't already. Is it mostly standing?
Standing is the big issue. We've also got attorney's fees and punitive damages.
Oh, because there's two other counts. Right. So maybe be clear. On counts 1 through 4, the primary argument you're going to make that would be something we didn't cover already is standing,
Yes.
as opposed to, well, you know, they didn't pay for the burial lots or this or that. I mean, because I want to avoid duplication as much as we can. There's overlap. I get that. But it's primarily standing as to counts 1 through 4, and then a whole set of arguments as to the remaining counts.
Correct.
Okay, got it. The clocks here all say different things. I'm gonna say it's about 12:50. If we come back at 1:30, is that enough time for plaintiffs?
Yes, sir.
Okay, and for defendants?
Yes, sir.
And most importantly, Ms. Richardson?
Yes, sir.
Okay, all right, let's start up at 1:30, please.
Allow you to into the and what they'll have to do is about flash.
Back home. All right, Ms. Richardson, you ready?
Yes, thank you.
All right, let's go back on the record. In Piney Grove versus Bluffs at Lennox homeowners. And when we paused for lunch, we were going to pivot after the break to hearing from Ms. Whitlock about the defendant's motion for summary judgment, which is to all counts, not just counts 1 through 4. And I think I'm ready for that. Let's check one thing. Yes, when you're ready.
Bless you.
Bless you.
So, Judge, thank you for your time today. We know that we have been very time consuming, not just today, but with this case in general. And we appreciate, as I'm sure the plaintiffs do, the time and attention that you have devoted to this case, because you mentioned earlier the issue in this case are very, very, very important to both sides. I'd like to start with, and as we said, I'm kind of getting some feedback, so I'm going to move that back a little bit. As we talked about before the break, I'm going to try not to repeat what we've already done today, because that would be a waste of everybody's time. But there is some overlap that we'll need to plow through. The first thing that I want to talk about with standing is that the plaintiffs don't have standing to get an injunction because there has not been a violation of any recognized legal right. What they've done is they've come in here and said, well, Judge, we'd like to be able to do some things at this cemetery, which they've never been denied the right to do, because you go back to that letter and it says, okay, here's all the things you can do without talking to us about it. But if there's something else that comes in one of these other categories, you need to talk to us about it. They were never denied that. They never asked. So we submit that it is premature to come to you, not just premature, but it is improper to come to you when there hasn't been a violation, even if you concede that they have an easement right, that they have all these things, that hasn't been violated. So we think that they don't have standing to come to you and ask for relief. On the whether it's public or private, we don't think that they have standing to do that, because there's no need to do that. If you go back and read every case that's been cited about whether it's a public or a private cemetery, the question was whether the bodies can be moved or whether that land must be used as a cemetery. The city took care of that for us. The city said it will be maintained as a cemetery. So there's no need for this court to do anything with respect to public or private. It has been decided.
It's been decided that it's a cemetery, but it hasn't been decided, is it a private cemetery or a public, or because the city spoke, that means it's a public cemetery?
I think what the city said is we're not going to say that it's public or private. The only significance of that being whether you can move it or not, because if you look at all those cases, they say because it's a public cemetery, it always has to be a cemetery.
Which is why Ahmed needed it to have been abandoned so he could proceed with the original plan, which was disinterring all the bodies.
Correct.
But when people step back from that, then it really became moot, public or private, because there wasn't a plan to do anything other than, and to your point, the city said, doesn't matter what anyone else might want to do, this is cemetery, and this is what it will stay as.
Correct. And if you go back and read Judge Downs' order, she says, well, this plan to move the bodies has been abandoned, but I'm still going to decide this case because somebody might come after these people. And I just want this decided once and for all with Mount Olive that this is a cemetery.
There was no ordinance in that case?
No.
Okay.
But that's what the city did here, is they said, okay, well, Ahmed has moved on, and I think it was Capital Partners by that point. They're not going to move these bodies, but let's just settle this question once and for all the reasons that the plaintiffs have suggested to you, that with the racial issues and, how important this was to the community and all that, the city just said, we're going to decide this cemetery remains a cemetery. And that is what we believe the zoning ordinance says. That's what it means. It means nothing more. It means nothing less. All of this, you've got to refurbish it. You've got to bring it back to what it looked like in the 1970s, what it looked like in the 1990s.
Have the plaintiffs in this case ever said that? You've got to bring it back to the 1970s? Or is that Mr. Whidden went through a few examples of other descendants saying things like, I want there to be lights in there. And that was sort of a parade of horribles. Understandable, I'm not critiquing that, of, well, look what else this term maintain could transmogrify into if we aren't careful here. Good point. But those aren't the plaintiffs. We're dealing with Ms. Jackson and Ms. Collins and Piney Grove, as in friends of, have any of those three said maintain means return it to how it looked in 1970?
Not using those words, but yes, I did ask both of them that question in their deposition. So, and I'm sorry, I don't have the exactly what they asked for, but it was paths and benches and lights and.
Okay, it was more than what a standard definition of maintain might mean.
Yes.
Okay.
And which is a really important point, Judge, because.
Did it ever have, I'm sorry, I keep interrupting. To your knowledge, did the cemetery ever have benches and lights?
I don't know that it had benches and lights, but if you look at the picture that we've got on the screen now, this is from about 1990. And so that's 27 years before our people come in, because we don't come in until, we weren't formed until 2015, became populated in 2016. So
Is that the church on the hill? Is that the
Yes.
building? Okay.
Yes.
Okay, and you can see some headstones. I don't know if they're lights, can't tell there. But this is how it looked in 1990.
Shortly before the church abandoned it.
Mhm.
Then if you go, let's go to 2006. So this is what it looked like when Brockington, these are Brockington pictures, what it did, what it looked like when Brockington was in there. The reason that that's important is because that's when Capital Partners said, we'll refurbish it. That never happened, but now in 2025, 20 years later, they are suggesting, well, now we, because we had an obligation to maintain it, need to go back and clean all this stuff up and get it back to 1990, which we suggest is not even possible because of time. It's rained, the ground has shifted, all the things that happen over time. So it would be, I don't think it would even be possible to get back to that, but that's essentially what they're asking for, is let's go back to some undefined, and that's one of the problems, is some undefined period of time. At what point do we go back to, you know, at what point do we have to go back to? Because it's certainly, this is 2006. We took over in 2017. There are not, as far as I know, contemporaneous 2016 pictures. So this is the closest we've got.
When you say 2017, really doesn't the obligation start once the declaration is in place? The declaration was set up in 2015.
And you are correct. So 2015
Okay.
is when the declarations were filed. 2016 is when the owners of the homes.
Right, and I know there's a
Right.
gap there, and one of the contentions, I don't know if it's a contention, but the way the plaintiffs have presented it is with Mr. Smith, when it was the corporate HOA, they were all on board, we're gonna do this. And then the owners stepped in and they had to be reminded, you've got this obligation, they ignored that reminder, et cetera. So that's why I was pressing you on 2017, because whatever obligation the HOA had started when the declaration was adopted, not when the owners actually moved in. None of that's changed. It has been incumbent upon the HOA from its creation. It just may have been a corporate entity with no actual owners occupying the buildings, but that would seem to be, if we're going to look at a snapshot of what do things look like, not when the current board got put into place or 2019, but whenever, one could argue 2006 with the ordinance, but certainly at the latest, it would be when the declaration is adopted. Do you agree?
I agree with that.
Okay.
I agree with that. And what Mike Smith said was when he left the property and turned it over to the homeowners, it was still in a wild state. He had sent the goats up there one time, and he thought, the way that he interpreted it was, maybe the homeowners have to send goats up there a couple of times a year. But nobody ever suggested that there would be this giant refurbishing, we'll take out all the trees, we'll take out all the underbrush. Nobody ever suggested that. Until this lawsuit was
If there
filed.
were a magical way for your client to be totally and completely immunized from any liability, does your client object to Friends of Piney Grove doing the work that would constitute refurbishing, using your term? And I don't mean putting up lights and benches, but maybe if we go back to the 1990 look, returning it to that.
No. And we've talked to them about that.
No, there's no
No, we would not
objection.
object.
Okay, if there would be a way to say forevermore, the HOA isn't liable for that window of time while things are being restored to the 1990 look.
Correct.
Okay.
And that's something that our board has talked to, I don't mean to be disrespectful, but the plaintiff sisters, and certainly would be willing to work with them to try to come to that kind of solution.
Okay. That's a data point.
So, I'm sorry, I lost my train of thought, Jeff, but we were
You-
talking
you
about
were-
whether it needed to be public or not, and whether they have the right to demand that it be public, when nobody's trying to move the bodies, and the ordinance says it will always be a cemetery. The second reason I don't think they have standing is the point that you were making with Mr. Whidden about, okay, well, we're going to go in, you're going to issue if you do what the plaintiffs ask, you're going to issue an order that says you comply with the law, and this is what I think the law is, and somebody else is going to go to the city, and the city's going to say, that's not what we meant with the ordinance. And the city, I mean, that's why there's a statute, I've asked Thomas 16 times to give it to me, I think it's 16-30-.001.
Yeah, that was in the, but statutes aren't numbered that way. Is that
It's the ordinance, it's a city
an
ordinance.
Okay.
So I misspoke when I said statute. It's the
Okay.
city ordinance that says when we pass an ordinance, we're the ones that enforce it. And it's exactly the process that he explained to you with code enforcement and all that. And if the plaintiff is not satisfied, the plaintiff sues the city and says, city, you're not doing your job, you're not enforcing it. And then they can come to you and you can say, well, city, I disagree with you about how you're interpreting that. And since I'm wearing the black robe, I get to make that decision. And then we'll go up to more people that wear black robes and they will either agree with me or not.
Lots of black robes. So from your experience, it really would be an aggrieved citizen, maybe with a lawyer in tow, gets in front of the zoning committee for the city to say, I don't think this ordinance is being enforced correctly. maintain, this isn't maintained, look at this, it's terrible, this tree needs to be removed. And the zoning committee, which would be now constituted of people who weren't alive in 2006 when, or certainly weren't on that committee when the ordinance was passed, they do what? They say, you're right, maintain does mean something different, and we are going to direct. I mean, what flows from that?
I think you get a citation.
Okay.
And I do think that I'm not certain, but I do think that they have injunction powers. So just like you said with your car, that car has to get out of the yard.
Yeah.
So
and if you don't, they find this. I know. I mean, I've talked with code enforcement people, and they would get the call. This guy's Camaro is in the front yard with no tires, and there are weeds growing up through the engine block. And so you get the citation. Got to get the Camaro out of your front yard. And if you don't, they fine you for it.
Right.
And you end up having to spend lots of money to deal with that. But that process is initiated by someone calling code enforcement saying, come down my street, you'll see the car, it's in the front yard. And that's a little different than I get in front of the zoning commission to say, what do you think maintain means? Because I think it means something different.
Well, I think it starts exactly where you are. Somebody has to call and say, this is not what you meant.
Got it. Take a look at this cemetery. It's all overgrown. It's not being maintained. And then that code enforcement officer either says, whoa, this is way beyond my pay grade, or she might write something up and stick it on the gate to Bluffs at Lenox saying, right, you got to do this. And if your client thought that's ridiculous, that's not what maintain means, they can sue the city.
Correct.
Okay. But your point is the fulcrum here is the city. Those who want relief, enforce this, please. You go to the city. Those who think that enforcement is onerous or is an overreach, you push back against the city.
Right.
And the city's not here.
And correct. And this is also to Mr. Whidden's point of who gets to decide this. I mean, that's the reason you have government agencies is they decide this is how it's done. You don't get, and ChatGPT says that there must be 78,000 descendants now of people that live in this cemetery. So there really is a genuine concern about, whose rights do we protect and how do we protect all of those rights? And that's why you have a government agency like the city that can do that.
So I don't disagree. I think I asked Mr. Whidden this. I've asked someone this morning. It's now starting to blur. Is that a necessary predicate before you can sue? Or could you not sue for nuisance, trespass, et cetera, the person who's not maintaining? I guess we did talk about it because I haven't seen in any of your pleadings, Judge, you should dismiss this because the plaintiffs failed to exhaust all their administrative remedies. They came here too soon. They didn't go to the zoning commission, lose there, get a formal ruling, because then we get appeals from city agencies all the time. But you're describing a leapfrog. We know the city's there, but we're going to leap right over that and go straight into court to get the judge to say to Bluffs at Lenox, hey, you have to comply with the ordinance, which is really what the code enforcement officer ought to say. C06000592, you got to maintain the cemetery.
I agree with that, Judge. And I would, when you say I don't see in your pleadings that you exhausted administrative remedies, it's not like a Title VII where you got to go through all this. So there wasn't anything that said you must do this and then your next step. That is the way that it goes, but it would never have been a lawsuit against us, which is why we raised it as a standing issue, is they don't have the right to sue us. They can go to the city.
Well, but it's different between saying they don't have a right and they have another remedy. Let's say what was happening was that your landscapers were dumping stuff over the fence and it was going down into the cemetery.
right?
That's certainly not maintaining the cemetery, but it's also a nuisance into what's a maybe public space. I don't know, but why can't an aggrieved plaintiff also sue? They could pursue the route you've described, but they also could I'm gonna go straight to the source. I'm gonna sue the people who aren't maintaining. I'm gonna sue the people who are dumping the lawn clippings down the hill into the cemetery.
Because I think you're talking about two different things. If you're talking about dumping the lawn clippings over, that's a trespass.
Mhm.
And if they have an easement right, they do have a right to bring that action. We'll talk
Okay.
about easement rights in a minute.
Okay.
But that's different than an omission where you're saying, I'm not doing enough to maintain it. That's just a whole different ball of wax. The only thing that gives us the obligation to maintain is the zoning ordinance.
Not the declaration?
The declarations gives us an obligation to each other. That is a contract among the homeowners.
Okay. And someone on the outside, you're saying doesn't have privity to that contract to seek to
Correct.
enforce it. So let's stick with the ordinance. It's not this affirmative trespass of dumping the lawn clippings, but that tree that we see fallen over in one of the pictures on the screen actually fell over across that grass and plastic and rubber route that goes down to the cemetery. And so it is blocking access. And unless you're fit and 17 years old, you're not getting up and over that tree.
Mhm.
I can't sue for that trespass that is preventing my access.
Well, I think then you go back to if you have an easement right, yes, you are being denied your right to the easement.
Okay.
I think and because there is a zoning ordinance, I think the city could come out and say, you got to move that tree, but I do not think they can sue us directly and say, you got to move the tree.
Okay. Can we talk about the easement rights now, just
Sure.
before we leave this? Because it sort of seemed from some of your pleadings that you were acknowledging that Ms. Collins and Ms. Jackson have easement rights that flow from their status as descendants of people buried at the cemetery. That's not what I heard orally today. There was this, I don't want to say new because there's so many pages, I may have missed it, but it was new to me that actually they don't qualify because their ancestors didn't pay for the burial plot. So you don't get that easement right.
So I think, and probably we did not, or not probably, we did not articulate that argument in our brief. I will tell you that. It is in the cases. But I think there's several reasons that they don't have easement rights. One is that they didn't buy the properties, and all of the cases that we could find that said that a descendant had an easement right was where they had purchased it. And you used the example, I can't remember who was arguing, but you used the example, well, if I let you tell you that you can bury somebody on my land, but you don't pay for it, can I later tell you you can't visit Uncle Bob? I think, in fact, you can, and that's what happened here, because the church sold that property, and it reserved a strip of land, but it did not tell the plaintiffs, okay, you can come in, you can still come in and visit your people, even though we don't own the property anymore. I think that's exactly what can happen. That's exactly the danger of not buying the property, is you have a right to use it unless the owner says that you can't, but you do not have a separate easement that you can burden the owner's property with. In this case, it's different because we have the zoning ordinance. So I think that gives everybody the right to go see it, but
It gives them a right of access, but not necessarily the easement, which is an interest in the property.
correct.
Okay.
And these descendants have a greater right because I think that they can go in and clean their people's graves. And if you look at the language of the cases, they talk very specifically about if you have a right, it is to your grave. It is not to the whole cemetery, which is an enormous difference in cases like this, where, you know, do we have to get people all the way up to the hill, or do we only have to get people up to the hill when they sue us? I mean, you know, we get into all those issues, but we think that there's that problem. There's an abandonment problem. they both testified that as children, and I'm sorry, I can't remember which was which, but as children, they went to the church. One of the sisters would play in the playground after church. The other one was too young. But then they both went on and had their adult lives until about 2010. So sometime between 1997 and 2010, nobody is paying attention. Nobody is doing anything to this cemetery. So it's our position that if there was an easement right, it was abandoned when all of this stuff that was going on, or all this stuff was going on, and nobody was doing anything to protect that right. And we noted in our papers, this was not when it was purchased in 2000.
Can you abandon an easement right just because you don't exercise it for, it's not like there was an open and notorious adverse possession of that easement, like a fence going up saying, can't come in here, will be shot, et cetera. In fact, you have argued, no one was keeping anyone off this land. Nature might have, but none of the landowners were intentionally, purposefully seeking to exclude with a gate, with a fence, with a guard. So I'm curious about the abandonment argument. I have a relative who's buried, and I've never been to, other than at the funeral, his grave. He's been dead a long time. I'd be shocked if I was told when I showed up, like, you know what, it's been 10 years, you didn't visit grandpa, you don't get to visit him anymore. I think that would be problematic.
If you bought your gravesite, I agree. But if you buried grandpa in Mr. Smith's backyard and Mr. Smith sold his house and, you know, like here, it's been sold 4 times.
Okay.
Then I think that is a significant difference.
Okay.
And that sort of leads into another defense we have on all of this, Judge, which is latches. So even if you don't get all the way to abandonment of an easement, it is unfair and not equitable to say, okay, in 2025, we're going to make you go back and do something that people could have been doing since 1997. And the testimony is when the church was there, people were, and you saw the pictures, people were keeping up the cemetery. But then when the church left, nobody else took responsibility for it. So to come in 25 years later and say this homeowners association of 29 people now has this enormous obligation to clean it up, fix it up, maintain it the way that whoever is calling the shots says they have to maintain it, we think is not equitable and is barred by that doctrine. On the ingress, egress, I know I'm sort of going out of order, but there was one point I wanted to make on that. When you're talking about going to all the graves, if you look at the notes, which I know you will, but if you look at the notes where they're talking about the zoning ordinance before it was passed, it is very clear that the concern they have is ingress and egress. So getting to the cemetery, as I said when you and I were talking at the very beginning, all of this is being built up, and we've got to make sure that people can still get to the cemetery, which is the way I look at the map of what the church retained. That's exactly what they thought, is if we sell this and, all this, we still want to be able to get back to where these people are. So that was what was being preserved, not you can go to any individual grave unless you want to do that, which is to your point, would we object to that? No, we've never objected to that. Go and don't do it on Saturday morning at 8 o'clock with a saw without telling us.
The strip of land that you're saying the church retained, are you able to kind of point out where it is on that? The plaintiffs had a picture of that survey with the blow up of the cemetery, because you're describing it as probably not a strip of land that had many graves in it. It would be much more, here's sort of the central corridor that we want to preserve so that people can get in, and then sort of up to the rest of the world if you're going to be able to make it to your gravesite.
Yes, and it's actually on the side, but you're right.
On the edge.
Yes.
Okay.
So there are a few graves in it. But it's mostly just space. And you saw that number one where you had all the, where's the? So if I can, I'm just gonna show them right here.
Is it in?
This is yours.
Do you have the same, will you just tell me what page?
This is there, it's tab 11. So it's the same one you were looking at with the yellow.
This has tabs?
I don't know, it says appendix at tab 11.
Well, that's from the,
It's
what we
page
filed. So it's, if you look at, there's a number over on the corner, that's the slide number.
Oh, four.
Page 4, got it.
4.
All right.
So,
Oh, yeah, tab 11. Okay, so yeah, we're looking at this thing that's got all the curvies around the edge. And sort of where is the, oh, down at the bottom?
at the bottom edge next to where these townhomes are.
Okay. Okay.
So that's what people were concerned about is can you get into or get up to this cemetery? But you see from the early pictures from 1990, as you noted, it was very difficult to access. And, you know, there are some of us that look at it and we're not sure that we could climb up if it was that clean. So, you know, that wasn't something that was ever intended or expected from that ordinance. And we don't think that it would be appropriate to enter an order that requires that something like that be done, which would be the mandatory part, and then the prohibitory part. Like I said, that was never, there is no violation which needs to be addressed with that kind of order. Then we talked about this, I think you talked about it with Mr. Whidden, that even assuming that they had an easement, it would not give them the right to deprive the homeowners of the rights that they have with respect to ownership. So that's another reason that we do not think an injunction would be appropriate. And as we've discussed, there's all these other rights of other descendants. And they're experts, which we don't think you should consider, but have talked about, there's no question, if you move that tree, it's probably going to affect somebody else's grave. So it's not something that you can just say, well, I think all the trees should be removed, so let's pull them all out. And we've got in our brief cases that talk about, yeah, when you mess up somebody else's grave, that is a problem. So because an injunction is equitable relief, we think that that would be too far, a bridge too far for the court to go. We talked about the declaration and they don't have the right to enforce that declaration. The testimony was that, well, sure, it would benefit them, but that's not why it was written. It was written for the homeowners, to protect the homeowners, and in case they didn't go down to the zoning office and read the zoning ordinance. He said, I'm going to make it real easy. I'm going to put it right here. You have to maintain it, but in your board's discretion, it is in your board's discretion what you do to maintain it. And if you leave it in its natural and undisturbed state, that is within the board's discretion. But whatever that declaration says, we think that it is not something that is enforceable by these plaintiffs that are in front of you today.
It would be another homeowner suing the HOA or a different homeowner about some impact of maintaining the cemetery.
Right, right. And you've done homeowners association cases. Homeowners have no problem suing their homeowners or each other.
Nope. Keeps you in business.
It does, it does. All right, so if we're finished with those, if the court doesn't have any other questions about those issues, I would like to move to the other issues that they did not have in their motion for summary judgment. So it's the trespass, the quantum merit, and the nuisance. And it's my
I
understanding,
think
but I
quantum merit's gone.
that's what I was going to confirm, is that has been withdrawn.
Yes.
Okay, so we're just talking about nuisance and trespass. So for the reasons that we've already talked about, we don't think they had an easement to trespass against, but trespass is taking some action that hurts somebody else's interest. I was unable to find a case that said that omitting to do something is a trespass. You know, when I explain it to clients, I actually explain it the other way. It's, if you put your toe over the line, that is trespass. But if you don't put your toe over the line, it's not trespass. So we don't think that an omission can constitute a trespass. And we note that there's no evidence anywhere that we ever denied them the right to enter this cemetery to do what they thought appropriate, so long as they also considered the rights of the homeowners. And then the nuisance, Judge, you gave a good example of, tires and grass clippings and these other things. There isn't any of that. Mike Smith said that when he first got there was a lot of trash, which he cleaned out, tires and that kind of thing. Our people have on occasion gone in and cleaned up trash that's been in there. We don't have a lot of that, even though there are a lot of homeless people in the area and a lot of parties and this kind of stuff, in part because of the kinds of signs that they're complaining about. Is we've tried to limit what goes on in there, but there has been some affirmative action, and we listed it at the front of our brief, but we have taken some action. So we do not think that the cemetery, as it sits, constitutes a nuisance. So we would ask that you grant summary judgment on that. The last two claims are the punitive claims, both punitive damages and attorney's fees. And you're well aware of the standard, but the evidence in this case, Judge, is we've got a 29-home homeowners association who's trying to do what they think they should do. You've got evidence in the record of communications that they've had with each other. And, I don't think it means that. This is what I think I have to do. We've talked to a lawyer about it. And they're trying to do right. There's no evidence that they ever came in here and intended to violate the plaintiff's rights, that said you can't come in, that did anything that would warrant punishment by punitive damages. Attorney's fees and expenses, we think the same argument applies. There's no bad faith here. But there is an additional argument. They've changed it now with tort reform. But you may recall that there was the case of Junior versus Graham in 2022, where the Supreme Court said you can get both 13,611 and 91168 fees, even if it's the same money, because one is compensatory and one is punitive. And we have here only a claim for 13,611. There's no 91168. So it will be compensatory. And since they haven't incurred any fees, we don't think that you can award them. So for all those reasons, Judge, we would ask that you grant our motion for summary judgment. And I will sit down and shut up unless you have other questions.
I have a question. When you say they haven't incurred any fees, meaning because this is pro bono representation?
Correct.
And there are no cases before where an appellate court has been confronted with, we're pro bono, but here are our billing records. This is what we would have billed. And so we, the firm, ought to be compensated because that's where the money goes in the end. And it's a 13,611. Assume there's bad faith or stubborn litigiousness. And I'm not assuming that at all, but assume there was in that case. The answer is too bad because it was pro bono. You worked for free. It would be odd to make the defendant pay for free legal services because your client's out of pocket zero.
So there was a decision in front of you that where you found there was no appellate decision.
Oh, then I was right. What did I do?
But you said, this was before the Junior case, and you said exactly what you just said, is, well, that's not fair. Just because the lawyer said that they would do it for free doesn't mean that they ought to be able to get away with that. And that's the distinction I'm making here, is you were looking at 13,611 as a penalty, that the defendant ought not be able to do these things.
Sounds like you would have reversed me.
That
Yeah.
might have reversed you.
Okay.
But we were unable to find a Court of Appeals case or a Supreme Court case that dealt with exactly that issue.
Okay.
Although there was one dissent, and we cited it in our brief. I forget what it was. There was one Supreme Court dissent which talked about the difference between punitive and compensatory.
Okay. Thank you.
Thank you, Judge. Give me a second.
Oh. Thank you.
Wait 1 second. All right, Ms. Metcalf, as I understand it, you are speaking in opposition to defendant's motion for summary judgment.
That is correct.
Anything else?
I will also be responding to some of Mr. Witten's arguments as the rebuttal.
Okay, they all kind of go
They all
together.
go
I think that's
together.
natural. Okay,
We figured it would be easier for one person to do that.
yeah.
All right. And to not repeat things that we've already discussed, the defendant has raised standing as to seemingly every count. It's not clear to me. With regard to count 1, whether this is a public cemetery, I did not hear any argument as to why we don't have standing as to that, but to the extent that they are contesting standing, we have standing under the Declaratory Judgment Act, which gives the court the right to settle or afford relief from uncertainty and insecurity of rights, status, and other legal relations. That's what we're seeking here. I believe earlier you said you didn't need us to discuss why Friends as an artificial person has the right to pursue this litigation, so I won't belabor the court with that.
Well, yes, as a concept, it is not foreign to me that a corporation can sue someone. And I think with count 1, I think I get the
Right.
Declaratory Judgment Act standing as a basis for either Friends of Piney Grove or Ms. Jackson and or Ms. Collins. So that I get. There are a couple other counts where I may ask you to say, well, wait, what's Friends of Piney Grove's basis for pursuing this? And I know they aren't pursuing each of the counts.
That's correct.
And so it may be that we've covered what we need to as to their standing, but it may come back up. But it won't be in my mind because they're a corporation. It will be, well, wait, that's not a descendant. But keep going.
And in this case, it's not just that they're a member of the public. They were personally, the HOA personally directed a letter to them telling them that they were going to restrict their right of access. If you can.
Them meaning Ms. Jackson and Ms. Collins.
To Friends of Piney Grove.
Oh, to Friends of Piney Grove.
And if you just bear with me a minute, because I'm skipping around a little bit to try to make things go faster. If you could pull up tab or slide 16, please. The defendant said that the plaintiffs didn't ask and haven't tried and just went running to court. The opposite is true. Since 2020, the Friends and, well, the predecessors of the Friends, Ms. Jackson, Ms. Collins, have been trying to do something about restoring this cemetery. And after a Memorial Day weekend situation where some goats got loose, Friends of Piney Grove, not Ms. Jackson and Ms. Collins, but the Friends of Piney Grove received this letter. And in this letter, it starts with, please understand, the association does not intend to interfere with a friend's right to use the 20-foot wide access easement depicted on the plat. Notably, the access easement depicted on the plat ends prior to the boundaries of the cemetery. And then it goes on to talk about what the descendants can do. So right there, the right of access has been challenged, and we have standing to bring a claim on behalf of Friends to say, Friends have a right of access, not just to that 20-foot wide easement, but to enter the cemetery. And to enter the cemetery is not an easy task because of the way it's been left. There are large trees. The way they make it sound is there's some underbrush. There are large trees that have fallen.
Why don't you have pictures of this? This is like, if I were a juror, I'd be like, what the heck? You keep talking about the situation, and then I see pictures of, there's one tree in the distance that fell over.
All right, let's talk. Well, right now my slide, I don't have good pictures of the trees, but I do have good pictures of what it looks like. If you can turn to slide 29, please. And this is a picture of a cleanup day organized by the Friends of Piney Grove and Ms. Collins and Ms. Jackson in summer of last year. And so this is after they've been trying to work at cleaning up the cemetery. And this is what it looks like. And can you go to the next slide? And that is what it looks like. If you can see in the corner at the bottom, it looks like there appears to be a tombstone there. That's what you need to do to find tombstones in the cemetery. It is not a matter of just having some overgrowth. It is completely turned into what Ms. Mendoza referred to as an urban forest. It is, the defendant says it is a cemetery and it will remain a cemetery. Well, not without the efforts of the Friends. It had become a forest.
What did it look like, as best you know, in 2006 when any obligation on anyone, and not the HOA because it didn't exist then, was set forth by the city to maintain, not take it back to how it used to be, but the term was maintain. Was it like this then?
Well, there were pictures that we saw earlier from 2006, and it wasn't that.
Well, maybe. Also, I don't know where this is in the property. Maybe this particular space has looked like this for 30 years because it's always hard to get to. But the bulk of the cemetery today and 2006 looks about the same. I'm not quibbling with you. It's just peculiar that the important pushback from the plaintiffs is this has gotten out of control and there's not a before and after. And appreciate you weren't involved in 2006 to know to take pictures and all that. But how do we know that maintaining a 2006 situation looks anything other than what it looks like now?
Well, what we do know is that when the homeowners took over, it didn't look like that. And we know that because we have testimony about it. And we know that because we've got an email from their their property manager that says that. And if you look at, can we pull up slide? Sorry, excuse me, Your Honor. Slide 8, please. So this is Mike Smith, you've heard about already. He was on the developer, he was with the developer and one of the original members of the HOA board. Mike Smith testified, answered, we did not turn it over in a state of disrepair. And is that because you had undertaken certain maintenance duties with the goats? Yes. And it's your expectation they would continue to further those maintenance duties going forward? That's correct. And you told them and advised them to do that they should do that. Yes, we did. So we know from his testimony, which is not controverted, that he turned it over in better shape. And then we also have.
Well, when you say better shape, was this question asked of him after you showed him the picture I just looked at? Well, and he said, whoa, Nellie, that is not what it looked like when we handed it over? Or is
he said it was not in a state of disrepair, but Your Honor, there is another email from 2017, which, since I'm flipping around, let me find it.
And just so you know, I press not because I think this changes my view as to entitlement of relief, but one of the things that I asked Ms. Whitlock about, and she said, no, I want to be real clear. The HOA is not standing in the way of efforts paid for by someone else to get the cemetery, I'm going to say back, as in moving it back to when it was more accessible. And a role I may need to play in this process is deciding how much of this lands in in the HOA's checkbook because they didn't do what they ought to do after Mr. Smith handed things over. And how much of it is you can't let it get any worse. And worse is the wrong word to use because it is how it is right now. But if how it is right now is how it was when the HOA took over, then maintenance, I think it's a stretch of the word to say you need to make it look like it did in 1990 because that's not maintaining what you acquired. But I'm also hearing that the HOA wouldn't stand in the way of the kind of efforts we saw there if the right constraints are put around them. Not 8 a.m. with chainsaws, not violating city ordinances by cutting down trees without a permit, et cetera. So that's why I'm exploring with you. That's not a real happy looking picture in terms of people being able to get to grave sites.
So, well, just going back to what it was at the time, they want to say it's always been like this.
Mhm.
We have contemporaneous evidence that it wasn't. And this email was an email that was provided to us on the last day of discovery. It was from their managing, their property manager who wrote to the board. The email is to the board and it is saying.
So Ms. Kiefer is the property manager.
Property manager, which they have identified as an agent and claimed privilege over communications with Ms. Kiefer. So these are admissions of the party.
Stop. Yes?
We did not claim privilege as to Ms. Kiefer. We claimed privilege as to lawyers, but.
Okay, well, this is on the screen, so I'm hoping no one is saying it's privileged right now.
Right, no.
Because someone's in trouble.
But with regard to team management, which is the property manager.
Okay.
So it starts by, the subject matter is cemetery maintenance, and this is from 2017, so shortly after the HOA took over. Says, once I got the interpretation from the attorney, I forwarded this to the landscaper so he could best scope out what needs to get to the cemetery maintained. I apologize if I overstepped my boundaries on this, but I thought once I got the response from the attorneys, it would be prudent to forward this to Matt so he could get an accurate plan in place. And then it says, in the best fiscal sense for the community, I held off on removing the trees based on AKA, which is their tree removal company's recommendation, and without knowing we needed to maintain the cemetery. But now that we have this, now we know this area needs to be maintained, it is definitely something that needs to be included in the 2018 budget with a plan from the landscaper for monthly maintenance. And then the next paragraph, it says.
Before you get to it, just so the record's clear, there's a sentence in here that says based on what the attorney has sent. So I can understand why the defendant wasn't handing this over to you on day one. This is clearly connected with some legal advice. This itself may not be, but you're right on the edges of things that might well have been properly withheld.
Right, but we got it on the last day of discovery. But in any event, it says in the next paragraph, we just need to allow proper egress and ingress for the cemetery and remove the trees that fell over the last couple of months. As this is not how the community was left after TPG finished the development. So we have contemporaneous evidence that the urban forest that they've allowed the cemetery to become was not how it was turned over. We have Mr. Smith who testified to it. We have Ms. Kiefer's email and no one responded to this and said, no, it was always like this. And we also have other emails where there's talk about, should we take down trees that are about to fall? Oh, well, they took down the ones that were going to fall on the townhomes. They left the ones that were going to fall on the cemetery. They left them to fall. And they did. And not only had they fallen, but there are some that have taken out gravestones and interfered with the ability to get into the cemetery. So we take issue with the idea that they have provided ingress and egress into the cemetery because it is very difficult to get into the cemetery and walk around the cemetery unless you're in hiking boots and you're young and fit. And so then we go to Ms. Whitlock's argument that all we had to do was ask. But if we go back to the slide that I had shown before with the letter that was provided by the HOA's lawyers to Friends of Piney Grove. It's slide 16, please. In addition to pointing out to Friends that their right is only up to the cemetery and not in the cemetery, and then they said they were not going to interfere with the rights of the descendants, not the public, just the descendants, to go into the cemetery to do such things as to maintain the burial plot, which includes such activities as cleaning off the grave marker, removing windblown sticks and debris, weeding the burial plot area, and hand trimming vegetation around the grave marker.
Why is that remarkable to you that access, level of access is limited to descendants?
Because
as opposed to me coming in and saying, I'm going to be picking around this person's gravestone that I don't know, and I'll decide what that's going to look like, even though I'm not his descendant.
Well, my concern there is not so much that it's limited to just descendants, but that it limits the descendants' rights beyond what is allowed under the law. And let's pull up that one.
Meaning, for example, it doesn't let them remove a tree that fell on top of it, because that's not a windblown stick.
They can't, well, and even currently they can't, you're not allowed to use power tools and things like that. They can't remove these trees. And when we're talking trees, we're not talking little trees, we're talking big trees. But here's the slide we're showing you now. This is a picture of one of the descendants who was deposed. And she's there crying because they finally found her grandfather's grave that she had been coming to clean up, looking for it because it disappeared. And look at the size of that grave. They couldn't find it, but they finally found it. And I asked her some questions. I said, had you and the other volunteers simply restricted activities to cleaning off grave markers, would you have been able to find your grandfather? Never. Why not? No, too overgrown. Had you and the other volunteers restricted activities, simply removing the windblown sticks and debris, would you have been able to find your grandfather? No. Why is that? They had vines and all kinds of stuff had overgrown. You couldn't see. You couldn't even hardly walk back there. Had you and the other volunteers been limited to hand trimming vegetation around the grave markers, would you have been able to find your grandfather? No. Why is that? It's all that overgrown. So what the HOA was offering the descendants, not the public, but at least the descendants, is something that was not, which was useless. And that is why we're here.
If it was consistent with the ordinance, then isn't your beef with the city? Let's take this example here on this picture. And I don't think you can show otherwise, in 2006, this particular gravestone was overgrown with vines, et cetera, et cetera. How does maintenance turn into you have to go in there and clear it off when you, they didn't even own it back then, but when the city said, going forward, the owner of this property must maintain, how do we get to more than that? In terms of the obligation of the property owner, not could someone negotiate with the property owner to say, could I do a little more than maintenance if I warranty that you won't get sued for what I'm doing on the land. I make sure you're indemnified, whatever it needs to be. How does the city ordinance that says maintain get you to, no, actually get it to how it might have been when that headstone was put in the ground?
Well, I think everyone at the time in 2006 knew what they were talking about.
And what were they talking about?
If you look at all of the documents, let's pull up slide 24, please. So again, let's put ourselves back in 2006. What Mr. Ahmed was looking to do was first, let's dig up the bodies and move them elsewhere. And you need to establish that this cemetery is abandoned in order to do that. And by the way, this is a good segue in, defendant has said that all the cases involving public cemeteries have to do with moving bodies and abandonment. That is just not the case. Hasselrig, again, an African-American cemetery where the owner of the land, even though it had been used as a cemetery for approximately 50 years, had said no more burials here. And, put up the, rubbish and logs to keep people out and said you couldn't erect a fence to keep cattle from roaming over the cemetery. And the court said, no, that's not right. It had nothing to do with moving the bodies. It had to do with whether or not the public had access to that cemetery. But putting that aside, at the time, that was what Mr. Ahmed was looking to do. And then there was public outrage. And he backed down. And so what did they do? They said, okay, well, we got to do something with this property. We want to develop it. How do we develop it? We got to rezone it, right? So they go to the zoning board and they say, because people are upset about this cemetery, what are they going to do? They're going to refurbish the cemetery on the site, which contains several hundred marked and unmarked graves. That's what they're going to do. Because it had become overgrown and inaccessible, the applicant will create a private alleyway and make it accessible to the public and provide for future maintenance. They're saying, let us rezone. The cost of doing business is let us rezone and we'll take care of this problem that the public is already upset about.
I see that language. What made it into the ordinance?
The ordinance says the word maintenance, but maintenance, Your Honor, we would say includes the words refurbish. If you look at the case
In
that
what
Mr.
world?
McConnell, the case that Mr. McConnell mentioned, and I'll pull up that slide. What is the slide number? Okay, it's slide 22, please. In this case, it's the case is Hardy versus Prather, where the court says, what does maintain mean? And this is another situation where the party wanting to maintain it was moving something, and they're like, okay, well, can you move it as part of maintaining it? And the answer is yes, because what it means to continue in existence. Well, this cemetery is not continuing in existence as an urban forest. It's not, if you allow it to become an urban forest, it does not continue in existence. To preserve, we would say the cemetery has not been preserved. The cemetery has become an urban forest, which is not what you would define as a cemetery. Not to suffer, to cease, or fail. They have allowed this cemetery to cease or fail. And the only reason it hasn't is because of the efforts of Ms. Collins and Ms. Jackson and the Friends of Piney Grove and the many volunteers that have come to try to help solve this problem that the ordinance put on the HOA, not them. And although they have worked tirelessly, there's been over a dozen cleanup activities with volunteers out on weekends working very hard in not particularly pleasant situations. But Your Honor, it is our position.
When you say that, meaning because it's hot or because the HOA people are throwing rocks at them?
I'm not saying the HOA has thrown rocks at them.
Okay.
But it's in, they're working through weeds and overgrowth and
Sure,
it's
snakes,
hard work.
kudzu, poison, but you meant that, not that.
No,
that
I'm not
people are
saying that
picketing
everyone-
outside saying, stop destroying our urban forest.
No.
Okay.
No, I'm not saying that, Your Honor. But anyway, Georgia law defines what to maintain means. But again, going back to there's no evidence that the city thought otherwise of what was in the application. And then also and we've put in the record, what the developers were thinking at the time and what they wanted to do. And they were talking about, we're going to clean and restore. In addition, Mr. Smith, the member of the board, told the board what he thought, and again, this is an admission because he was a member of the board, what he thought the obligations of the board were. And if you turn to slide 36, please. Again, this is only a few months before the email where Ms. Kiefer is like, oh, we have this legal opinion, we have to do this. And by the way, you know, we haven't budgeted for it and it needs to be in our budget. On April 16, 2017, again, in the early days of the HOA board minutes, which we got on the last day of discovery, said Slave Cemetery, 300 people buried there. Mike Smith says the Bluffs of Lenox will clean and maintain the graveyard. Not keep it as an urban forest. We're going to clean it and we're going to maintain it. And they just chose to ignore it.
Was there direction from the city on how to do that?
Mr. Smith got direction from the city. And then again, it says direction from the city, how we should do it, June 2015 AJC article. And so Mr. Smith actually is in an article with the AJC, which is again in our submission, where he says, he went to Sally Silver, who works for the city, and said, help us figure out what we need to do to get this cleaned up. And he did it. And that was to bring in the goats. And they started the cleanup process. Now, the thing is, goats is not a one-time fits all process. You've got to bring them back, you know.
To maintain.
Right, you got to keep bringing them back. But he started it, as he testified, turned it over in good shape. And then no one brought goats back again until the Friends brought goats back again. And then when they did bring goats back again, you know what the answer was? You can't have goats. So
Or you can't let your goats on our property eat our shrubs.
Right. Well, you know, there are a few, these goats are goat yoga goats. I mean, they're tiny little things that crawl on people's back to do yoga. They're not scary billy goats or anything. But in any event, what the contemporaneous evidence, whatever the HOA wants to say now, the contemporaneous evidence is they were told by Mike Smith that 1, he got direction from the city. 2, he had goats out there. 3, the managing agent said, we now have a legal opinion that says you have to maintain the cemetery. And they chose to do nothing. When I asked the HOA's representative about it.
Legal opinion, what's he referring to? Or is he simply saying, hey, there's an ordinance, we need to comply with the ordinance?
I'm referring to Ms. Kiefer's, the property manager's email that we talked about a few minutes ago.
Okay.
When I asked the HOA representative at 30B6, all right, so what did you do with regard to the fact that you have this reference here that Mike Smith says the Bluffs of Lenox will clean and maintain the graveyard? Don't know, nothing. What did you do with regard to this email from Ms. Kiefer that says you have a legal opinion that says you have to do more, you have to budget for it, and you have to take care of maintaining that cemetery? Nothing.
Judge,
We didn't do
I'm
anything.
so sorry to interrupt, but she does not have a legal opinion of anything that we did withhold the lawyer's memos and notes. And so I think that's just unfair to say that there was a legal opinion that said this when that has been withheld on obvious privilege grounds.
Okay, but we do have an email where someone says, we got a legal opinion that says X. So you're relying on the hearsay of, okay, because that's what you got.
Whether it's true or not, they were on notice, right? And I asked, did you talk to the lawyer? No. Did you talk to any lawyer? No. Did you talk to anybody about it? Don't remember doing anything. Why? Because we read the declaration and we found something that says we can keep something in its natural state. And that was what we should do. And all this transcript is all in the papers that we've submitted. So at that point, the answer is they were on notice and did nothing about it.
So let's get back to responding to Ms. Whitlock's arguments and her motion. What's this have to do with standing? What about why you didn't sue the city as opposed to HOA? That kind of thing.
All right, so suing the city, I find, well, first of all, you were correct, Your Honor, that this is not an argument they had made before. They weren't making some failure to meet administrative requirements. The ordinance that they cite, we had mentioned it in a footnote just to talk about generally, there's this right of injunction for failure to adhere to ordinances. The ordinance states, as they quote it in their brief, if a violation of this part exists or is proposed, if a violation of this part exists or is proposed, the Department of Law or any owner of real estate within the district may, in addition to other remedies provided by law, institute injunction, abatement, or any other appropriate action or proceeding to prevent, enjoin, abate, or remove such violation. It's an action. We've instituted an action for an injunction. But then it's interesting that they're blaming us for not doing that when the next sentence they say, but plaintiffs are not an owner of real estate and therefore they cannot rely on this. I mean, this is that they're building a straw person out of this argument that there's some ordinance and that we're supposed to go to the city. But the facts are this: there's an ordinance, which is the law, as you said. It's like, and who interprets the law? The courts. There's no case at all that says that we had to go to the city and institute some sort of zoning proceeding in order to pursue our claim here. And the claim here is allowed by law. And as Mr. McConnell mentioned earlier, there's the AT&T case, which allows that, and the and Massey versus Butts. Can you pull up slide 21, please? So again, Massey versus Butts, Georgia Supreme Court. A party may have a special interest in order to enforce or attack a zoning determination. And these are cases in which they're talking about standing to go to court, not to some zoning board, in order to enforce a zoning ordinance. Same with AT&T Wireless versus.
I don't have Massey versus Butts in front of me, but that language sure sounds like someone is challenging a decision to zone something this way or that way. And if you don't have a special interest in it, the Nature Conservancy can't challenge that zoning determination. And that's not what we're dealing with here, is an ordinance saying, here's how things work in this space, not this is now multifamily dwelling versus industrial. So I don't know about Massey, but let's talk about AT&T.
But AT&T was the situation Mr. McConnell talked about before, where you had a property was rezoned, and the rezoning allowed for a vet clinic to be put next to a residential area. And to protect the complaints of the residents about that, they said, it's just going to be a vet clinic. You can't do anything else. So then the vet clinic did a deal with AT&T to put a cell tower on the property. And the neighbors were rightfully upset, and they tried to do something about that.
And they had a special interest because we're the neighbors.
Exactly. And they then went to court to enforce the ordinance that said nothing other than a vet clinic on that property.
Okay.
That's exactly what we're talking about here.
Who constitutes a substantial interest aggrieved citizen?
And here
And it
that is.
sure looks like Ms. Collins and Ms. Jackson would.
That's exactly.
And then you've got the experts who could help a ultimate fact finder understand why maybe even Friends of Piney Grove would, as an organization of people who are either descendants of or supporters of descendants of people buried there.
And whether that is, I agree with you, but for purposes of this motion, our motion is based on Ms. Collins and Ms. Jackson alone for count 4,
Okay.
which is, and they have the easement interest in the cemetery. Earlier, the defendant said you can't have an easement interest in a cemetery if you didn't buy the plot.
Yeah, that's
That
a big
is
question for me now.
Not the law. There's no case that says that. The cases that refer to the rights of the.
So is your sense that that argument was being made by implication? Because any of the cases that say you have an easement right in this cemetery because your ancestor is buried there just coincidentally involved for pay burials?
I don't know, I don't pretend to know what they're thinking, but if you can pull up slide 17, please. Davis versus Overall, and Walker versus Georgia are both cases where it just says a descendant, not a paying descendant.
Well,
But-
that's what your parenthetical says, but in Davis versus overall.
There's no mention of who paid for the lot. It's talking about family cemeteries. But there's, you could have, but basically the law, when you talk about cemetery law, is there's public cemeteries and there's family cemeteries. There's, so that's just the dichotomy there. But it's not, there's nothing in Davis that says, oh, and by the way, this turns on the fact that they paid for it. I don't even believe payment is mentioned in either of those cases, nor is there anything in the record about who paid for what. For all I know, Ms. Collins and Ms. Jackson's ancestors, because they have 11 of them buried there, somebody may have paid for one of them, but we don't know. It's possible, I could ask them, but this came up today for the first time. So but there's nothing in those cases that hinges upon who paid for it. The easement is not because you bought something. The easement is because
Who's buried there?
Your loved ones are buried there. And there's a public policy in the state of Georgia to respect the dead. And this is all part of, this whole body of law is built around how do we respect the bodies of the dead? And that is just why their easement arises.
So if I lived on the same family land for 150, my family did for 150 years, I now live there, and it turns out my grandfather had let his friend bury his uncle on our land, and unbeknownst to me, that family had been visiting the gravestone, et cetera. Basically, I am acquiring the land through inheritance from my father, with it burdened by an easement that my grandfather's friend has, his family has, because my grandfather let that family bury someone on my land. It's not a public cemetery. No question that this is nobody's cemetery. It's my backyard. But my grandfather, in his infinite wisdom and generosity, let these people bury a loved one there. As you understand, Davis and versus overall, et cetera, I'm not disagreeing with you.
Right.
I've never had to deal with this legal question. The descendants of the gentleman buried in my backyard, within reason, they're not going to come in the middle of the night. But if they said, hey, we'd like to come put flowers at that gravestone, I would say, I always wondered what that stone was. I didn't realize it was a gravestone. They could sue me if I said, no, you can't put flowers on that gravestone.
That is correct.
And I'd lose.
That is correct.
Okay.
No, obviously there's time, place, and manner restrictions.
Understood. I'm not pushing back. I'm learning through these
They can't
questions.
put a whole florist shop.
Right. Plant a new tree or something.
Right. So, but yes, they have that right of superintendents. There was a reference earlier that the right only applies to the plot, and they cite the Nicholas case. That case talks about the plot because that was the subject of the case. So in that case, the owner of the plot wanted to bring in their own personal florist and their own fertilizer and such into a cemetery. And the owner of the cemetery wanted them to use their own gardeners and fertilizer and such. And the case turned on whether they had that right. And the court said, well, they have the right to personal superintendence of that piece of the cemetery. But there is nothing in that decision that says you don't get that you're limited just to that one piece where the body's buried. And in fact, the Arlington Cemetery case says the opposite. And the Arlington Cemetery case, it says that, let me find that, but, all right, well, anyway, the Arlington Cemetery case says, oh, you have it up now, thank you. Lot owners have an interest in the preservation of the cemetery in its entirety. And it's not necessary that all the lands of the cemetery corporation be laid out in lots for lot owners to have an interest in the preservation of the entire lands of the cemetery for cemetery purposes.
That's lot owners.
Right.
Okay.
But it's still like, but again, it goes to the very case they were talking about that they were saying, which was before Arlington Cemetery, the Nicholas case, that concerned a lot owner as well. And they're saying, well, in that case, the court said you have a right of personal superintendence to the lot. But that was the only issue before the court.
Okay.
So they weren't, it's not inconsistent with, again, this later decision that says, oh, you have right to the cemetery and the lot as a whole. And then when we talk about the Hasselrig talks about the cemetery being not just where bodies are buried, but the shrubbery and the paths. And it's as much of a public place as a courthouse or a marketplace.
Mr. McConnell really wants to hand you something.
Apologize, Your Honor.
It's okay.
I just thought for the terms of the extending cemeteries.
Yeah. Yeah, and so and then also with regard to Davis versus overall, which is 301 Georgia Act 4, says Davis and Farmers, as heirs of the person who's established the family cemetery, own an easement to enter, care for, and maintain the burial plots of freedom from damage or disturbance, and to use and enjoy the property. Again, not just the grave, the entire property.
And again, I'll dive deeper into these cases, but the fact that the court said family cemetery isn't taking that case outside the ambit of what we're discussing, because this clearly was not a family cemetery.
Right. It's just that, again, is that factual situation. If you want to look at, okay, so the family cemetery says you have the right to the whole thing. Hasselrig, which is a public cemetery case, says that it's not just the burial ground, it's the whole, the shrubbery, the paths, the whole thing. It's as much of a public space as a marketplace or a courthouse.
And what if we're in the third space? Because if I find this was not a public cemetery, it also wasn't a family cemetery, it's the mystery third type of cemetery. Does that take it outside the reach of any of these cases?
No, I don't believe so, Your Honor. Well, and generally the cases are either family cemetery or public. There's not that sort of middle ground.
Making a law.
Yeah, but generally the courts, these are all concepts that derive again from what I was saying was the Georgia public policy. And it's to, we honor the dead and we do what we can to honor the dead. Even like the abandoned cemetery statute we talked about before. I mean, there's a lot of procedures that one must go through to determine that the cemetery is abandoned in order to move the bodies. There's a lot of due process that has to happen. So to sort of address a question we had about the Osby case, just because Brockington provided essentially what would be an expert report that says the cemetery is abandoned, there was no proceeding that actually established that. In the Osby case, what was happening is the developer was attempting to remove the bodies, and the plaintiffs came through and went to court and said, this is not right. And the court found that despite the fact that the cemetery was in a state of disarray, that it was not abandoned, that there were people that still were interested in it. And it was a court determination that the Mount Olive Cemetery was not abandoned. There's never been a court determination of abandonment in this. So the word abandoned gets thrown around a lot, but the only one who's ever actually established or said anything towards establishing abandonment was the Brockington report, and that was never used because Mr. Ahmed decided not to pursue.
Okay.
So going back to, I believe I'm jumping around just to try to not go over old ground.
So why don't you tell me what the trespass is?
Okay. The trespass is in several ways. So the trespass here, and again, the Davis case is sort of our guide on a lot of these issues. If you turn to tab 42, please. So, and I'm just providing some case sites here. Any unlawful interference with a property right is considered a trespass. And in Davis versus overall, again, another cemetery case, the Court of Appeals found that piling junk around the cemetery or allowing goats and dogs to roam free over the cemetery constituted a trespass.
So in the first of those two alleged or I guess found trespasses,
Mhm.
that's an action taken by Overall or Davis. And I want to keep people out of here. I'm piling junk up.
Mhm.
That's different from a tree falls over. No one pushed it, no one cut it. Nature ran its course. I don't know if that makes it more of a nuisance or it trespass to me says action results in injury. And I'm trying to figure out how we fit what you're contending. And the record seems to support that there was inaction, how that turns into a trespass. It doesn't mean it was okay. It doesn't mean there are not consequences, but there's a motion for summary judgment saying that there's no material issue of fact surrounding the claim that there can't have been a trespass because sort of an admission, but we didn't do anything. Well, that's part of the problem. You didn't do anything, so you weren't maintaining. But assume for a minute that they didn't do anything.
Well, so, we did not move for summary judgment on this count.
No, they did.
Right, exactly. So we're saying we say that their facts, that there is a factual dispute
Which is what?
that did they do things that got in the way or constituted trespass? For example, they allowed trees to fall that they knew were dying, and they allowed them to fall on the cemetery. They also, as we talked about before.
This concept of allowing trees to fall, though, and I mean, that suggests some sort of superhuman, there are trees out there and the trees fell over. I don't
They
know.
knew they were dying. And they took down the ones that were going to fall on their property, on their townhomes. And they let the ones fall that were going to just fall on the cemetery. But then.
So that's in the record, that the HOA had reliable information that there were trees that were going to fall, trees on cemetery ground, and those that looked like they might fall onto it's all HOA property, but in the direction of the homes, those were removed. But the ones that looked like would fall into the cemetery, they let fall.
Well, that's what Ms. Kiefer is talking about in that email that we were looking at before, when she was saying, I didn't want to remove the ones that had fallen, but we also have testimony. I don't know if it's in our tab that we can supplement, if it would help, Your Honor, that they knew that there were trees that needed to come down. They were pricing it. They eventually just took down the trees that were going to hit the townhomes and not the ones in the cemetery.
And so the action they took was the act of not taking down a tree.
Right. But then they also have that no trespassing sign that the HOA's representative on deposition, when I showed her the sign, admitted, I could see how somebody would think that they could be prosecuted by coming to the cemetery. And has that sign been moved since? No, it's still there.
Okay, and that's your interference with.
Right.
Okay.
Right.
Okay, and I don't know, that's the strongest claim ever, but there's an issue of fact for someone to work through at a date later than today.
And then they also, the letter from the lawyer that said basically, friends, you can't, to the descendants, all you can do is sweep off and take sticks away. We contend that was interfering with the right of personal superintendence over the cemetery by the descendants.
Okay.
Then there's also the claim for nuisance, which again, Davis is a nuisance case that says, yes, this interference with rights to burial, it can constitute a nuisance. And a nuisance is basically anything that causes hurt, inconvenience, or damage to another. We cite Seegers versus Cleveland, 255 Georgia App 293. Where in that case, a defendant violated a Gwinnett County ordinance that had a certain amount of feet that had to be between roof lines. And the plaintiff successfully argued that by doing that, they interfered with the property rights, which created a nuisance. And we're saying here that the HOAs, what we contend is their deliberate failure to comply with the zoning ordinance that required maintenance has interfered with the ability to enjoy easement rights by Ms. Collins and Ms. Jackson, because it's made it very difficult to get into the cemetery. And then add on top that no trespassing sign that the HOAs Representative conceded, could cause people to believe that they would be prosecuted for going to the cemetery, which is supposed to be on a public easement.
And what is the Friends of Piney Grove's interest in land here?
The Friends of Piney Grove, again, this claim.
This is just for
The
Ms. Collins
damages
and Ms.
claims
Jackson.
are just Ms. Collins and Ms. Jackson.
Okay.
So if you're doing a scoreboard here, Your Honor, the Friends of Piney Grove is count 1, count 3, and count 6.
Okay,
Count 2, 4, and 5 are just.
okay,
Ms.
and we've been
Collins
talking
Jackson.
about 5, which is the
Right.
trespass nuisance, and
Right.
that's just Ms. Collins and Ms. Jackson. Okay.
They're in for all 6 counts, but those are their solo counts. Just briefly touching on the latches argument that Ms. Whitlock made. Latches here, there's an important element to latches, which is that the claimant's neglect in asserting its rights prejudiced the adverse party. And they can't show any prejudice because, again, what we looked at before, the 2017 board meetings, the 2017 email from the property manager already raised this very same issue. And what did the HOA do? They said, nothing. That was it. They decided, well, we read the declaration. There's something in there about being able to keep the property in its natural state. So that's all we're going to do. Nothing that Ms. Collins or Ms. Jackson could have done and would have changed that, nor do they put forward any evidence of that. They don't put forward any evidence or even raise the issue of what they would have done differently. They don't show prejudice, which is a requirement for the laches defense. And in any event, laches is generally considered not appropriate for summary judgment because it's an issue for the jury. And that a case for that would be Troop versus Loden, 266 Georgia 650. Then with regard to, there was a general reference to abandonment. As Your Honor mentioned at a previous hearing, abandonment's very hard to prove. If you can pull up tab 39, please. And the law is clear that in order to establish an abandonment of an easement interest or any property interest, the evidence must be clear, unequivocal, and decisive. And what their argument is that Ms. Collins and Ms. Jackson didn't visit the cemetery from when they were children until sometime in middle age. As you said, I mean, I love both my parents dearly, but when my mother passed away recently, and when I went to the cemetery, I hadn't seen my dad in 20 years. That doesn't mean I wouldn't be very upset if something happened to the cemetery. There's no proof of abandonment in this situation. They do not even attempt to address this standard. And so therefore, summary judgment is inappropriate. There's no case law that would allow a failure to go to a cemetery for a few years to raise to the level of abandonment. And in fact, there are cases that say, not using your rights for a certain number of years as a matter of law doesn't count. And those are in our briefs. On the attorney's fees and punitive damages, I'll just address those quickly. We believe that the evidence of the failure of the HOA to do anything in the face of the notice from Mike Smith in 2017 that it's their obligation to clean and maintain the graveyard, and failing to do anything when the property manager emailed them and said, I have a legal opinion, we have to do something, we need to put this in the budget. I don't mean to overstep my bounds, but we have to put this in the budget. And then they chose to do nothing. And in those years, they allowed the continued erosion of the cemetery. We believe that those create fact issues that permit us to go to the jury on punitive damages. And again, that is the sort of thing that the Davis case, which comes up a lot, basically says is a case that allows us to go to the jury on punitive damages. That's a jury issue. With regard to attorney's fees, again, we disagree with the assertion that attorney's fees are not allowed for cases for counsel acting pro bono. We also think that there is evidence of bad faith and stubborn litigiousness.
I don't think I can grant summary judgment on attorney's fee. I maybe in this rare scenario on the narrow legal question of pro bono lawyers can't collect them, but I've been reversed enough times on just a mistake, not I meant to do something wrong, but summary judgment's not appropriate on 13-611 claims, full stop.
Exactly.
But this one has this wrinkle of, but if you're not eligible for, if this were a pro se plaintiff, I'd grant summary judgment on that because you can't get attorney's fees as a pro se litigant. It's not. But what does your case law say here?
Georgia Department of Corrections versus
Ouch.
Couch, 295, Georgia 469. It's talking about the purpose of statutes and rules that authorize attorney's fees for litigation abuse, which would be being stubbornly litigious or acting in bad faith. And it said it would be thwarted if a party could escape the sanction whenever opposing counsel's compensation is unaffected by the abuse, as when the fee arrangement is a contingency fee or a flat rate, or if counsel is working pro bono. And this is a Georgia Supreme Court decision. I also want to address for a moment, kind of going back now that we've talked about the damages claims, and whether or not there's some requirement that we go to the city first. In addition to the cases we talked about that give a private party a right to enforce a zoning ordinance that we talked about earlier, there's also OCGA 9-6-23, which provides a private person may by mandamus enforce the performance by a corporation of a public duty as to matters in which he has a special interest. And courts have allowed private parties to seek mandamus against a private company, which the HOA is, for a public duty. And an example of a case for that is Atlantic Coastline Railroad Company versus Donaldsonville Grain and Elevator Company, 184 Georgia 291. And there they allowed a mandamus action by residents and users of a street that's a railroad crossing to compel the railroad company to reopen the crossing and maintain it in good working order at its expense, because it was required by statute to keep the crossings of streets over its railroads in good order at its own expense. And so we say that is analogous to here. We're seeking to as a remedy for the nuisance and the trespass, the torts that were committed here. As a remedy, we're seeking to enjoin them, to force them to do what the public duty that they had taken on with the amended ordinance requires them to do. So that's an independent ground. It's not required for count 4, but it's a remedy for count 5. One other thing I wanted to address, Your Honor. There's discussion that said there's no issue of fact that the HOA doesn't own the whole cemetery. We would say that's actually not true. There is in the complaint.
There is an issue of fact about
They're saying they say we all agree that they don't own, and we don't agree.
Oh.
What they are relying on generally is an expert report that they prepared, and they withdrew the expert before we could depose the expert.
Oh, it was their expert,
Their
not
expert.
yours.
Yeah,
Okay.
well, we've all withdrew our title experts or our survey experts, but they had prepared, and that had we never got to depose them. They withdrawn the expert. So while yes, there was no deeding out by the church for like a very small sliver of the property, there are quitclaim deeds later.
in which the quitclaim deed purports to deed the entire property. The amended ordinance talks about the entire property. When they went to get this rezoning, they were talking in terms of the entire property. It's our position that even if there's a small sliver that is not owned by the HOA, it doesn't matter. And Mr. McConnell cited to you earlier the Polo case versus he cited earlier, in which case, in that case, an HOA was being required to maintain a storm damage system that was not on the HOA's common property. It was on individual property. And they said, we can't do that. It's not on our property. And basically the court said, that's what the ordinance requires. That's what you're going to do.
Okay. I'm assuming for a minute there is this strip that the church didn't sell. Was it a carve out, or did they sell to Mr. Ahmed 95 little parcels because just the way the church acquired its land was different little pieces?
I believe the original part was, and I'm, I can have my colleague come up and address this because he knows everything there is about the title. But if it would please your
That's fine.
Honor, I'd have him come up and.
He has could teach a master's class on that stuff.
I don't want that.
And I don't want him testifying, Judge.
He's not testifying. He's going to come stand here and talk to me. I had a question. I just want the question answered, which is how, from your review of the deeds or titles or whatever happened, how did a little strip get left out? It's just hard to describe land, and it's normally with the meets and bounds, you're transferring, let's pretend it was a big rectangle. Someone would have to go out of their way to carve, and it's in a peculiar location. It's as if the church gave them a donut. If what the defendants are saying is true, and frankly, it's not going to change much of my analysis, but it piqued my curiosity.
Sure, of course, Your Honor. And if you look at on the left-hand side of the overall site plan here, where you have the cemetery and you have the 3 townhomes that are built there on the left-hand side.
Yes.
That general rectangle area, there's a prior survey that had divided that into basically 4 quadrants. The top right quadrant was deeded to the HOA's predecessor entitled to Mr. Ahmed. The area that's outside of the cemetery where the 3 townhomes are built, that was also deeded to Mr. Ahmed, but the church retained an easement to that area. The bottom right quadrant, what I'll say, it's not to scale, obviously, it's much smaller than that. I think it's around a 1/4 acre total. There was not a recorded deed out of the church for that quadrant. However, later in 2013, there was a quitclaim deed from T.I. Canterbury, who was a predecessor in title, to the to JBGL, who was the HOA's predecessor in title. And then when JBGL granted a quitclaim deed to the HOA, and the HOA got title, they got title from JBGL, whose title at least had color of title as of 2013 to that portion of the cemetery. Since 2006, the owner of the cemetery had included that property as within, when they applied for the zoning ordinance, they represented that they used that acreage actually.
So there's a gap. It looks like there's a gap in that the original assignment or transfer or sale of title from church to Ahmed was missing one of the 4 quadrants. But subsequently, everyone was acting as if, no, all 4. And so when it went from Ahmed to whomever and ultimately to the 4 initial and then to the HOA, that quadrant was brought along with it because it's part of the package, but there is some defect in the title there.
Yes, and to be clear to the court, the easement back in 2002, when Mr. Ahmed was obtaining title from the church, it is clear that the easement referred to that sliver as being retained by the church. I will concede that, and that is correct. However, as of 2013, and throughout that entire time period, Mr. Ahmed was at least representing that he owned property, and the when 2013, when TI Canterbury conveyed to JBGL and the Providence Group, and they began working to develop the entire property, going to the city of Atlanta to get building permits and developing site plans and things like that. It shows that they believed that they owned the entire property, including the entire cemetery. When the HOA took title from JBGL, it purported to convey all common areas, which included the entire cemetery.
Okay.
And I think furthermore, which I think is also relevant to this argument now that they don't own the cemetery, which is another thing that we did not have the opportunity to depose their experts about. But they commissioned a survey of the property last year in connection with this.
Who's they?
I'm sorry, the HOA.
Okay.
The HOA commissioned a survey of the property in connection with this litigation. And that survey was done by Prime Engineering, who in fact prepared this plat that you're looking at. And this plat, for reference, is the plat that ultimately made it into the site plan that was adopted in the zoning ordinance at issue in this case. So Prime Engineering has an understanding of this property's boundaries going all the way back to 2006. And that survey that they commissioned does not show anything. It identifies the defendant, the HOA, as the record owner of the property and does not include any carve out that would still be owned by the church.
So Canterbury Ridge Residential Development was the original name for what is now Bluffs at Lenox.
Correct. That it's my understanding that that is what Capital Partners had identified their proposed development to.
Okay.
To date.
All right. Thank you.
Thank you.
Just a couple of other cleanup items. There were some discussions about that the church controlled who was buried there, and you asked some questions. I just want to point your honor to the affidavit of Samuel Sawyer that we filed here. And is Dr. Sawyer still? Oh, he had to leave. Dr. Sawyer was a gentleman.
Was that the gentleman who had the walker?
Yes.
He has good stamina. He stayed for a long time.
Right. So-
Appreciate his endurance.
Exactly. So he provided us with an affidavit that I can hand up to the court.
Is this something that,
It's already in the record.
okay.
Thank you.
Thank you.
One of the questions you asked about the number of churches and whether they had cemeteries. If you look at paragraph 11, he said, when I was growing up, there were at least 5 to 6 Black communities, and their churches included China Grove Baptist Church, Mount Moriah Baptist Church, Roswell Baptist Church, St. Peter's Baptist Church, Mount Olive Methodist Church, which is the one we talked about before, Zion Hill Baptist Church, and many more whose members used the Piney Grove Cemetery as its cemetery. So there were many churches, not very many cemeteries. He says one did not need to be a member of Piney Grove Church to be buried at the cemetery. If you were a member of PGC, you did not have to pay a burial fee. You only paid for digging of the grave. If you were a non-member, you paid the burial fee and a fee for the digging of the grave. And then he says in paragraph 14, anyone who wanted to be buried in PGC could be buried there. All one had to do was ask. There's no evidence in the record, Your Honor, that anyone was turned away. The evidence is replete in the record from the descendants that Piney Grove Baptist Church made the cemetery open to the community. It was, I believe one of the descendants referred to it as the beacon of the community. It was a place for people to be buried who did not have anywhere else to go.
And they paid.
So finally, the concern raised about other descendants coming forward. There's a mechanism if other people were upset. This case has been publicized. It's been going for a while. There's not been a single intervener who's come to court. There's been lots of cleanup activities, put out on Facebook and by the Friends of Piney Grove and Ms. Collins and Ms. Jackson. Lots of volunteers show up, and not a single person has said, we're not happy with how the Friends and Ms. Jackson and Ms. Collins are pursuing this case or what they're looking for.
I hear you,
It's hypothetical.
but it is hypothetical, but it's not a false concern. Let's say the way this plays out is that in the end, there's some payment of a fair amount of money to Friends of Piney Grove. That can create a perverse incentive of someone who really didn't care much to suddenly care a whole lot and say, well, I want to get a piece of that as well. So I don't minimize that concern at all, but I do think there are ways to structure relief that is clear and would withstand challenge and would incorporate realistic requests for access from descendants who haven't become interested and involved yet. So I don't minimize the concern, but I think it is a manageable concern.
Yes, Your Honor.
Okay,
Thank you, Your Honor. Nothing further.
thank you. So it's almost 3:30, and based on our schedule, we still need to talk about fact witnesses and experts. And we can do that. I'm assuming that's going to take less time than summary judgment motions. I do have a few questions that I want to ask either Mr. McConnell or Ms. Metcalf to respond to based on things that I heard from Mr. Whidden and Ms. Whitlock. And so maybe I'll do that first, and then we'll take a break, and then we can hear from Mr. Storr and Mr. Noxheim about fact witnesses, and then have the experts at the end of the day when we have all our energy. So let me ask the questions, and any one of you can answer them from plaintiff's side. Why did you not seek a declaratory judgment action as to what maintain means, as opposed to declare that this is a public cemetery, declare we've got easement rights? I want you to declare that maintain means don't let it turn into an urban forest, because that's a lot of what we're arguing about, but we're one step removed from it. I'm curious. It's not a legal question, it's more a strategy question, but I feel a little constrained, or constrained's the wrong word, that in the end, I might come up with an answer to the issues raised here, and yet we're still one step removed from closure.
Yes, because I think my thinking, Your Honor, was that we wanted a declaration as to a public cemetery as an initial to establish the rights and how that would extend. And then with respect to the specific question on the ordinance, we were seeking not for a determination as to what the word maintain means, because we don't think there has to be done in a vacuum. And once the parties are in litigation, there's many times where it's raised that declaratory relief is improper since you have a claim for an injunction. So we thought I thought I had a claim for an injunction. I thought once I crossed that line that I couldn't.
You were already there, and okay, that they'd interfere with each other. Okay. We covered that strip of land, and easement rights only going to buyers of plots. Okay, I think that's it. Then why don't we take how much time do you want, Ms. Richardson?
Fine with whatever you want.
All right, 30 seconds. No, why don't we take 10? I want a little more than 10 minutes, but I don't want us to run late. So why don't we try to be back on that clock, which is slow, at 3:37 on that clock. So a 10-ish minute break. And when we reconvene, unless you object, Mr. Noxheim, I guess Mr. Noxheim, you'll go first because you're seeking to exclude the fact witnesses. So you'll be up next, be ready, and we'll talk about fact witnesses.
You
All right.
I think there's 3 motions to exclude there before the court. I don't know if you want to be arguing all 3 or.
You're eating into your break. So fact witnesses, exhibits, exhibits. Well, I wrote down, your name is exhibits. Oh, because Mr. McConnell, you're handling experts. I thought I had just written exhibits instead of experts, but you will push back against Ms. Shaka about the experts. And then you're also covering the exhibits and hearsay?
Yes, sir, but I have good news about that. I want to talk to you.
Ooh, have a productive break. Mr. Todd, you may have already said the one thing you're going to say about all these surveys and everything. All that orange tie, all for nothing. All right, let's be back at 3:38 on that clock. All right, home stretch.
Your Honor, before you start, if I can.
You settled?
No, but Ms. Shawkat and Mr. Todd are out trying to work
Great.
something out, so.
Let's let them keep talking.
We can go
And
forward with the next motion.
we will. Mr. Knoxheim. And so I'm clear, you are going to be advocating that a series of fact witnesses, and I've got all their names, we don't need to go through all the names, but these are people who, with one exception, visited and or engaged in cleanup efforts at the cemetery. No? Kind of, sort of?
Many of them are also descendants, if not all of them are descendants.
Okay, they can be both.
Buried within, yes, absolutely.
Okay, all right. Give me one more second. Okay, I'm ready.
Your Honor, I know I appreciate you taking a little bit of a moment today to get us through some of these motions. I know we've been here for quite a while. So the defense is looking to exclude the 6 facts testimonies, as you just discussed, under the basis of OCGA 24.4.402 for irrelevancy, as well as OCGA 24.4.403 for prejudicial. In particular, we've heard a lot of testimony today. We've heard a lot of arguments today with relation to what does maintenance mean? What are the obligations of the HOA? What are the easements rights of the plaintiffs standing? But this testimony doesn't get us anywhere closer to answers for that. Namely, most of this testimony is based on historical context. We'll go through each one individually. But more or less, it's the testimony of each of these fact witnesses is just not relevant to the present dispute. And for the following reasons why. The defense has never denied that the age, history, existence of the cemetery. We've never denied that numerous, almost 300 people have been buried there. That the cemetery and the church have been around for 200 years.
Let me pause you. Not denying something doesn't mean it's irrelevant. And one side doesn't get to stipulate away another side's burden of proof. So talk to me about how it's not relevant. Because if something, I'm just make this up, if one thing that plaintiff would need to show, if this gets to a fact finder at the end of everything, is that more than 200 people were buried there. And you agree more than 200 people were buried there, they could still call Madison Harris to say, actually, I have a certificate. My great-great-grandfather was the 201st person buried there.
Yeah.
And that's relevant, and that will come in, even though you don't contest the fact that 300 people were buried there. So tell me what's not relevant as to maybe cumulative? As I read through this, I thought maybe some of this might be cumulative. You can't bring in, you try to bring in 9 people to say the same thing, but I'm probably after number 2 going to say, we got it. There were 300 people in the cemetery.
No, I think that's the point I was getting towards. It's not that it's irrelevant per se as much as it is redundant. It's if we want to prove, if the plaintiffs need to prove that there's 200 people buried within the cemetery, we have multiple pieces of documentary evidence. We have expert reports. We don't need 6 fact witnesses that said their grandfather was buried there. And though I appreciate the story, I know we all appreciate the story, but it's just not relevant to maybe not the right word, but it's not, maybe it's overkill a little bit to the point they're trying to make. As well as I believe it starts to fall into this realm of prejudicial in that it starts to move the issue that maybe we're litigating away from what some of the topics we discussed today. Talking about, their grandfather being buried at the cemetery does not get us any closer to figuring out what maintenance means. It doesn't get us any closer to discussing the trespass issue. It doesn't get us any closer to what the obligations of the HOA are. The defense thinks that regardless of the testimony within each of these fact witnesses, depositions and transcripts, for the most part, we find that it starts to really can throw more confusion than is necessary in order for us to actually get the answers that both parties are looking for.
If one of the things that the plaintiffs need to show is sort of this vital necessity to be eligible for injunctive relief, then is there not a burden on plaintiffs to show how important access and maintenance is to them? It's not just a hypothetical concept, but it's very real to someone who is a descendant. So my grandfather's buried there. Here's the role my grandfather played in my family's life, maybe mine directly. And we have honored him in different ways, and it's important for us to be able to go to his gravesite and put flowers there. I hear you that in some ways that's prejudicial, as in, gosh, it would paint your client as being a bad guy for trying to keep someone from the gravesite. But of course, that's not what your client's doing, not trying to keep anyone from anywhere. It's just, what does maintenance mean? What does access mean? So you do start to muddy the waters and confuse the issues as to, is the homeowners association trying to keep people away or separate families? But unless there isn't a challenge to the plaintiff's ability and qualifications for injunctive relief, they have to prove up that vital necessity. Maybe not with 7 witnesses, each sharing a similar, a unique but similar story, but 1 or 2, so that a fact finder could say, this is important. This isn't just, I like to walk down the left side of the street and it's overgrown, so now I have to walk down the right side of the street. I don't know that that's a vital necessity. This is my family. These are my people, my forebears. The testimony will be much more compelling than that. But that seems relevant and on point, at least for 1 or 2 witnesses to bring that in. So I'm curious, as long as I make sure we're not getting a situation where there are a lot of tears surrounding it and we get into, well, you don't understand what life was like for my grandfather 100 years ago. That's not what this case is about. This case is about what's happening now in the cemetery. But those are kind of limitations that I can put on it, so you avoid the 403 risk of it becoming unduly prejudicial, that the homeowners association took our land. That's not what this case is about. That may be someone's true feeling, but again, not what the case is about. I'm pretty confident that the plaintiff's lawyers wouldn't intentionally go there, but when you ask someone an open-ended question, they can go in many, many directions. And it seems like guardrails could be put in place short of wholesale exclusion. And so if we're thinking about it that way, then I need you to push me further along to be comfortable saying we're going to exclude at least 1 or 2 people talking about some of these things. Again, I'm all for limiting things when they become cumulative. It's not so much relevance as probative value. Once 3 people have said the light was red, the 4th person saying the light was red, that's a very, very limited probative value. It's still relevant because they're trying to prove that the light was red, but I think it's within my discretion to say we're wasting the jury's time now. 3 people have said the light was red, so call a different witness or move to a different space. But I'm not trying to drive the bus for you. I just, in reading your motion and then seeing what the response was, I was coming down with, I don't know that it is excludable so much as it might need to be kept in a lane that doesn't stray too far into emotionally provocative topics that are adjacent to the reason why there were black cemeteries and white cemeteries, but isn't on point with there are access rights or there aren't, and these access rights have these dimensions or don't have those dimensions. Does that make sense?
I believe so, yeah. I believe
Okay.
so. My initial rebuttal would be, that's what the plaintiffs for here. That's what the plaintiffs here are for here. They have ancestors that live in the cemetery. They've gone through the experiences that they're going to need to make their burden of proof. They'll be able to show that if they had an effect, there was an effect. They can show, they have the ability to testify and put forward additional evidence regarding their experiences. I think we start to move into this cumulative grounds where you're starting to talk about, or you did speak about, when we get to 6 fact witnesses here that are telling very similar stories as the plaintiffs, but are not parties to this case. And then, Your Honor, when you pair that with this, as I started with, this confusion that we can fall into in terms of the details and the topics on which we're really trying to figure out, I think the combination of the cumulative nature, as well as the plaintiffs being able to provide the information that the plaintiff's counsel is going to need to make their case, I think it starts to move into this area where it starts to look a little bit more prejudicial. It starts to look a bit more irrelevant in that their testimony is not going to make a fact of consequence any more probable or not. I think, or at least in the defense's opinion, the plaintiff's testimony will be enough for a jury, yourself, to decide these issues.
Anything else? Did you want to talk more about the 403? Most of your thrust was 402, and I want to make sure you make the record you want to on the 403 side.
Yeah, absolutely.
You don't have to.
No.
I want to make sure you don't sit down and say, wait, stop, 403.
I believe there's a bit of overlap in the arguments I'm making, in that the probative value of adding each additional witness starts to wane. It starts to go down as we hear, again, I think they're very important stories, and I do not want to take away from the fact witnesses' stories. But it does start to lose its effect a little bit over time. And as that loses effect, the risk of prejudice starts to go up. As you know, it's a balancing test. And in this matter, as we hear more and more about these stories of their ancestors going through the atrocities of segregation or the difficulties of the time period, it starts to frame the case in a much different way than what we've spoken about here today. And that would be more or less.
Okay. Thank you, Mr. Knoxheim. Yeah. Appreciate it. Mr. Storr, before you come up, I have to send one quick email. There's someone stuck in jail who hopefully can get out if I send this.
May I approach and get ready, Your Honor?
You do what you need to do. You're not the one going to jail. This person's already there. Okay. Sorry for the pause.
Your Honor.
Ready.
May I proceed, Your Honor?
When you're ready.
Yes, Your Honor. Well, I think Your Honor hit the nail right on the head when Your Honor began by honing in on an issue of vital necessity. Each of these witnesses goes to that point as well as other points which we'll address in turn. Perhaps it's helpful to begin with kind of the law of the case, Your Honor, or the law concerning this issue. The Georgia Court of Appeals has held that pretrial motions to exclude evidence should be granted only if there is no circumstance under which the evidence is likely to be admissible at trial. Our argument, of course, is that this evidence is admissible and will be admissible at trial. And the Court of Appeals has further noted that courts, in that case, of course, Your Honor, was Ford Motor Company versus Hill, 373 Georgia App 480 at 486, quoting the Supreme Court of Georgia in Williams versus Harvey,
Supreme Court of Georgia.
In Williams versus Harvey, 311 Georgia, 439, 452, 2021. And the Court of Appeals has further noted that courts must exercise great care when ruling on pretrial motions to exclude, and that a motion in limine and ruling thereon must be narrowly tailored to the evidence and law applicable to each case. And again, that is Ford Motor Company at 487, quoting Williams at 452.
All right. So what are the purposes for which you would be advancing these 6 witnesses? Vital necessity.
Yes, Your Honor. They go to the injunctive relief being sought in the case. They also go towards punitive damages.
So explain more number 2. They go towards the injunctive relief being sought. What do you mean by that?
Your Honor, in order to, we're seeking, for example, with the declaratory judgment that the cemetery is a public cemetery under Georgia law, and it's dedicated, recognized, and used by the public for a sufficient length of time. Each of these witnesses, well, not each of them, but certain of these witnesses go towards that issue. So the witnesses concern the history of the cemetery. They talk about public access to the use and enjoyment of the cemetery. They discuss the unique features of the cemetery. They discuss the importance of the cemetery.
What's an example of a unique I don't know that that's necessarily something that has to be found for it being a public cemetery, but what's an example
Your Honor,
of the
those would go to counts 3 and counts 4, Your Honor.
Okay.
And I'm jumping around, Your Honor. I apologize.
That's all right. I can't tell you're jumping around. I don't have your document, so you're speaking linearly to me.
Okay, Your Honor. So in terms of the unique features of the cemetery, they will talk about the graves, the layout of the cemetery, going to the cemetery, all the things that make it a historic African-American cemetery, Your Honor.
Okay.
They also talk about the importance of the cemetery to the neighboring African-American communities. They talk about the availability of the cemetery to non-members of Piney Grove Baptist Church. They talk about the importance of the cemetery to African-Americans during segregation. They talk about the harm caused by defendant's failure to maintain the cemetery. Then they talk about the consequences of the restrictions imposed by defendant and how it's preventing the decedents and others from caring for the cemetery, Your Honor.
Now, so assuming, and I understand it's not each of the 6, we'll talk about each of those, but let's say 4 of them could talk about the importance of the cemetery to the Black community.
Yes, sir.
Why 4 as opposed to 1 or 2?
Well, Your Honor, of course. And so necessarily that would be a decision at trial. And if something became cumulative, we might not put up all 4.
But to your point, deal with it then. Don't say now you can only have 2 and tell me which 2. It's the rule of reason, and I promise I'll let you know when you've had enough of that.
It's not in the court's interest for us to waste the court's, for time to be wasted. We certainly don't want to waste the jury's time. Obviously, if we're putting up 4 witnesses in a row, they're all talking about how the cemetery was a public cemetery. Well, at that point, we may want to reconsider.
Okay.
But we're not there yet, Your Honor.
Okay.
And for example, Your Honor, in our papers, which I just brought up an excerpt to hand up, and I'll give a copy to counsel. And again, this is from our response brief on pages 3, 4, and 5. I'm not going to go through and talk about every single instance.
Thank you.
But we put these tables in our response brief to give the court a sense of how each fact witness, who is a descendant, which we do want to stress that for the record, each of these fact witnesses is a descendant. How each of these fact witnesses talks about different parts of the case,
different portions of the case. And we made a helpful table, what we think is helpful, concerning the facts and the topics addressed, and then who addressed them and which portion of their testimony addressed it. So as you can see, Your Honor, it's not the same names for every single one. They're spread out. And normally, the way this would be dealt with, of course, even beforehand, would be perhaps if we had deposition designations, we would argue over what was appropriate, et cetera. But plaintiffs are entitled to put on their case, and we should not be precluded from doing so at this early stage, let alone having the request that the court not consider the testimony of these witnesses in the rulings, the current dispositive motions that are before the court, Your Honor.
Okay. It's a helpful chart. Thank you.
And again, that is in our briefing. But, you know, the issue of prejudice, while relevant to defendants' arguments, there are, of course, different notions of prejudice. In a different case, the Court of Appeals also held that pursuant to OCGA 24441, relevant evidence is, I'm talking about relevance here, but I will get to prejudice, that relevant evidence is evidence that has any tendency to make
Don't read too quickly.
Yes, Your Honor. Any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And that's Piedmont Noonan Hospital, Inc. versus Barber. And that's 333 Georgia Appeals 624-625 at 2015. Now, the reason why Piedmont is so important besides the relevance issue, Your Honor, is the next portion of the opinion and the holding. While the HOA, and this is the quoted language, is the facts are the facts, and to exclude evidence merely because the information would be prejudicial to one side or the other is an extraordinary remedy which the court should invoke sparingly, and the balance should be struck in favor of admissibility. And that's Piedmont at 625. And so while the HOA may not like the facts set forth in the testimony of the 6 fact witnesses, the facts are the facts, Your Honor, and we should not be precluded from relying upon it for the dispositive motions or the responses to the dispositive motions, and it certainly shouldn't be precluded prior to trial, Your Honor.
Okay. Mr. J, anything more?
I think I've covered it all, Your Honor, but if Your Honor has any specific questions.
I don't. I mean, I've asked them already, so I think I'm in a happy space on this one.
Okay, Your Honor.
Okay.
Thank you.
Mr. Knoxheim, was there anything you wanted to say in rebuttal?
Briefly, I can speak briefly, Your Honor.
Okay.
Thank you, Your Honor. The one thing I'd like to say is that in the list of reasons why the plaintiffs would like to include these fact witnesses within, or would like to include these fact witnesses as we move forward, is they named the history of the cemetery, the importance of the cemetery of the neighboring African-American communities, the unique features, the importance of the cemeteries during segregation. And these are the exact sort of issues that I think the defense is worried about would need guardrails or would be a good reason for prejudicial.
I hear you on that. And a couple of the categories that Mr. Storr mentioned caused me to think there's a motion in limine, but I think that's the format I'm going to have us follow. I'll enter an order on this, but in general, in a civil case or a criminal case, it is an exception to say this person can't testify at all. I mean, we'd need to know the only thing this person is testifying to is, say, an alibi. And if adequate notice wasn't given in a criminal case, the remedy can be to exclude the alibi witness. Several of the categories Mr. Storr mentioned are central to the plaintiff's case. Of course, they're free to make, but not through 90 witnesses saying all the same thing. And so what I'm envisioning is that should this be going to trial, bench or jury, there will likely be a motion in limine or two from your side that says, we don't think this topic is relevant at all. That's not exclude a witness, that's exclude a topic. And an example would be potentially the importance of Black cemeteries during segregation. no question that they were important during segregation, but this is a case about the well-being, if you will, of the Black cemetery now. And it may be, and I listen to both sides, that really for a fact finder to truly understand the vital importance and interest of descendants is to understand what these represented at the time, and so what they mean now. That it was a survival mechanism or this or that, or the only way certain people could get closure in their families. I don't know that that's relevant to deciding whether Ms. Jackson and Ms. Collins have easement rights, if that's the question for the fact finder. But I'm very happy playing that regulatory role when we know what's actually going before the fact finder. It might go to damages. The intrinsic value of this cemetery to the community that it served and continues to serve. But that might not be until a jury decided there was liability. And so they don't hear about it until they say, yes, the HOA is liable to Friends of Piney Grove, Ms. Collins and Ms. Jackson for damages. And then it becomes more relevant. So I think that's how this will play out, is instead of saying, you may not call these witnesses at a later point, if we get there, it may be, you may not ask these witnesses about this topic unless a door is open during the trial. And then I might find that it is either relevant or the undue prejudice doesn't substantially outweigh the probative value. It's a pretty high bar you have to clear to exclude something on 403, but the bar is there. It's not up in heaven, and so things can be excluded. And this case involves some flashpoint issues that could be particularly resonant with a diverse jury in our county. And so there may need to be those kinds of guardrails that I think you're pointing to with this motion, but the remedy is later and not now. And the remedy, I think, most definitely won't be, this person can't testify at all. It would be, she can testify, but I need to make sure, Ms. Metcalf, you don't ask this witness about these questions. If you think suddenly they've become more probative, we'll have a sidebar, and then you can go there. And don't talk about it in your opening statement, that kind of thing. I appreciate you teeing this up so that we're all sensitive to some of the legitimate defense concerns about what this case needs to not turn into. Some referendum on were certain people treated well or not well in the past. We know that answer. And this isn't about reparations. It's about making right access and maintenance, whatever those words mean, in this space, this important hallowed space. Okay.
Thank you, Your Honor.
You're welcome. Experts, do you have an update first? Let's start with a happy update.
Okay. We have, I wish Miss Niles was here, so.
She's listening. She has to,
You would know how great Hillary Shawkat is.
that's right. In case anyone's wondering, that's Miss Shawkat.
Anybody, SHAW, I'm just kidding. So we filed a motion to exclude the attachments to the complaint. There's 150 footnotes, but it turns out to only be 53 unique items. We do not have objections to 30-ish of those. In response to that, because we had to file that motion before we ever saw their motions, and so that was sort of, it reminds me of Patrick's motion, the preemptive, like just in case they were going to use these things that we know they're already relying on.
Right, like a newspaper article.
Correct. And in response, they said, I see this, but here's the 78-ish things that we did rely on. So when you sort of shuffle those two lists together, we have 5 things left. And we think we can hit those pretty quickly. Like I think there's 2 newspaper articles, 2 newsletters. No, it's only 4 things, right?
4 things.
2 newspaper articles and 2 newsletters. And so we can do that very quickly.
Okay.
Very quickly, if you'd like.
Well, we'll save that to the end, because if we run out of time, we only have to have a quick hearing to do that. I want to make sure we get to the experts. So, but thank you for both of you for spending some time collaborating on that one, because it sounds like there is very little that remains that's contentious in that area. Okay, experts. That's still you, Ms. Shawkat. You don't sit down.
This is the great one. I love charts and I made a chart. That might be helpful, but we'll see if we can get there. Yes. Judge, the plaintiffs have presented us with 4 really remarkable individuals who are fascinating, who I could have listened to them talk all day.
2 of them are experts that would relate to the cost and requirements of maintaining / refurbishing. We're going to not agree on the verb right now, but they are focused on urbanomics kind of thing. And
Correct.
2 are anthropologists, historians, focused much more on what this cemetery was about and the importance of the cemetery to the community, et cetera. Is that a fair way? You got
It is.
2
I see
people who grow things and cut them down, and 2 who have been very involved in researching and understanding the significance of Black cemeteries, the reason for them, et cetera.
Correct.
Okay.
I think I like to look at it the same way linearly. Dr. Hobson is backwards looking in time. He says, I'm a historian. This is what I'm here to tell you about, how the lived experience, which is just fascinating, up to what it is now. And that's sort of, I think, Dr. Robinson looks at the history. She also collects the data of what is here now. She talks to the living about the dead, which was, I thought, a great way to say that. And she also testified a little bit about what can be done at the cemetery, what additional study can be done. And then we have the other 2.
But in terms of can be done, not, hey, we can lift this tree off
The
without,
study that can be
Okay.
done, yes. And then the other 2, Wetlaufer,
Yes.
okay, and Comiskey, right? I want to see Comiskey Park, but she says Comiskey. They are forward-looking of, I don't know how this got to be the way that it is, and it doesn't matter to me and what I'm going to talk to you about. They're potential vendors, frankly. They give a great pitch. So,
does Trees Atlanta, you can hire Trees Atlanta?
yes. Yes. It's great. So, when
So
we got here,
Wetlaufer is
headstone.
so it's like stonework. Okay,
Yes. I think somebody today called him the headstone guy.
okay.
So when we got here today, one of the very first things that you said was,
Profound.
so I took notes about what are we talking about? And I wrote, we started this hearing with question, and you said this is questions about access and maintenance. We talked about how the city is a resource perhaps for some relief. I made notes all day about open and notorious. It's understood to be a cemetery. This is a hallowed ground, well-known, the size of it. We allegedly allowed trees to fall. And so I have written down all these things that were so very important today. And in my mind, I'm trying to find, okay, how does this expert help us with this? Because the law says, the key phrases, Judge, I know you know the law. Expert testimony is admissible if it concerns matters that are beyond the understanding of the average layperson, properly qualified, et cetera, drawn by the expert that the jury could not ordinarily determine for themselves. So our motion is focused on the fact that while they're wonderful and they have a lot of information, it's not anything the jury needs help with. And I think the most recent thing that you said that I wrote down was, it was right before you were talking about, this is a flashpoint issue for a jury here. These are sort of obvious issues, I think, that we all know that we're facing. The importance of the cemetery, that every individual there is important, deserves respect. Everybody knows that. And to have Dr. Hobson, who's great, Dr. Robinson, who is great, the jury doesn't need them to tell us how important those things are. And that's sort of the thrust of the motion. You did mention today 2 areas of, and here's where I would expect your experts to come in and help us. And I don't think we need that help.
Let me pause you for a sec. I am interested to hear the 2 that I said that you're saying, that's wrong. But unless and until you and your colleagues say, you're right, it's a public cemetery, we think you should grant declaratory judgment that it's a public cemetery. Don't Doctors Hobson and Robinson, in some of their proposed testimony, assist the plaintiffs in demonstrating that? And I'm really coming at it the same way I did with Mr. Knoxheim. There may be things that Dr. Hobson can speak about eloquently and powerfully that the jury doesn't need to hear about because they might stir emotions in a way that isn't relevant to what this case is all about. And should this go to a jury, I'm going to be very mindful of that. Not because the plaintiff is going to intentionally push those buttons, but it's just so natural to, I won't even say veer over there. It is on the main road that we had to have separate ray cemeteries in this town. And so it's not unnatural to say, here's how this was important, because short of this, they had to bury their family member in their own backyard.
Right.
And that's not what folks ought to have to do. And so this church created this opportunity, and it's a public cemetery because X, Y, Z. And they probably can't say it's a public cemetery, legal conclusion, but they can provide evidence that a fact finder could rely upon to say that is a public cemetery. And they seem like well-positioned experts to educate a jury on what, based on their research, was really going on at the Piney Grove Missionary Baptist Church Cemetery. And I think that can be done without some of the very related, but not so inextricably intertwined that they have to talk about it. Here's how bad things were at the time, because that's why they had to have that cemetery. But to your point, people know that, and if they don't, shame on them, and hopefully they get stricken from the jury anyway. But
We'll do our best.
This seems like Mr. Knoxheim dilemma, where dilemma is the wrong word, but it's almost you're putting up a flag now saying, hey, we may have a motion to eliminate, and we're going to be jumping up out of our chairs, maybe to the point of saying mistrial, if these experts start waxing eloquent on certain things that are not intentionally, but just historically inflammatory, that get us away from what does maintenance mean? What does access mean? What is, well, but part of it is what is a public cemetery, or what are the elements that have to be proven? That is a burden these plaintiffs have assumed by bringing this case. And the fact that proving it up gets us kind of close to some awkward topics for the defendant, and it might lump the defendant in the minds of certain jurors, like, why would you oppose this? And you're not opposing it. And that's a difficult project for your legal team, but you knew that when you guys didn't settle this. So that's where we are. So that's where I am.
So I have
You got your chart.
Robinson's opinions.
Yeah.
And why the plaintiffs say she needs to be heard. This is how she can help.
Okay.
And I don't want to read, I mean, we can read them all, but.
You don't need to read them all, but I'm curious why, I'm inquiring of you why the answer to this is not, first, this really isn't a Daubert motion, or is it a Daubert motion?
It is, but only on the final point that it is not helpful.
Okay, okay, so it's not, we don't need to
Probably
work,
filed now as
Okay,
opposed to a motion
got
in
it.
limine.
it's not the classical 702, but it is the 702, but we're not going to need to fight about their qualifications or the science, if you will. These are educational experts, so the methodology really isn't something that gets challenged anyway. But is it helpful?
Correct.
Okay.
And so.
Are you saying it's helpful on nothing? Or gosh, it's helpful on maybe one or two. We want you to keep it out on all the others. Because nothing is a big word.
It is, and I try not to say always and never either. I do not think it is helpful in the way that they rely on it. The testimony from both Robinson and Hobson do not further our understanding of whether it's public or private. And going through the testimony, you can see that Hobson specifically says, I use the word public cemetery as in everybody in the public knew it was a cemetery.
Mm-hmm.
Robinson does not tackle that issue.
But our historian, Dr. Hobson, does he have information to impart to a fact finder about the ability of a non-church member to be buried there? So we already have, I mean, in some ways, he's going to be redundant anyway, because we have Dr. Sawyer. And Dr. Sawyer says, I'm telling you, you guys can impeach him if you want. It's kind of rough. But he's going to say, you didn't have to be a member of the church to be buried there.
Correct. And Miss Collins will say that. And there's another fact witness, I'm sorry, I don't have their name, that says that I don't need Dr. Hobson to tell us that.
Okay. So then it's more cumulative. The probative value is so limited by then because we already have distinguished individuals and be distinguished people. Look, I know, I didn't realize Dr. Sawyer he's an older man. He's got his date of birth here. So he goes way back in the history of the church.
Yes.
And his dad goes even further back in the history of the church. So, I don't mean to make your argument.
Oh, well, no, you're doing a great job. I don't need the gold medal of Dr. Hobson to tell us that non-members were buried there. That's in a document. We can see that, and then we have the plaintiffs will say that and many of the witnesses. So the expert's testimony in that sense doesn't help us understand a fact. A lay witness will understand that non-members were buried there. We don't need him to do that. His testimony was kind of interesting in the sense that, normally we would make an argument that his opinion helps us understand something. His opinions as a historian aren't well suited for that. And I tried to.
It's a tricky one. We get this in gang trials. Yeah, we get with a gang expert, and the gang expert's not offering an opinion. The gang expert is saying, when you see this hand sign and someone's wearing this color, that means that's Tres Locos gang. But they're not ultimately allowed to say, and that guy on trial is Tres Locos. They can just say, in the picture, holding his fingers like this with a green shirt is the guy sitting over there. And then the jurors connect those dots.
So we're kind of in a unique position with Dr. Hobson, who is backwards looking, and that sounds backward, but I just mean into the past. And if the issues are, the maintenance obligation to access and is it public or not, he didn't have any testimony about dedication or acceptance specifically, but those would be facts, not opinions. And so most of what his testimony is a great collection of facts that he's put together. He did give us a list, I believe it's Exhibit 14 to his deposition, that has 3 topics about which he is expected to testify, and it served as a unique and historically significant. And he uses the word public cemetery, but then says, not in the legal sense, I'm not touching that. That's for you guys to quibble about. Then longstanding history of the cemetery, the importance of the cemetery, and then more specifically about the identities and the history of the individuals there. That was in his written opinions. In his testimony, he more or less provided those as well, but then he added in his great perspective on what he calls the Atlanta way. Did you read that? He has a great description of the Atlanta way is you progress at all costs, which he has a tremendous problem with, and I do too. But that also, that is an opinion that doesn't help us figure out anything in this case. It is adjacent to what we're talking about because progress did move these communities out, but it does not help us understand the HOA's obligations here or if this is public or private. And so that opinion was a significant, he has lots of other opinions. He also submitted an affidavit after all of the filings that I don't think is particularly important or helpful to what we have to decide. But so his testimony in our motion, we say a lot of this is just, he's reporting facts to us, and it's he does it in a great way. It just doesn't help us understand what a layperson, he's a great storyteller. We get the story. Do I think everybody ought to hear it in their lives? Yeah, especially if we live here. So that's sort of briefly about Dr. Hobson, and sprinkled throughout his testimony, he says things like, you know, we've said, are you going to come and testify that the HOA has done anything wrong or has done anything that caused the cemetery to not be preserved? No. And he says, I'm just here to talk about the history. And that is more of
And talking about the history, is it your understanding that the opinion he would give in the end is that, in his opinion, the cemetery is of powerful cultural significance, value to the community that it served and continues to serve?
Yes.
Which goes back to your original point of who doesn't think that?
Right.
Okay.
Right.
Or why do we need an expert to provide that opinion?
Yes.
Okay.
And I think that was something that you commented on, was that we all understand how important all cemeteries are. Like that's something that is just within the general knowledge of people.
I don't know that the plaintiffs would necessarily agree that everyone understands that, but if we're talking about with jurors and working through the significance of where your ancestors are buried, that I don't know, we need an expert to say that's an important place to lots of people.
Correct. And then the real issue, I think, is, so how do we show that? And he doesn't provide that. He did have some reliance materials that I thought were really good about how different historically black cemeteries are laid out. And Dr. Robinson has the same, what types of plants are there, what types of stones are used, biodegradable materials were used. But he didn't offer an opinion about those things. He says he relied on these things, but and sort of moving into the arborist and the headstone guy, Dr. Hobson didn't provide us with an opinion or any help with, historically, this is how this cemetery has been handled. Let me give you my opinion on this is what it should look like going forward. We don't have that from him. And Dr. Robinson sort of occupies this space between the two, the historical perspective of that, and then what can we do, what maybe should we do a little bit. She didn't, in my recollection, didn't get too much into that, other than to say this is important, and her testimony as well as to why this is important to counts 1, 3, and 4. And the plaintiffs will tell you this is why we need the experts to help us understand counts 1, 3, and 4. She testified that we need to go out there and do some more testing. And so if this maintenance is
Testing means what?
ground penetrating radar.
Oh, to see, are there other burial plots?
Correct.
And thus there ought to be other headstones.
Correct.
Can't tell because it's an urban forest right there. I mean,
Correct.
I can't see the headstone. We know using the technology, here are 8 more
Right.
burial plots, but you wouldn't know that absent this fancy technology. So let's see what we ought to do to refurbish.
Maybe. And she, with great zeal for her profession and what can we do? It's good. But again, our argument is that, of course, that is not anything a lay person doesn't understand. And so again, for her, she has wonderful things that she brings to the table. It's just not the expert level, and calling them an expert kind of heightens the importance of what they're saying. And so sort of moving then to Ms. Kumisky, who has the greatest job, I think, in the world. Again, she presents a plan of what we can do. And I believe Mr. McConnell said, these are just examples, which that's not an expert opinion. This is, like I said, this is a vendor who says, hey, we can do this. And she's wonderful because she also says, hey, let's bring all stakeholders to the table. Everybody needs to have a say in this. All the communities, do they need a privacy screen, and these things. But again, this isn't an expert arborist opinion about the maintenance that's really focused. These are things that you could do to this cemetery. And we've argued all day about, we run the risk, like if I do this thing to your grave site, this person gets upset because it wasn't done to theirs, or, so she doesn't help us navigate the really sticky points of that. Mr. Wetlaufer says, hey, I fix headstones. I got some great techniques to do that, and here's how much it costs. That's not an expert that also did. It's an example when we get to damages.
Right.
If we get to damages of how much that would be, but that's, again, that's not really an expert opinion. That might be an example of something that could be done.
Why wouldn't it be, assuming we get to damages, which is where it seems like Wetlaufer would best fit in, and plaintiff is trying to establish how much would it cost to, if somehow the fact finder has said maintain means refurbish, then what would it cost to put together some of these headstones that have cracked or faded? Faded is the wrong word, but they kind of get weathered down, and there's sometimes a way you can use techniques to get the letters a little more visible again. That's not free, and if it's going to happen, but it's not necessarily happening at the HOA's expense, it's happening, the HOA needs to maintain it, but the plaintiffs are free to bring in vendors to do it, or I'm not quite sure why it's damages to the plaintiffs if the end order is, defendants, you have to do this. It's going to cost what it costs, and you might want to hire a Wetlaufer, but it's not a plaintiff issue.
Right. Because those again are just facts. Here's a receipt. This is how much this would cost for this guy to do it. He is uniquely situated, I think, because his position is rare, but everything that you said about how the water breaks down the marble and it erodes or degrades the headstone, lay people in a jury understand that as well.
I don't know if they do. I don't think we have to sort that part out, but I know that Mr. McConnell will fill me in on how the cost of repairing a headstone fits in pre-damages, because I'm not seeing it right now.
And sort of to jump to that, both of those two witnesses, Kumisky and Wetlaufer, said, I don't know how we got here. I don't know when this tree came down. I don't know where that headstone, when it broke, how it broke.
Whether it was 1927, or, I mean, maybe that's extreme, but it could have been 1985. It could have been 2016. 85 is on the church's watch. 2007 is in between. It's not the church and it's not the HOA.
Correct.
And they don't have
the developer, and they have nothing to add to those issues. So if we want, he can come up, maybe I can
Yes,
fill in at
why
the
don't you
end.
sit and please, and I'll hear from Mr. McConnell, and then I'll let you pop back up at the end.
I have a slide, but it's just 702. So if you wanted to look at it, but I don't think we're going to need to in light of counselors'
Especially since they've said,
remarks.
look, to be clear, we're only challenging that last element of the test, which I think is smart. I mean, these are clearly extremely qualified people, and you're bringing them in to talk about the things about which they know. So we're not having a foot doctor talk about brain surgery. I'm interested in knowing what opinions, not meaning what their answer is, but about what you want our historian and anthropologist to opine. And then I'm going to ask you some follow-up questions about that. And then the same for our two restoration people.
Right. Well, and the opinions that, starting with Dr. Robinson, her opinions were set forth in her affidavit that we submitted in support. And there's essentially 11 opinions. These opinions primarily concern the requirements and elements for the establishment of a public cemetery. So it is what we attempted to do was go through and look at, because this is the presentation of historical evidence, right? This is not a situation, well, what was going on 100 years ago? How do you stay there that this cemetery was in effect in existence at this time? They say that they stipulate to these, but they didn't stipulate to these they denied almost everything that we alleged in the complaint. So we had to go ahead and establish all of the factors, and that includes the attributes of the cemetery itself. Like, how do you know how many people were buried there? Who was buried there? Who were their descendants? How can you show these things? Well, that was done.
I'm looking for Dr. Robinson's affidavit. I've got one here, and it doesn't list 11 opinions. It talks about racial separation and segregation and Jim Crow, and that's not what she's going to be testifying
That
about.
may be the rebuttal. She has two.
She has two.
Dr. Hobson and Dr. Robinson both submitted affidavits in support of the responsive brief. Although we haven't addressed the issue today. One of the arguments that was raised in the response, in the initial motion for summary judgment filed by defendants, essentially stated that because white people cannot be buried at the cemetery, it was not a public cemetery. They relied upon certain testimony of Dr. Robinson. We respectfully submitted was taken out of context. Her affidavit that you pulled up just there addresses that narrow issue. And the one filed by Dr. Hobson does similarly.
So
can we find?
Well, I can find it with what would it have been attached?
It would have been
yours.
It was submitted with the motion for
Got it. Okay, I've got it now. Okay, so this is a bigger file. This is a 531-page affidavit.
The attachments are what are.
So would it be her summary of, okay, it's the A through K.
Yes, Your Honor. And so we, exactly. And so the opinions, the summary of the conclusions, if you wanted to see to kind of the shorthand version, is at page 7, starting with paragraph 29.
I'm there.
Got it. And so that is the primary focus of her testimony. And why is that relevant? It's relevant for two.
I see why it's relevant. I'm just trying to think through, so the expert piece and the cumulative piece. We've got Dr. Sawyer, who, if he testifies consistent with his affidavit, is going to be establishing, not with the level of detail, 324 anomalies consistent with grave shafts. I'm not going to be talking like that, but he'll be saying, let me tell you how it worked. And you didn't have to be a member of the church to be buried there.
And that is correct. But this is also from an expert testimony is based upon, as all experts can be based upon oral histories and explain that to the jury in a way that is not simply coming from one witness, but is from a survey and looking across. I think that goes to the quality and the depth of what is being stated. But this isn't a single witness. We have evidence that it's multiple.
Sure. If the question of whether this is a public cemetery is not before the final fact finder. What do you call Dr. Robinson for at trial?
Well, Dr. Robinson, I still think as to certain of the claims, I do think that the significance and importance of the cemetery is important for this court today for this motion for two reasons. The public cemetery component, and then I'll get to the jury, and I'm not trying to dodge the question, but I wanted to highlight it's very important to what's before the court right now on the injunctive relief, on the vital necessity points. And I think that's true of Dr. Hobson, both of them.
I agree.
And so, and then if that is still in the case, obviously, that would remain as well on the injunctive relief, if that is not addressed through our current motion for partial summary judgment.
Okay.
As to the remaining claims, I do think it could arguably go to the nuisance claim in the sense that the injury and the assessing the conduct in the context of the significance of the cemetery could be a factor that could be taken under consideration by the jury in assessing that this isn't just some trivial interference with just a cemetery. This is a very significant, important landmark in the city of Atlanta that needed to be preserved, and they were charged with the preservation and the charge of the maintenance of that cemetery and failed to do so. And I think that goes to assessing, is this really a nuisance? Well, it is, because this cemetery is important. The city of Atlanta said it's important, and it's important for these reasons historically. I do think it could go to the nuisance claim, Your Honor.
Okay.
But that's, again, we're going to be much closer to trial at that point. We'll have a pretrial order. The issues will be more narrowly defined. I think now trying to assess this in a vacuum can be difficult.
How about Dr. Hobson?
I think I think it would be very similar, and obviously.
So why both?
And that's a fair point, Your Honor. And again, I think at this point, Your Honor can take both of them into consideration, put whatever weight that the court would like to in connection with the public cemetery issues, which I think both of them are important for that. And I think they're both important for counts 3 and 4. And if we do get to trial, and we don't want to have duplicative testimony, and we would avoid that.
Okay. But you agree there's overlap. They come at it from a different perspective. They're not the same, and they have different things to say. But if in the end, what remains for the trial time finder of fact is the importance and significance of the cemetery, as opposed to, is it a public cemetery, then you might elect not to choose both, to call both.
We may not call both, or certainly not call them on overlapping opinions.
Okay.
And avoid that.
Okay, great. I'm going to have the same questions about Comiskey and, except it's pronounced differently, and Wetlaufer. I need to deal with this guy who's stuck in jail for a little bit longer.
Oh, I'm sorry.
No, you don't have to apologize. You had no way of knowing, but so you're welcome to, you can stay right. It'll take just a second, but I need to see what's going on here. All right, I'm going to be back in a couple minutes. Sorry.
I am gonna, this transcribe, so. Okay. We got one water left. I don't want to take it.
I think you get it. You brought it. You should get the water, I think. Thank you for doing that.
Isn't it beautiful? Oh, you're welcome. Wow.
Is that your bag with the green thing?
Yes,
I have one.
that's why there's the green thing on it.
I tell you what, I had a carry-on bag with a suit and it was black and it looked just like everybody's. And I was in a hurry and I went through TSA and I grabbed it. And I went and got to the hotel, opened it up. It was somebody else's.
Someone else's clothes.
And I told her, that's not my suit.
Anyway.
And then I was like, oh no, what do I do?
Benefit.
I felt sorry for them. I said, there's someone out there. Someone who needs a larger suit.
Right.
I told them
You
left
could wear a
my,
larger one.
left my headphones on a plane. They show that they're in Concourse T, but they're probably gone.
Oh, really?
It's so rude.
I think that's amazing that you can. I think that's like magic, because I'm everybody, Mom, where's your phone? I have one.
I bought this thing from Apple. You're supposed to be able to put it on things and you can find just about.
Oh, the best.
Yeah.
That's what you have on your headset, right?
Yeah, I've got, I had, maybe I'll have to ask you how to use it. On the world.
Can it tell you, like, I'm always leaving, I rarely leave it, at the office, I leave it in the bedroom.
It's on our dogs.
We have a
They,
lot too.
they run away. So they are.
Okay, I have one.
Do you really?
Yes, it's like a keychain. Usually we tie it on their drawstring.
It's a big thing to, when you're traveling, to see it all, steal
He
a
said,
bag.
yes,
drop
take a
it.
lot of to afford.
Check bag.
Then does it like be touch?
You can just figure out where it's at.
Like you look like my phone. It's like fine.
But like in Mike's case, they're grabbing stuff out of the overhead bin and he just grabbed the one, it wouldn't beep at me and tell him it's the wrong one.
No, but you could figure out where
Where
the person is.
the right one
with
is.
that, if they were
Oh.
walking with it.
Yeah, I did that. I took some.
You can talk down to it.
And they probably didn't have good stuff, so you wanted to come back.
I mean, I like these drugs. You know, for like arthritis and diabetes. I was so worried when I got home. This massive like Ziploc bag of like daily medications. I was like, oh my God.
We need to find those issues. Apple Watch, another brand.
But I think the more important. Oh, I would like that. I would like that. I would like that.
Mine said, make a noise. I can't find my phone. Make a noise because you're not gonna do that.
That's what my
My
AirPods
haircut.
Oh, really?
Now they're keep everything.
So he made his phone
Turn
do
them
that
on,
through
they'll be
his watch.
silent.
So if we lose the air tag.
Or maybe it'll just make noise.
Oh. I gotta learn how to do that.
Yeah.
I've gotten bad.
I love it.
I'll put something down in the house and I'm just like, I just had it. Where?
You can't get your phone. For my mom, I had these
Much better.
ear tags.
Sauce, case. I don't know how I.
But you're.
I have that in my wallet.
Yes.
That's the best thing.
Or you did what?
I can put an air tag in my wallet.
I have this in my
Oh,
house.
no. Oh, that was the case, because I looked up on it. Getting.
I don't think it's. I know you said it.
How are you doing? It's a long day.
It is.
Yes, every day.
Yeah.
I don't know how you.
Generally, the work that I do is quite interesting. The brand.
What is this?
These are certified copies of ordinances. I just want to make sure that those are in the record. I know you're not showing. I'm an oral. I just want to make sure that.
Okay, why do I have?
There's two ordinances, the 0952 and
Okay.
2508, or 2502.
Okay, I
Thomas
got
does one set, you know.
Okay. Oh, there's not stapled, these, oh, all right, I got it, I got it.
And actually one is. I just passed the whole file.
Yes, so let's go. Excellent.
Yeah, so it comes down to the email run.
Oh, this is sort of, what did he say? I don't remember. Get my train of thought back on. What was the last, before the interruption?
About what we were gonna talk about?
Yeah, I was trying to.
He was getting ready to move to the arborist and I think.
Right, you had just said her name. What? Because Robbins, it was talking about Robbins. Oh, wow. Oh, you know, if only someone was written it down.
That would definitely be so
I know. That's he says this one's. I might be kind of seeing parts. That's a good one. It's like WTT.
It's an interesting.
I'm not just asking.
It's just your.
They only need two, that's what we figured out.
Six factors.
That's right. I just need two to have a full set. I don't need.
Yeah, I just gave you guys extras. It's the two ordinances. I gave them.
Yeah, it's the same
So you
thing,
all
these are
have-
just certified copies.
Yeah.
And there's just two, okay, I got it, thank you.
Yep. Friday.
Next one.
And
So.
make sure it's not
But if you're at home, so.
No, not
Don't
just-
get it there, yeah.
So I'm going to Harvard Masters.
That was a great.
She's like, wow, school from 8 to 5. And that's Monday, Tuesday, Wednesday.
So what are you gonna do?
I know. I think I sort,
What's you gonna do?
I think I sort of lost my mind.
Or you'll only.
I would just
We manage our in-house. She goes to.
I will.
Always, it's just
Oh.
the inbox.
Oh, I know, it is.
And it's like you have more people further behind us, the years go by. Makes it worse for me, like. It's like, hey, we got this referral. It's like, oh, great. And I'm like, that's for Monday. I've already, you know, and so. Because
I don't think he said that, he's right. He said. He grant, he grant. His name is worse, so it's fixed.
For
so many creations.
Speaking just the court said.
Yeah, during film, we started having cocktails at home.
Oh, good, okay.
Good adventures and ones I would normally get out.
The guy called me.
State law.
2 years after a year.
Good.
Yeah, absolutely.
Or take.
now right before you take a
Yes.
Is there a particular place where from or something?
Sorry about that. I know it's hard to believe there's something more important than this case, but this young man should have been released on Thursday.
Oh, my gosh.
And he's still in. His mom actually came in towards the end of our session just before lunch. And he is the other breadwinner in the household. So he needed to get out and there was a paperwork problem. But anyway, you gave me time to fix it. And here we are. So, Mr. McConnell, you were about to engage with me in the same exchange, but with our restoration experts, what their opinions are. And here I'm not concerned about cumulative because they're the only people who, from everything I've heard, could be talking about here's what it will cost to, or here's a plan for doing maintenance and restoration, et cetera. So I'm just trying to figure out how it's relevant if we're not in a damages space.
That's correct. And then I have also one point. I'm going to address that first, and then I wanted to loop back to one other point that I think of relevance on Dr. Robinson.
Well, let's close out Dr. Robinson, and then we'll move to our.
And one of the points that she testified to during her does relate to the condition of the cemetery today as compared to back in 2006. And she was. And this concerns that she's familiar with the archaeological process of probing and trying, and remember the delineation map that we had showed, and you have to have access in order to get in there and take the probe and to search. Well, for each of those graves depicted on the delineation map, someone was able to do that. And she visited the cemetery in January 2025 and was deposed on this point, said you couldn't do that today.
And when was the delineation map done?
2005.
Oh, okay. So the 20 years passing, we know 2006, now the obligation is on the owner of the land to maintain, and it's not going to become so impassable in 1 year.
Correct.
And so the way things have been maintained over the course of the 20 years has fundamentally altered from her perspective, but this is where she could educate someone about
using the natural state approach to maintenance.
Okay.
And I don't mean that in a pejorative sense, but just the natural state allowed it to get to the point where you could not conduct that test. So that was one point that someone reminded me, and I wanted to offer it to the court. Now, with respect to both of our restoration experts, I believe that you referenced, the first and foremost that they go to is in the weighing of the harms on the injunction. That it was, we wanted to give the court, and I think I mentioned this, I did say it was examples, but they're examples from experts. And in the sense that this is a yardstick, Your Honor, because I mean, in assessing, you have the vital necessity, which is a Hobson-Robinson thing, but then on the weighing of the harms, that's both Robinson and Hobson on the significance on one side of the scale.
Right.
And then on the other, how much does that scale weigh? And that testimony shows that, and it's not just, oh, here, we're trying to get a gig to be a contractor. This was a plan for sustainably maintaining the cemetery by the arborists from Trees Atlanta, that if you put this canopy back in, you're going to knock out the invasive species. You can eradicate the invasive species. This is what it would look like. And you can do all of this, and I think the all-in total is less than $50,000 over a 5-year period. That is, I would respectfully submit, far less harm than what's going to be sustained.
Okay, so it's just putting, from your side's perspective, the right weights in the scale as one is assessing the relative harm to the two sides if injunctive relief is not imposed, or if it is. They're the intangible, unweighable, this is a cultural heirloom, and then it's $1 million or it's $50,000. And their example is it's more like $50,000.
Exactly.
Okay.
And so I think it's directly relevant to that. I'm not so sure. On the damages, we haven't incurred those damages, but I think a jury could try to figure out, well, if it, and I would respectfully submit that it could be argued as trespass when the owner allows, just like it allows goats to run free, or not goats, that was a bad choice, dogs to run free, or
Cows.
cattle, or things like that to run through the cemetery I think it's no different through an act of omission. An act of omission can be as cruel as an act of commission. And here, by simply turning your head and creating a situation where you cannot even walk through the cemetery is a form of trespass. And if that is the case, there's going to be damages. And I do think the damages can be quantified by this is what you have to do to get it back. So I do think it would come into play there as well.
Okay, got it.
So that's really all I had on to discuss the relevance of the witnesses.
Okay, very helpful context. Ms. Shawkat?
Judge, to touch on the recency and primacy, the recency of what was just said about Dr. Robinson with the testing, the probing with the stick.
Right, that your colleague jumped out of her seat on that one.
Yes, she did, because the testing done in 2005, her visit was in 2025. There's this tremendous gap of when it was not within the HOA's control. And the testimony of all the experts is, I don't know when those trees came down.
Oh, I understand. I am not attributing to the HOA 2006 to 2014, 2015, whenever it came into existence, but that's a shorter window than from existence to now, about the same. But it's just a helpful data point because all I have is this 1990 photo where it's grass and you can see headstones. And then that guy with his underwear sticking out with this kudzu everywhere. And he looks like he had to work about 4 hours to uncover this sad abandoned's the wrong word, but neglected headstone. And clearly that's two different, I mean, we're like in the Amazon and we were in like, hey, it's a nice little cemetery. It's hilly, but it's a cemetery.
It is.
So something changed in that window.
Brockington's pictures are 2006.
Okay.
So we do have that glimpse there as well.
Little snapshot.
Correct. And as you said earlier, no one knew to be taking pictures
Right.
during.
And no one is saying that they're all pictures of the same thing. I'm not gonna, I mean,
Right.
the shot that had the church up on the hill was a beautiful vista, but that's not the same vista as the gentleman who had recently cleared the headstone and looked like he was being sucked into this kudzu mound.
And that will look different in 6 months because it's growing season.
Hmm.
And in the
And there's
winter,
probably a new tree that fell.
as we have seen the cleanups in the winter, it looks much better. Everything is dormant. And so I
Right, but
don't think.
cemeteries need to be year round and not just you can visit your loved ones in January.
Correct. Well, and I don't think that the experts help us understand maybe how people visit their loved ones. And
When you
that
say the
was-
experts, meaning our restorative experts or our
well, certainly not
Well,
them, and that wouldn't be within
I
their
agree.
scope anyway. But with Hobson and Robinson, looking at,
It would seem like their source material would allow them to offer an opinion on how descendants visit their ancestors because they know what they know having talked to descendants.
correct, and those descendants could also come and tell us
Oh,
these
yeah.
things too.
Yeah.
And I don't recall, and I'm sure Mr. McConnell will correct me, I don't recall any expert opinion on how those worship services and how the burials took place. And that actually brings me around very well to the opinions.
But how's that relevant anyway? I mean, if
That's
Mr.
exactly-
McConnell was going to spend 40 minutes with a witness on how did the burial work? I would hope that after minute one, you'd object and say, that's not relevant to.
So some of the opinions that were given are about burial practices. For example, one I found fascinating was they used to be at night. And I thought that was really fascinating, but that wouldn't be relevant or helpful to, how the burial practice took place is not relevant to how people mourn today. And so that historical opinion isn't necessary.
Well, probably so, unless what the testimony is that some people choose to mourn and pay respects at a time consistent with the burial, which is why we need after dark access to the cemetery. My great-great-grandfather was buried at midnight because that's how we did it. And the most meaningful time for me to connect with him is on the anniversary of his burial, which would be August 14th at midnight. And so I actually do need to be there at midnight, which is why I need light poles in the cemetery. I'm totally extrapolating here.
Correct.
But all of a sudden that is relevant for Dr. Hobson to say, let me tell you, actually, people were buried at night. It was safer. They weren't going to get run off the land, or who knows.
That would be, but they don't offer that.
Okay.
That's not something that they brought up in his deposition. Ms. Whitlock said, after the body's in the ground, sort of, do you have any opinions after that? And he said, no, I'm historic. We're looking back. Another thing that the plaintiffs have said, these Robinson's opinions are helpful for the public versus private. And I was just truly highlights the words, the phrases, the dedication, landowner's permission, the exclusive use, all of those things that help us with that analysis or that govern that analysis. Robinson's opinions don't touch on that, that there are 324 graves there. That doesn't help us determine if this is public or private, because a public cemetery could have 4 graves in it, so it's her opinion that there's 324 graves there. Well, that's a fact. And it also, her saying it doesn't guide or assist with the analysis of that. And so sort of in this room today, that expert opinion of how many, breaking down her opinions, that doesn't help us determine public versus private.
Well, there's one. Letter I may be in that space, and we don't need to get too much into the depth of it, but opinion I is that members of the African-American communities in Atlanta, so not just the church membership, understood that this cemetery was available for the burial of their loved ones. And then she cites why, and it's some of them are the fact witnesses that your colleague discussed. And so maybe we're getting to be a little cumulative here. If her expert opinion is based on the testimony that we'll be having from witnesses who testify, I think the jurors could perform that synthesis. But there's a little more. It looks like there's some literature she relies on as well, although it looks like it's mostly the depositions of the fact witnesses who are also identified. So we'll see. But as I forecast or previewed with Mr. McConnell, if the question of is this a public cemetery, not something that the ultimate fact finder is wrestling with, I was heartened to hear Mr. McConnell say there's a whole lot we don't need to go into with either Hobson or Robinson. They have things to say about the vital interest and whatnot on the injunctive relief side, but much of what they might be educating a jury about using their expertise that would go to public cemetery, the jury wouldn't need to hear about.
I agree.
Okay, look at that. Anything else?
Probably shouldn't bring up the 2 times that I disagreed with you earlier today.
No, I'm ready for it.
Well, one is the vital necessity, where you said this could be a place where the experts could come in. And I had written down that this headstone will disintegrate, time is of the essence, when the canopy is opened, the sun helps plants grow. And I was just writing these things that, yes, all of those things are true, and those aren't expert opinions or outside of a lay person's understanding that things break down over time. Trees, you had a great, trees will fall or something that you said, and I wrote, yeah, that's not a necessary expert opinion. It gives it that extra special shine that makes it mean more than it needs to, and we don't need their help with whether it's vital or not, and those things that was one that you said this is where it would come in. I wrote one more, but I do think we had already talked about it, so. I think that's all I've got unless you need more from us.
Feel like I've had enough.
Oh, you're welcome.
You were satiated.
You asked. Thank you. You may not want to run away though, because I think we've got the 4 exhibits that remain where there, unless during the break except you didn't have a break, so it's still the 4?
Yes.
Okay, so what are the 4? Well, you have a mess at your feet.
I know, I have a lot. 2 newspaper articles and 2 Buckhead Heritage newsletters. And our objections in our motion are that the contents of those are hearsay and do not fall within an exception to that. We discussed some exceptions. I disagree. So I think I disagree with the plaintiff's point on that. I think we were able to work out other ones, but
Those
that's
4,
very briefly.
are they available in the electronic world?
Yes, Your Honor. I believe it is Appendix 21, 24, 25, and 42 to Plaintiff's Appendix.
I'm sorry, will you give me the numbers?
21, 24, 25, and 42.
I don't know where to look when you say appendix. I have a directory that's your motion for partial summary judgment. There is something called flash drives, flash drive exhibit 122, and then this infamous manual filing.
This would have all been submitted in connection with our motion for partial summary judgment.
Okay, let me open
It
that.
says notice of filing numbers 1 through 18, I think is the first group.
Yes, Your Honor. I think this would have been within the second notice of filing.
So in the folder that says is for plaintiffs MFPSJ, I've got a brief, a motion, a theory of recovery, a zillion exhibits.
Yes, Your Honor. So it's exhibits 21.
Oh, so it's exhibits.
Yes.
Okay. Because you were saying something about an appendix and I was.
An
Okay.
appendix of exhibits.
Got it.
And then, Your Honor, we also have one minor housekeeping item. I have certified copies of the 2 ordinances that are at issue in the case. I've handed a copy of them to opposing counsel. I would just like to introduce them so they're part of the record.
Okay. Any objection to the certified copies of the ordinances being made part of the record?
No, sir.
They're admitted. What are they called?
So the first one is ordinance.
Oh, I mean, are you calling this plaintiffs 1 or plaintiffs 900?
We'll do plaintiffs 1 and 2
Okay, for today's hearing.
for today's hearing.
Okay, great.
So.
Do you have copies that will go to the court reporter so she can make them part of the official record? Great.
Plaintiffs 1060952.
Oh, you don't have exhibit stickers?
I do not.
I have seen those.
Okay, great. I don't need them, but for the official ones, they should get.
And then this is.
2.
And uncertified copies of the norm in the appendix. This is just a certified copy.
All right, we don't need to be on the record for the questions I'm going to ask now. So it was, I need you to say those numbers again then. 21.
So exhibit 06, I'm sorry, ordinance.
No, I'm sorry. In what you called your appendix.
Oh, I'm sorry.
With the exhibit numbers, there are 4 exhibits that are contested.
21, 24, 25, and 42. And Your Honor may also want to have exhibit 62 handy as well.
And why is that?
That's relevant to exhibit 25.
So 21, if I'm looking at the right thing, I just want to make sure I'm looking at the right thing. And again, we don't need to be on the record for this. It is like a brochure from the church. It's not an article. It's Pastor M.A. Shin, a church where you feel right at home, celebrating our dedication.
Yes.
That is? Okay, because I was told it's 2 articles from the Buckhead Register Heritage.
Was 2 AJC articles or was it just 1 AJC article?
So I understand that it's 21 and 24 is the other newsletter from Buckhead Heritage. And then if I understand your objection, it was 25, which is a AJC article, and 42, which is an AJC article.
I think the question is 21.
21 is not an article. It's something from the message from our First Lady, a proclamation about the Higher Piney Grove Baptist Church from the governor.
Yes.
It's not my objection, Your Honor.
I don't know why I'm looking at you. 21 is not an article. It's this collection of documents, including something that says history of leadership of the Higher Piney Grove Baptist Church. It lists a bunch of reverends.
Correct, and our objection to that one as well, I've forgotten, that's not an article, so it would be 5 things. 2 articles, 2 Buckhead Heritage newsletters, and then this is a special publication by the church that they put out, and it's lengthy. There's a lot of information in there, and a lot of that is hearsay, and that was our objection, was that it's hearsay throughout.
Yeah, so talk to me about Exhibit 20. Hopefully the others are simpler. You guys said this was going to be quick, but we can go on the record again. Exhibit 21, I lost track of how many pages it is, and it's just this random collection of things. There's a death notice, and I'm not sure what it is. There's a hymn, and a message from the First Lady. She's writing a letter, not meaning Melania Trump, but I don't know what it is, and a bunch of it looks like hearsay.
Well, I think first thing, Your Honor, the documents from 1997, which would make it a ancient document under OCGA 24-8, 803, I believe that's 15, it's the ancient documents rule.
How do we know that's when it's from?
So if you look at the first page of the document, it's dated Sunday, July 20th, 1997. If you look on the 2 pages later, the proclamation from the governor has its seal, and it has the dated 25th day of June, 1997. One of the other items that I would submit is...
What is this?
It's a proclamation. So the overall document?
Yes. What is document 21?
I could just.
Anyone?
I'm not trying, I actually do have some personal familiarity. It's my understanding this was provided to us. And it was a brochure that was issued by the church celebrating its dedication in almost 100 years. And the relevance of this is the acknowledgement at that time of what the church was that had been around for 100 years. And given the history is going to be relevant to the case, we wanted to have in something that confirmed that. What is the evidentiary basis for that? And yes, I thought the proclamation by the governor probably would be a good piece of evidence with respect to commemorating that and saying it's significant. So that's what this is. And it's the entire thing may not be relevant, but portions of it.
But it is actually, in 1997, it was one contiguous document. It's not that someone said, hey, I've collected all these things from the church. Here's my collection of things from the church.
Correct.
If I had been there on Sunday, July 20th, I might have received a copy of this.
My understanding, you would have received that.
Got it. So it's almost like the church program for that day, but it was a particularly joyous day. They had moved to Decatur. and they're dedicating the new house of worship.
Yes, sir.
Okay.
That is my understanding.
Okay. All right. So now I can start taking some notes here. You're saying ancient documents,
Yes, Your Honor.
which was 803.
It's 803-16.
All right. I gotta say, this is I've heard of that as an exception. Never had to deploy it before. This case is great. Okay.
There's one other point that I would make. I think it's particularly relevant to this, but what's also raised in our brief. Our brief points out that a motion to exclude has to be specific. You have to be, particularly with hearsay, you're trying to exclude in reference to a statement.
Right.
And so we made, in our response brief, we noted that their motions to exclude
We're generic.
it's a blunderbuss. And the Supreme Court has said these motions to exclude, particularly at the pretrial stage, a motion of limine has to be narrowly tailored to the facts and evidence at issue. We don't believe that's the case. And so we're happy to go through these specific items. I'm happy that we were able to narrow the scope. But we just want to have that on the record as our objections to the motion in its entirety.
Okay. I appreciate you flagging that. Are the remainder of the documents not a church program? They're actually articles? I guess I should be asking the defense. They're the ones challenging them.
Yes.
Okay. So it was a big old church program. It even has ads in it. It's great. 24. I'm impressed someone still has it. Okay, so then we get to the Buckhead Heritage Society. Just generically, Mr. Todd, why would a newsletter not be hearsay? Or is this also ancient? It's not as ancient? What's the age limit for ancientness?
20 years, Your Honor.
All right, this is not 20 years
This is
old.
not ancient.
It's old, it's not ancient.
It's 2012.
Yep.
And this document, Your Honor, first, we're still unsure what the specific statements that are being challenged as being.
Well, why would any statement in it not be hearsay?
So and to that point, we have offered this as an example of a public organization talking about the history of the cemetery. So this is a document that I don't believe we're offering for the truth of the matter. But it also goes to, if it is considered for the truth of the matter, has statements about the general history of the cemetery and the general history of the property and the reputation of the property. And that is another exception to the hearsay rule, 803-20. And so that would be another basis for the fact finder or for you to consider this document for the truth.
Okay. And I'm assuming that's the same for the other issue of the newsletter? The same basis? Your defense of it as not hearsay would be either we're not offering it for the truth of the matter asserted, or it provides information about the history or the reputation of the church.
The other newsletter, I believe counsel said that they were withdrawing their objection because that was just identifying a cleanup that was supposed to take place.
That's correct. Thank you. That's the numbers that we had a problem with. It was only one newsletter. We withdrew the objection because it was the one newsletter simply reported a cleanup was taking place and all these facts were and evidence from other sources. The newsletter that the objection, sorry, on my computer. It's gonna be 24.
Yep, that's what we just looked
That's
at.
what we're considering.
Correct, yes. So that's the one. Yes, reminders of a African-American past. That portion of it contains lots of hearsay that I don't think falls into those exceptions. But Judge, I will tell you, didn't find much authority out there on this ancient document.
I'll look it up.
Subsection 16, there's not anything helpful out there on that, that I could find.
Rule, I mean, for the rule says statements in a document in existence 20 years or more, the authenticity of which is established. And
I'll take a look at it. 25 and 42 are both AJC articles, and neither is ancient. So what is the non-hearsay aspect? I appreciate that the defendant hasn't said, we don't like what Ernie Suggs says in paragraph 5, but this is Ernie Suggs telling it like it is at the cemetery. How is that not hearsay? Or when he's quoting someone, he's quoting, I'm assuming, I went way in here. Smith, we never go in there. My policy has been everybody stays the heck out of there. There's a statement from Smith, as written by Suggs, and neither of them is here. So what's the exception for the two articles?
so for, I believe, so you're handling both at the same time, Your Honor?
Well, just generically, how do you get a newspaper article in at trial?
So
If someone says, wait, that's hearsay, that's an out-of-court statement written by Ernie Suggs did one, and I didn't see the byline of the other one. Maybe it was Mr. Suggs again.
the other one is David Pendred, Your Honor.
I get that.
That was in 2006. I think there's a couple of bases for these documents. One, again, these are all documents that contain statements about the general reputation and history of the cemetery and the property.
So the 80320.
20, yes, Your Honor. They also contain statements. So for example, when Mike Smith was quoted in that statement, those are statements. Mike Smith at the time was a officer of the HOA, so it would be a statement by a party opponent. There's another statement that was quoted in the 2006 article that is tab 24. I'm sorry, that is tab 25, exhibit 25. That document, statements by Mr. Cooper. Mr. Cooper has submitted, and this is why I said that exhibit 62 would be potentially relevant, Your Honor. He submitted an affidavit saying that he was accurately quoted. He believed that the statements were true. In that article, he identified the article. And so we expect that at trial, he would testify that he believes that he was accurately reported in that article.
Okay. Well, I guess I'll need to look at these. You've got the head of the Buckhead Coalition saying the new owners are being cooperative, but they may have built on the cemetery. They violated the law. That's not a party opponent.
The last one that I would say, and for some of those statements regarding the as it exists, I think those are statements of a then existing mental condition that are describing the cemetery as it exists at the time. So they're describing, or then existing condition. Some of them are describing their plan, their motive, their intent. For example, Mr. Cooper was describing in 2006 what they planned to do, what their intention was to do with respect to the cemetery. Again, Mr. Cooper, his firm was involved with obtaining the zoning ordinance that's at issue in this case. And so we think for obvious reasons, his plan, what he understood that the intent of them seeking this ordinance is relevant to what ultimately made its way into the ordinance. It helps the court and the fact finder understand the meaning of the term maintain.
Except the court and the fact finder can't cross-examine him about that. Well, what did you really mean? When you said this, what did you mean by that?
We can bring him to trial, Your Honor.
And there you go. You don't need the article.
And that's one of the other items for one of the reasons why a pretrial motion in limine at this stage is improper, because in order to be excluded at this point, there has to be no way for this evidence to be admitted at trial. And so that's another independent reason. And the site for that, Your Honor, is Williams v. Harvey, 311 Georgia 439. It's a 2021 case in the Georgia Supreme Court.
All right. Ms. Shawkat, anything else about the 4 exhibits?
These were focused on the use of those in the motion setting.
Okay, not at trial.
Correct, that would be, we're trying to comply with scheduling orders
Mhm.
and understanding that for use at trial, those would be motions.
Okay. Well, that's a helpful adjustment for me. So your point is, Judge, you ought not to base a ruling on the partial motion for summary judgment on what Ernie Suggs wrote in a newspaper, because that's hearsay. And his quoting of other people would be double hearsay. Got it. Okay. Unless it's an ancient document, or I don't know about the some of the other exceptions that were cited, but I'll look at them. But thank you for focusing that. It's not, also might not be usable at trial, but you're not seeking a ruling to exclude it from trial. You're saying it ought not to be something you weigh in assessing, for example, is it a public cemetery, or is injunctive relief appropriate at this time?
Correct, we would raise that as a motion.
Okay.
Your Honor, if there's one point that I can add to that.
There's one you can add.
So these two articles, for example, Article 42, the Suggs article, that is the article that was referenced in the board minutes that were shown to you earlier today. And if you look at it, that's in our appendix. So that article is relevant, and it is, that's.
I don't doubt it's relevant. That there's no challenge to relevance here, as I understand it. The challenge is hearsay. So relevance, you got to be relevant before I even worry about hearsay. It is relevant.
Yeah, so they possess, it shows, it's also relevant for a non-hearsay purpose because they had notice of it and whether or not they acted on it, but they had knowledge of it. So these are documents that are admissible for both the truth, but also can be considered for non-hearsay purposes as well.
You can just say it out loud.
I apologize.
That's all right.
I'm sorry. I apologize, and I apologize to Mr. Todd. No, it's also, though, the Mike Smith statement is the mission. So that.
Well, Mr. Todd made that point. I think anything that's coming from I want to be clear, Ms. Shaka, I'm not attributing what Mr. Smith says to the Homeowners Association. There is a distinction, but given his role in the process and who he was and the Homeowners Association, I think that has some traction, but that might be 3 lines in a 400-line article. And so it may be there are pieces of it that I ought to consider, but some of the other parts I think might be excludable at this juncture, which is really all we're talking about. This is sort of a motion in limine for the motion for summary judgment.
Yes, I think Mr. Smith testified, though, that at the time he made those statements, he was an officer at the HOA. And I think the statements, likewise, the statements by Mr. Cooper, the HOA has adopted those, at least to some extent, as true. And so under 801C, they would be potentially attributable to the HOA.
Who is Mr. Cooper?
Somebody completely unrelated to the HOA, who was one of the developers that has nothing to do with this HOA, didn't start this HOA, was never an agent for this HOA, and should not be considered by the board.
I'm just trying to find Cooper's name or is he in the other article?
He's in the earlier article. He's in the behind tab 25, Your Honor. And if you, I'm going to direct your attention to the second column.
All right, hold on. Let me get to 25. Okay.
Mr. Cooper was Capital Partners, one of the early people.
Brad Cooper, CFO of Capital Partners.
Yeah.
Right.
Okay. He's saying some things about the cemetery. Okay. And there is, Mr. Todd claimed that the HOA adopted his statements. I don't mean to put words in your mouth, but it was something to that effect. But that's different from Mr. Smith, who was the HOA effectively.
Yeah, I think, Your Honor, the argument would be the manifestation of an adoption of that statement subsequently by Mr. Smith when he acknowledged when he was quoted, which he said he did say in the article, the subsequent article, to clean up that essentially he had the same understanding and adopted what Capital Partners, who, by the way, was the entity that had applied for what became the amended ordinance, for what ultimately was relied upon by Mr. Smith. And so it's the similarity and the adoption, at least as an understanding of by the HOA, which is consistent with what Mr. Cooper is saying. And what Mr. Cooper is saying, we know we can never build on that property, and it's in our best interest and the community's best interest to do something. We'll provide ingress and egress, but historic markers and
I can see his words.
yeah, and so, and then the subsequent, he then provided the affidavit that was referenced that said, yes, that I was quoted. So for purposes of summary judgment, I do think it's appropriate for the court to consider his statements in that article based upon his affidavit.
Got it. Okay. I think we covered the motions we were going to cover today, but let me take attendance. Mr. McConnell, were there other things you were hoping that we would work through today?
No, Your Honor.
Okay. Ms. Whitlock?
No, sir, I think you got it.
All right. Next steps. You've given me lots to work through. Thanks. And I will feel very comfortable having Ms. Niles reach out to both sides, but it may be defense. I'm interested, do you have any case citations that address X? But if I have a question for one side, both sides will get that question, and there's no prohibition on saying, well, we got some cases on that too. But if I'm reaching out to just one side, it would be a sign of, I don't see going your direction unless you've got some case citations. I also might have Ms. Niles send an email out saying, this is the way this one's going to be resolved, but we are going to invite the side that's winning this particular issue to submit a proposed order on that. I don't know that that will happen in this case because I think without having worked through all these things that it's going to actually be a split decision, and that's more complicated to say, why don't you write a little bit and you write a little bit, just 'cause different writing styles, et cetera. That just means it's going to take a little longer, but I will think through this and let folks know if it's helpful to get proposed orders from either side. You should feel free to reach out if time has passed and you want to know when is there going to be progress on the case. How are we doing right now with managing the temporary order? I'll start with plaintiff. Are your clients comfortable enough with the status quo, or is there also a step that needs to be taken clarifying what the temporary order means and doesn't mean?
Now, I think generally the order has worked well. We're going to have another cleanup tomorrow. The notice, I believe, has been received, and so folks are doing that. There could be opportunities for additional work. Some of the new board members, which it has been expanded.
Board members for your client or HOA board members?
For our client. So the Friends of Piney Grove have additional board members, and some of them are quite active in cleanup activities and also are quite industrious, and they may want to see if they can't use perhaps some additional power tools, things of that nature that they have not been using up to this point, because you get to a point that you can only do so much by hand removal of certain things. But you know, perhaps getting something like a wood chipper or something like that, because there are certain small tree limbs that are falling on the ground, and we're still trying to, as you can see, still trying to climb through it. And if we could use some mechanical assistance, that would make the labor side of it go down. But that was the only thing that I have been essentially, I think, communicated to me, that if we could look into that, that would be something we would be interested in.
Okay, well, if it reaches that point and I somehow need to be involved, certainly reach out about that. What is the process by which the vegetation that's been removed is actually removed from the property? And is that working smoothly? I'm thinking in my neighborhood, there are these brown bags that say Lowe's or Home Depot, and this is such a large space that it would be lots of bags, and you don't want to leave them where you're not supposed to leave them on the HOA property. And how does that work?
So what we've been doing, it's not easy because I've actually carried a lot of these bags, so I can attest to that. They're getting green bags, and then we bring them up to the front of the easement area, that alley, and try to put them as neatly as we can. And then usually the Monday or Tuesday afterwards, we have a service for a fee that comes out and picks them up.
So you're not waiting for that totally unpredictable and infrequent city of Atlanta, here's when we pick up yard waste.
So
Okay,
we've been
this gets
trying-
them out of there sooner,
Yes.
but you're paying for it.
Well, we're paying for it, and we're incurring expenses as we go along, and there's other things that we're incurring expenses for as we go out there. But, but in terms of the order itself, I think in general, in terms of what we can do, it's working.
Ms. Whitlock?
So I have mostly agreement with that. But I think the order already provides that if they want to do something more than what they have been doing, that we are to meet and confer about that. So I don't think that that requires anything from the court at this point in time.
Okay.
We can work through that. So long as, and there have been a couple of blips when we think that there was that the order was not complied with. And so I think so long as everybody understands that both sides are expecting full compliance, that we can move forward as we have been moving forward. And I would, on your last question about the removal and notice, I will say that they have been very, what's the word I want?
Good?
Good. Yes, they've been very good about providing us clear notice about when they're coming and what they will do with the trash. And they have done that.
Okay, that's good to hear. And in the same way that I am not encouraging, but inviting Mr. McConnell to bring to my attention if there's a need. Same on your side. If there is what your client perceives to be non-compliance, just once, but on a couple of occasions, and that means we need to convene, we should do that. But the fact that I haven't heard from you all on this part of the issue said to me that probably it's working well, but we're all together, so I figured I should ask. Well, thank you all. Thank you in particular, Ms. Richardson. You're gonna need to rest your head for the rest of the day. We got some work to do, and we'll move forward. Thank you.
Thank you.
Good we go.
To the extent it helps the court, we are going to order a copy of the transcript and we'll file it from today if that's helpful to you.
All right, so we'll go off the record, so you don't have to put that thing back on. But yeah, you should settle. You're splitting, I know, but just make sure Ms. Richardson has a way to send a big bill to both of you.